Good morning, everyone. I now declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for Supplementary Budget Estimates. The Senate has referred to the committee the particulars of proposed expenditure for the 2024-25 for the portfolios of Home Affairs and the Attorney General and other related documents. These are supplementary budget estimates proceedings, and the outcomes to be heard during today's estimates are from the Home Affairs and Attorney General's portfolios. The committee has set Thursday the 19th of December as the date by which answers to questions on notice to be returned. The committee has also decided that written questions on notice should be provided to the Secretariat by 5 p.m. Thursday the 14th of November. Understanding Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of the evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any question going to the operations or financial positions of the departments and agencies which are seeking funds in estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where a person has discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of the Department of the Commonwealth shall not be asked to give opinions on matters of policy, shall be given reasonable opportunity to refer questions asked to the officer, to a superior officer, or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of the 13th of May 2009, specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from the disclosure of the information or the document. I remind all senators that as we continue our work implementing the Set the Standard report as chair, I will ensure that proceedings are conducted in an orderly, respectful and courteous way. Officers called upon for the first time to answer a question should state their full name and the position for the Hansard record, and witnesses should speak clearly into the microphones. Mobile phones should now be switched off or turned to silent mode. I now welcome Senator, the Honourable Jenny McAllister, the Minister for Emergency Management, and officers from the National Emergency Management Agency. Minister, would you like to make an opening statement?
Yes, please, Chair.
Thank you.
I do appreciate the committee providing me with the opportunity to say a few words. It fills me with great pride to have been appointed as the Minister for Emergency Management. That occurred in July this year. And I would like to place on record my deep thanks to the NEMA staff who have worked tirelessly to brief me and prepare me as we head into the next high-risk weather season. Can I also acknowledge my predecessor, Senator Watt, for the role that he played in emergency management, both in opposition and for the first 2 years of the Albanese government. And he has certainly made his mark on this portfolio through his work in establishing NEMA, the improved budget situation for NEMA, through his leadership in the Hazards Insurance Partnership, and of course the establishment of the Disaster Ready Fund. I have been extremely conscious of the short time frame I have to get my feet under the desk ahead of the high-risk weather season. I've spent the past few months travelling to many disaster-impacted communities to listen to a range of voices and understand what is working and what is not as they recover. What's evident to me is that we are going to need to continue to build and adapt our processes to ensure that we meet communities where they are during times of crisis. Although disaster management is primarily a state and territory responsibility, the Commonwealth has had to mature and step up from where it was 5 years ago. Australians expect us to show a united front and back each other in disasters and crises. Our approach to preparedness has also changed to keep up with the increasing frequency and severity of disasters. While the ADF will always be available, it cannot be the first port of call. That is why we are building alternate national capabilities. We're delivering this through our investment in the National Emergency Management Stockpile and by supporting Disaster Relief Australia. But also we are building and expanding our aerial capability to now include 3 heavy lift helicopters and a large air tanker, which can be reconfigured to support a broader range of emergencies than just active firefighting. The Commonwealth has also released an updated Australian Government Crisis Management Framework, which reflects the pivotal role states and territories play as the first responders in crises, while supporting consistency in how the Australian Government, including NEMA, can back these efforts. Across the disaster continuum, we are continuing to support states and territories. In preparedness, NEMA ran a second successful National Preparedness Summit, and they continue to roll out their 24-25 high-risk weather season preparedness program. As I've already mentioned, in response, we are also seeking record investment in our national aerial firefighting fleet and across other programs such as the National Stockpile. In recovery, we continue to support communities impacted from as far back as the 2019 monsoonal trough, through Black Summer, through the Northern Rivers floods and late 2022 floods, including in the Central West, through flooding in ex-tropical cyclone Ellie, and then of course through last year's tropical cyclone Jasper and this year's Victorian fires. All of this work is underpinned by what we are doing to improve built and social resilience. A decade ago, it was suggested that around $1 in 13 was spent on resilience. Currently, $26 billion have been committed for resilience programs over the 3 years to June 24. This is being delivered through our flagship Disaster Ready Fund and through the many DRFA Category D measures, for example, reconstructing the Fitzroy Bridge to a more resilient standard, and measures such as the New South Wales and Queensland Resilient Homes programs. I wish to note also that the complex crises that NEMA manages and engages with pushes beyond what we would classify as natural hazards. The CrowdStrike outage in May was a stark reminder of the vital role that NEMA plays in human-induced events, and they are now playing a supporting role with the Department of Agriculture, Food and Fisheries as they grapple with the threat of avian influenza and partnering with DFAT to support Australians returning from Lebanon. All of this is to say that while we plan for this year's high-risk weather season, the personnel in the National Situation Room and across NEMA remain extremely busy. In closing, I would like to acknowledge Senator Davey and the many members from across the Parliament who have approached my appointment with a sense of collegiality. Disaster-impacted communities want to see elected officials working together to support them, and I look forward to continuing to work across the Parliament to ensure we are reaching the best outcomes possible for these communities. I will now hand over to NEMA's Deputy Coordinator-General to make some opening remarks.
Thank you, Minister. Thank you, Chair. Thank you, committee members. Mr Moon, unfortunately, is unwell today and sends his apologies. I will be stepping in on his behalf today, but thank you, Chair and committee, for allowing me to make a statement today. The shifting climate and other natural hazards continue to challenge emergency management and risk reduction globally. As an agency, we continue to work with our stakeholders to evolve our capabilities and prepare for all hazards. Whilst the short-term forecast for this season indicates no single dominant climate driver, the agency has been busy preparing emergency management agencies, the private sector, charities, telecommunications authorities, energy providers for all scenarios through our higher risk weather season preparedness program. At the same time, as we prepare for the up-and-coming high-risk weather season, NEMA has also been coordinating Commonwealth responses to several non-natural hazards. Events like CrowdStrike, the domestic repatriation of Australians from conflict zones are a reminder of how hazards can intersect and compound in our operating environment. NEMA is equally building critical national emergency management capabilities. The revised Australian Government Crisis Management Framework that came into effect on the 16th of September 2024 now requires NEMA to take an active role in the whole of government coordination and support other government agencies in all extreme to catastrophic crises. We continue to mature our capability to meet this requirement. Last month, several new multi-use aircraft were added to Australia's national aerial firefighting fleet. Further, NEMA's National Emergency Stockpile continues to be expanded, meaning that critical goods and services such as emergency shelter are available when and where they are needed. We are also uplifting workforce capabilities by facilitating scenario-based exercises, conducting lessons learned forums, delivering crisis appreciation and strategic planning training, and by funding critical volunteer capabilities, as an example, Disaster Relief's Australia New Operations Centre. Preparation is, of course, paramount, but we also need to make sure that when disasters inevitably occur, the recovery process for communities and stakeholders is timely, targeted, accessible, accountable and equitable. To support this, we launched a new recovery support package to streamline the funding and support processes for local communities and governments. Holistic risk reduction and national resilience requires a connected, systemic approach. Cross-sectorial partnerships are needed, and while I will not go into all these now, an example is the Hazards Insurance Partnership, which is focused on better understanding of risk and the intersection of risk mitigation through insurances and public sector investments. NEMA is directly coordinating investment in risk reduction initiatives across the country through programs including Disaster Ready Fund. Approximately $2.6 billion has been committed for a range of different resilience programs between the 1st of July 2021 and the 30th of June 2024. And this targeted investment in risk reduction remains a key priority for NEMA. Our systems need to evolve to face the challenges of increasingly complex and frequent disasters. We will draw on the reviews into insurance, funding, governance, and work with our partners to drive systemic change. Thank you for your time. We now welcome your questions.
Thank you very much for those opening statements. Senator Davey, you have the call.
Thank you very much. Thank you all for attending today, and I welcome the Minister in her first time as Minister. And I acknowledge your extensive preparedness for this upcoming high-risk season, and thank you for the invitation to attend the opening of the Preparedness Summit that you held recently. I was wondering if you could give us an update on the Northern Rivers Resilient Homes package that the Minister also made mention of in her opening statements. I understand that the lead agency for delivery is the New South Wales Reconstruction Authority, so appreciate that, but given there is a lot of federal funding going towards it, the last available information I had from the Northern Rivers was there was about 3,500 homes determined uninhabitable, but at that point in time only about 720 offers had been made with just over 500 accepted. Have we got updated figures?
Thanks very much, Senator. Obviously, the situation in the Northern Rivers was unprecedented. It's also a community I happen to know well, and I've visited there on many occasions. It's a very long road back to recovery for that community. We are partnering, as you've indicated, with the New South Wales Government on a range of recovery measures, including the Resilient Homes project, and I might ask Dr Charker to give you an update on some of the specific figures that we have about the rollout of that project.
Thanks, Minister, and thanks, Senator, for the question. So on the Resilient Homes Fund in the Northern Rivers area in New South Wales, so as you'll be aware, that was announced back in October 22. Guidelines for it were released or published on the 30th of January 23. It's a $700 million commitment cost shared by Australian and New South Wales governments, and as you've noted, it's administered by New South Wales Reconstruction Authority. It has, by way of recap, three elements. One is the retrofit program, which is the funding for retrofit or repair of livable areas to improve resilience for future floods. Second is the home raising program for elevation of livable areas above a specific flood level specific to a particular property. And the third is the piece you've touched on, which is home buybacks, where the homeowner obviously receives payment for the purchase of their house and land. The latest data I have is current as at the 11th of October, so it's only a few weeks old. The data I have indicate that New South Wales RA has prioritised 1,003 homes for buybacks. 825 offers for buybacks have been approved. Another 94 are in progress. 699 offers in total have been accepted. 548 contracts have been settled with purchases complete. So that's on buybacks. On raising and retrofits, 370 homes have been prioritised for raising and retrofit, and 12 raising and retrofit payments have been completed. I also note that the New South Wales Government is solely funding, i.e. just the state government funding, a further $100 million land acquisition program to open up new flood-safe locations for future development. The other aspect, of course, around supporting recovery in the Northern Rivers goes to road reconstruction. Senator, that's obviously a different issue from that which you've raised, but I note there's been significant progress in New South Wales on progressing estimates of cost for that, and I can update, of course, if required.
Mm-hmm. Just on the home purchase program, there have recently been reports of some of the homes that have been brought back and offers accepted and they've been vacated are now being occupied by squatters. Are there concerns by NEMA that's putting people in danger? Is there a requirement under the program for the New South Wales Government to speed up demolition of those homes so to prevent this issue of squatters and new dangers arising?
I would need to take that on notice, Senator, and we're very happy to talk to New South Wales RA on that issue specifically. So we work incredibly closely with RA on this and other programs, and particularly focus on Northern Rivers. So I will take that on notice and follow that up, Senator, to address your question.
Okay, and also while I'm on home buybacks, I note that after the 2022 floods in central west New South Wales and Eugowra, former Minister Watt acknowledged the serious issue and said that they would stand with the people of Eugowra, indicating, and the council was under the impression that they would get similar standing to Lismore. It wasn't until August 2023, following questioning by Nationals leader David Littleproud of the Prime Minister, when the Central West would receive a resilient homes package. And then finally in November 2023, Minister Watt announced $40 million for that package. That was November 2023. It was almost a year to August 2024 when Minister McAllister announced consultation would commence on that program, which is now closed, and last month we saw a re-announcement of the $40 million saying that the program was opened. What was the delay? Why did it take so long, given that this is not it's not a blank page? We've got the precedents of Queensland Resilient Homes, Northern Rivers Resilient Homes. So why did it take nearly 12 months to open consultation, nearly 2 years before the funding would roll out from post the actual disaster?
Thanks, Senator Davia. I'll ask Dr Chaka to talk through a lot of the detail, but I think the high-level answer to your question is that we really did want to work with the community to understand how they wished to approach the future of their area. One of the things I feel very strongly at a personal level is that for some communities that are highly exposed to very serious risk of natural disaster, there do need to be conversations about whether all of the homes and businesses that are in those very high-risk places can continue to be there over the long term. But that has to be a conversation that takes place in the community. It cannot be a solution or an outcome that is imposed from outside of the community by a government or another expert-led process. It needs to be something where the community works together to make a decision together about the future of their community. It's feedback I hear very regularly in some of the disaster-affected areas, and we were very keen to see the New South Wales Government, who lead the recovery process in the Central West, engage in a detailed and serious way with those Central West communities to make sure that the program actually responds to what they wanted. We have had, I was in Yagara 2 weekends ago, and I had the chance to speak to a number of the local government leaders there, but also ordinary community members. I think the feedback from them was that they felt it was really important that community was involved. I also know that the New South Wales government at the time, Minister Dibb, made a number of statements about how pleased he was with the collaborative way that the different local government areas and the different local government leaders worked together to identify the best way to allocate resources in those communities. I think he thought it was a very... his observation was that Communities Leaders Forum had operated in a way that really saw everybody look for the best outcome for the whole community rather than seeing people fight for their patch, and he was very proud of the way they'd approached it.
And while I appreciate that, Minister, and I absolutely agree that communities should be involved in determining the shape of their futures, I think the feedback I have had was just the radio silence from the first announcement in November 2023 to when you, to your credit, opened consultations in August 2024. Why from November 23 until you took over, was there no consultation occurring? Was there no collaboration? I mean, when I talked to people in that community and local government, it was like, we knew the package was there, we knew the funding was there, but we had no progress until you've got your feet under the desk.
Well, I'd make two observations. One, the first is that the recovery process in the Central West is led by the New South Wales Government. We provide important funding support, but they lead. The second is that work has been underway during that period to engage with the community to receive feedback about how best to design it. And I may ask Dr Charker to just explain specifically what was going on and the work that was being undertaken by Reconstruction New South Wales.
Yeah, thanks, Minister. So essentially, as you've noted, Senator, back in October 24, the Prime Minister agreed to the Premier's request to cost share an amount of money for the housing program. The PM at that time agreed to cost share initially $2 million for the consultation program element, and the PM agreed in principle for the $40 million for the actual housing program, which was contingent on the consultation being done with community and guidelines being then provided through to NEMA and with advice to the Minister that had been done. So essentially, the core first step was consultation. Prior to the actual going out to the community to consult, my advice from RA, New South Wales RA, or my understanding is that there needed to develop a view of what an appropriate methodology might be to inform particularly eligibility for the housing program. And New South Wales RA, which as the Minister's noted administers the program, developed a methodology for eligibility which was informed by a range of elements, particularly flood mapping that they were compiling to help identify future flood risk in each of the impacted LGAs, but also using flood studies, updated data, input from technical experts, engagement with councils, state emergency services staff, etc., to form an initial view of that methodology, which they then took to consultation this calendar year. As the Minister's noted, there is a very active community leaders forum in the Central West. NEMA is part of that forum, as are, of course, local councils and representatives from New South Wales RA.
I note the funding for that program has come from the DRFA through the Category D funding. Is there a timeline post an event by which the Cat D requests must be made?
So there's certainly a period. I'll have to take on notice the exact timeline for a request for Cat D, Senator. What I can advise that there is also a timeline for a state in which they can incur expenses, which can then be claimed back from the Commonwealth. That's typically 2 years after the year in which the event occurred. Now, in the event that a state, though, identifies that they need more time, they typically would approach NEMA, and depending on the length of time and the quantum of money involved, NEMA would work through a process to assess that request for extension. I'll just have to take on notice the exact time that they can actually submit a request for Cat D, to answer your question.
So, because my concern is we are now 2 years post
the event.
And if New South Wales has not submitted a request for an extension, we could find ourselves up against a brick wall. But it through no fault of the community, and there's a lot of concerns that the opportunity may pass them by.
And certainly, Senator, there are always programs or measures after events which are complex and do require things like consultation in this case and others to develop and then administer, which then do often require some extension of time. And so we work really closely with the relevant state to understand what's needed, why it's needed, and to work through a way forward. As I said, we are working incredibly closely with RA on this program, amongst others. I might switch topics unless if I...
Oh, you have the call, Senator.
Great.
Yep.
Wonderful. I just want to come to some election commitments that were made prior to the last election, given that we are gearing up for another one before May next year, unless the Minister wants to share some intelligence about timing. But prior to the last election, there were several emergency management announcements made, particularly regarding emergency operation centres in several electorates, and two I want to highlight because I cannot find where they may have been progressed. Before the 2022 election, Tanya Lawrence, the member for Hasluck, announced a commitment of $1.25 million for a new incident and response and communication failover centre, and $1.75 million for improving mobile coverage. I know that's the communications department, so I won't ask you about that one. But the community failover centre local government and local residents have not heard anything further. I've received correspondence requesting whether I can assist in finding out where the project is at, and we can't find what program that may have been funded through.
I'll ask the Deputy Coordinator General to respond. Oh, in fact, Jill, are you better placed to?
We think we may need to take that on notice, Senator, and check the origins of it and revert.
Can I just confirm, is this the Wanneroo Emergency Management Precinct?
It was $1.25 million for a new incident response and communication failover centre in the Shire of Mundaring. There was no specific location.
Senator, we'll have to take that one on notice. It's not, it would be potentially in one of the program areas, but the specifics.
I can probably comment a little bit more, Senator. Sorry, I'm just linking the project to the possible funding source, which I know is what you're doing as well. Can I confirm perhaps it's the Wanneroo Emergency Management Precinct, which are the value of Commonwealth committed amount of $3,750,000? Are we talking about the same thing, Senator?
No, that doesn't, because this says $1.25 million.
Senator Davey, give us all of the information you have and we will align your information with ours and see if we can come back to you.
I thought I had the press release, but it's not here. I have got the press release for the other one that I wanted to ask about, which was announced by Fiona Phillips for a Eurobadalla emergency precinct that was originally announced as a $15 million for a new emergency operations centre, and then also then opposition leader Anthony Albanese announced a $25 million commitment to it. But as of April 2024, Eurobadalla Shire said that there had been a lack of progress. In October this year, the Gilmore member said she'd lobbied for a $5 million commitment, which she had got secured in the 2022 budget, which $5 million is a lot less than the 15 or 25 million previously announced. So I'm struggling to follow the bouncing ball from the pre-election commitments to the $5 million commitment, and also then the lack of any further progress.
Senator Davey, I think some of the projects with states and territories have required us to establish federation funding agreements, and there's been significant work underway to ensure that that's occurring. In terms of the two specific projects that you've identified, we can take both of those on notice and provide you with an update on each of them when we come back to the committee. I think there has been, and Dr Charker again can speak about this, significant work with each of the states and territories to establish federation funding agreements that will allow us to provide this money into these projects into local communities.
Okay, the Disaster Ready Fund. I've gone through the 2 rounds that have been funded to date, and I just am trying to get a sense through that fund, is there an analysis of what should be local government's bread and butter business? I look at some of these announcements, such as woody weed management, willow control on riverbanks, and I'm concerned that some of the states are using the Disaster Ready Fund as a bit of a contingency fund to fund what should be bread and butter business by councils or by state governments. So is there an analysis where when you're looking through and you're looking at the guidelines and you are going through all the projects that are sent in, what analysis is done to actually go, well, the councils should be doing woody weed management for themselves? Why is the federal government expected to fund woody weed management or willow control on riverbanks?
Thanks, Senator. Perhaps I can start, and I'll ask Dr Charker to supplement my answer. I think we are really proud of the range of projects that we've been able to fund through this program. We've had 2 rounds now. In August, we announced the second round. There are 164 projects, and there are 187 projects that were funded in round 1. You'll know that for a long time, there were calls from many stakeholders to shift the dial and ensure that there was funding being provided to improve resilience, so that we're actually making the investments up front, not simply providing support to communities after disasters have occurred. It doesn't abrogate our responsibility and the responsibility of states to help communities at the time of disaster or afterwards, but we do need to make sure that we are building resilience up front. We're presently working on the design of round 3. We are genuinely interested in listening to communities about what has worked in round 1 and round 2, and that includes the representatives of communities, such as yourself, Senator Davey. I think we would like to hear feedback about where the community's priorities are. The one thing I would say, and I've noted some of your public comments about this, is that systemic risk reduction and infrastructure are both important. We can get good outcomes by building our broad capabilities as well as by investments in hard infrastructure. We need to find a balance, and across the projects that we've funded so far, we have funded both kinds of things, but we'll continue to calibrate where the weight of our investment goes. Part of that is about getting better data over time about the sorts of interventions that make a difference, and one of the things that NEMA is working on is making sure that we have very good data sets and information about the risks faced, the highest areas of risk across the country, and making sure that we're able to direct our efforts towards those.
And to that end, is there a split between Stream 1 and Stream 2, Stream 1 being more the systemic resilience and Stream 2 being infrastructure? Is there an actual, 75% for infrastructure, 25% for systemic risk, or...?
Our assessment of round 2 was that there was 54 million provided for 41 infrastructure projects. There was 67 million provided for 85 systemic risk reduction projects, and then there was 75 million provided to support 38 projects which combined both infrastructure and systemic risk reduction. I don't believe that I have the breakdown for round 1 with me.
So there's, with the combined, it could be almost a 50-50 split, but there's no priority on infrastructure over systemic.
Both are eligible categories for applications, and as you've observed, we do rely on the states and territories to aggregate and prioritise projects within their communities. This program is always oversubscribed. There are plenty of things that communities wish to do. I am really interested in making sure that we are spending our resources on the areas where we can have the greatest impact. And as I say, I am open to feedback and interested in people's feedback about whether or not we're getting the balance right.
And to that end, when it was announced, and note the opposition supported the change in focus for the Disaster Ready Fund, there was a lot said about the capacity of the fund to also, in reducing risk, alleviate pressure on insurance premiums, as an example, by reducing the physical risks. Is there, and the Hazards Insurance Partnership was established, which again with support of the opposition. Is that partnership arrangement utilised in having a look at some of the projects that are put in to say, is this a project that will actually result in legitimate and real physical risk reduction, to try and see if that intention will be met?
I can ask Dr Chaka to talk with you about, or perhaps Mr Buffoni to speak with you about the work that is happening in the Hazards Insurance Partnership. The criteria for project selection are set out in the grant guidelines. We follow those carefully, and there is a measure of, there are a range of ways that the independence of decision-making around those projects is assured within the guidelines and the decision-making process.
Senator,
just before you answer that question, Senator Davey, I'll have to share the call after this question, then we can come back
That's
to you.
fine.
Yeah, thanks.
Senator, just to put some context before Dr Charker gives you some detail, but as you've highlighted, there are DRF objectives that are quite clear around the increase the understanding of natural hazards and disaster impacts, increase the resilience, adaptive capacity and or preparedness, and reduce the exposure to risk, harm or severity of natural hazards. And then there is a specific panel which is quite independent that has come together with a very diverse group, both from departments but also independents. The panel then assess it against that criteria, and as you've heard, the breakdown, and now Dr Charker can talk about what the next steps are to prepare for the next tranche, but also the Hazards Insurance Partnership.
So, Senator, as you've noted, there are a number of projects announced from rounds 1 and 2 which relate to infrastructure. In round 2, we did ask project proponents to self-identify whether or not their particular project, if approved, would be likely to put downward pressure on insurance premiums. We note that that was self-identified and so had not been actually assured or signed off by an insurer or similar. In terms of then going to that specific issue, the independent panel that Mr Buffoni's just referred to did include actuarial and other expertise on the panel. It did assess all the applications per the guidelines, as the ministers have noted. We did engage with the HIP on the design in general terms of DRF. Going forwards, though, I think, as the ministers noted, there is an opportunity for how we engage to get stakeholder feedback on this particular issue amongst other issues that are raised. So we're literally in the middle at the moment of getting stakeholder in consultation with states and territories and local gov and other sectors to understand administratively what works, but also to your point about the design, whether there's opportunities to do something differently.
Just one more question, if I may, and then I'm done. Just because I have to raise it, because I've had it raised with me by several people. The decision, the project to provide thermal curtains for Canberra households, vulnerable households, at a cost of $3,000 per house, to continue a program that was already established by the ACT government. This one, can you explain how that meets the DRF objectives and why that couldn't have just been foisted back on the ACT government if it was such a good program? They could fund it themselves.
Thanks, Senator, and thanks for the question. So just going back to the objectives of the DRF, so as you'll be aware, the objectives are outlined in DRF's core enabling legislation, and then the guidelines flow directly from that. So the objectives in round 2 of DRF, there were 3. One is to increase understanding of natural hazard disaster impacts. So that particularly goes to understanding risk and data. The second was to increase resilience, adaptive capacity and preparedness of governments, community service organisations and affected communities. And the third one was to reduce exposure to risk, harm and severity of a natural hazards impacts. In the case of the ACT thermal curtains that you've mentioned, that project, per my colleague's comments earlier, was submitted obviously by the state, or the territory rather in this case. It was assessed by the panel. It was legitimate, it was meritorious. It went specifically to resilience to heat waves. So in the ACT government's territory-wide risk assessment actually identifies heat waves as an extreme risk in the ACT, in this territory.
So I'm just concerned that if we have a repeat from every other state government, because heat waves are a risk all over Australia, and New South Wales now sees this, Tasmania, Queensland, at $3,000 per household, is this the sort of project we would support across Australia because it's meritorious? I think when we're looking at these things, we've also got to look at the precedent they set, and $3,000 per household for thermal curtains, I certainly hope those people are getting a reduction in their insurance premiums. Thank you. I'll share the call.
I think that was a statement.
That was a statement. Sorry.
Senator Ghosh, you have the call.
Thank you, Chair.
Thanks.
And thank you to the officials and to the Minister for being here today. I'd like to ask initially about the National Preparedness Summit, which I understand took place in September this year. And one of the observations, Mr Buffoni, that's been attributed to you is that it set a new benchmark for national disaster preparedness. Are you able to elaborate on some of the insights or outcomes from that conference, just briefly, or the summit?
Thanks for the question, Senator. As you're aware, we ran a 2-day summit. This is the second summit that has been ran that brings people together from across the country. But the interesting thing there is that it's not just governments, it's actually the Australian government, state and territory governments, emergency service leads, private sector, and also not-for-profits that all come together. So we step through a couple of aspects. First of all is the outlook, so that everybody has a shared understanding of what the outlook is and discussions around the outlook. Then we actually cover what the preparedness arrangements are, what capabilities exist, and then the other key thing is we ran a series of breakout sessions that were observations from last year, things like remote Indigenous communities, things like groups, special needs groups or those disproportionate at risk, things like warning. So some of those observations, and we actually had experts and discussions that people rotated through. The next day then was spent a full day with 300 people in the room that progressively worked through a scenario that was based on the outlook, but then we took it to the next level. So worst credible scenario that really saw the system under significant stress, and so that we worked through that. So what did that actually define? It told us that the country is well prepared for what the Bureau has forecast for this season, and we've looked carefully at that. And as I said in my opening statement, there are no strong climate indicators, and we are preparing for pretty much any event. Severe weather, cyclones, there's evidence that the oceans remain warm, which increases the risk of cyclones. We've spoken about heat wave, remains consistent, and fire as well is a significant focus, because there are some indicators around soil moisture deficits across the country. So those were discussed. How we share resources across the country was a significant focus. So not only at the local level, but across jurisdictions. So NEMA works very closely and actually funds a significant part of the National Resource Sharing Centre. We also, as you've heard, our national stockpile, and we sort of had discussions around that. And another key aspect is we're also working with international partners should we need to reach out further. So we've got a layered approach to our collective capability. The other key thing is this flows on not just from the summit, but we've continued to run a series of preparedness programs. In actual fact, on Friday we ran 2 for the disability sector. We've ran on Wednesday, I personally ran a session for the energy sector, both and a mini exercise as well. So we're continuing to work through with every aspect so that we can be best prepared for the challenges ahead.
And on that latter point, if I may augment the answer briefly, it's really an evolution and a maturation of the Commonwealth's role over the last 2 years to involve so many different sectors. There was a time when we would have considered, the Australian government would have considered its role was working just with the states and territories. What's significant about the evidence that Mr Buffoni has just provided to you is that it's evidence of the Commonwealth seeing disaster preparedness, response and recovery as being a whole of society effort. And so at the Preparedness Summit, there were private sector entities, there were companies that run supermarkets, companies that run telecommunications, companies that run energy systems. There were NGOs who provide support to communities in the aftermath of disaster, as well as those first responders that are so incredibly significant in dealing with disasters when they arise. This is a new approach for the Australian government, working much more broadly and playing a leadership role in supporting states and territories to engage very broadly with the widest possible range of relevant stakeholders as we prepare for the season.
Thank you, Minister and Mr Buffoni. May I ask about the National Indigenous Disaster Resilience Gathering that I understand was also in September and I understand was attended by NEMA. That's right, isn't it?
Correct. I might hand over to Dr. Jill Charker just to speak about the specific detail, but we've been working very, very closely with Monash University and a range of other Indigenous communities, including NDIA. As I said, one of the highlights out of last season was that remote Indigenous communities were overrepresented in evacuations and impacts from natural disasters. We've also worked with them and developed a companion document for evacuation of Indigenous communities, so actually picking up on some of those lessons. And in actual fact, NEMA is significantly focused on making sure that we are very closely connected. We now have a secondee from NIAA into NEMA, and I, in fact, currently I am the Indigenous champion for NEMA to make sure that we have their issues represented in our planning, in our preparedness. But I'll hand over to Dr. Chark to speak specific to that event.
No, thanks very much. And on the specific event, as my colleague has noted, we did attend, and in fact my colleague, First Assistant Coordinator General Andrew Minack, to my right, attended. So in fact I might just go direct to the horse's mouth and get him to give you an update on what occurred.
Thank you, Dr. Chucker. Yeah, I attended the event in Lismore. It was a 3-day event. It was the first time national gathering of 300 or 400 people from around the country to talk about specific Indigenous issues that relate to emergency management and resilience and recovery. There was a series of issues that were discussed, including how you better engage with Indigenous groups, both within urban settings, but more equally importantly around remote Indigenous communities. The Army Ombudsman who led the gathering, we have a very close relationship with him on a number of other issues. And again, from a NEMA perspective, that issue about the unique elements of impact on Indigenous communities because of their profile in terms of their physical location, their age profile, there are unique elements there. And as Mr Buffoni talked about, the National Resilience Framework that they're working on, that's the opportunity for both NEMA and state and territory governments, local governments, other stakeholders to actually reflect those challenges of partnering with traditional owner groups. Obviously, the other comment I'd made, which was really picked up in the gathering, was the unique understanding traditional owner groups have of the land, how to manage the land, how you incorporate resilience. And again, one of the key themes that was picked up, that for a whole raft of reasons, traditional owner groups have got an inherent resilience, and that can be tapped into in responding to an emergency management event. So, look, in summary, it was a fantastic event. NEMA learnt a lot in terms of those challenges, and looking forward to working with a range of traditional owner groups going forward about how you better incorporate their needs in terms of the work that NEMA does. Thank you.
Thank you. And I'm happy for this to be taken on notice if it's easier to do so, but I'd be very interested in some examples of those resilience insights that emerged from that conference and are being implemented. So if you are able to answer now with a couple of examples, great.
If I reflect on an event, Wudjil, which was a small Indigenous community which was impacted by Tropical Cyclone Jasper, 300 or 400 people, 1.5 hours west from Cairns. That community, in terms of the impact of Jasper and the need to evacuate the entire community from that geographic location, again, the unique elements of the connection to country and the need to maintain that connection, the issue of the family structures. Indigenous communities have different family structures, and we need to incorporate that in our resilience and recovery aspects. And even not minor things, but in terms of evacuating out Indigenous communities, for some of them, they've never been in an aircraft, a helicopter before. So again, they're the kind of both significant things, but just the operational issues that we need to better understand. And the other comment I'd make is, in terms of traditional owner groups, the connection to country in a Wudjil, that need to get back to country for cultural requirements. Again, that's another element that NEMA had to work through very carefully with Queensland Reconstruction Authority and others. And just finally, the connection to country and connection to family and their mob, as it were. When you evacuate entire community, they get spread across a whole raft of temporary housing accommodations. There's a real risk in that environment of individual members of that community being disconnected further from their broader family and other social structures. So there's a whole raft of issues there that we need to be mindful of. And then finally, the actual rebuild of that community, if you went to a place like Wudjil, the impact of the flood was so significant, both the housing stock but also all the key community infrastructure was severely damaged. So again, it's a much more complex program works in terms of recovery for a place like Wudjil. Thanks, Senator.
Thank you. There's been reference in the opening statements, and we've seen an increase in funding that's been provided to resilience, among other things, by the government. Are you able to just briefly outline what the different capabilities in NEMA that the increase in funding has facilitated or supported?
Senator, thanks for the question. I might start with the some of the physical capabilities that we're actually building. You heard both from the Minister and myself around aviation capability. Again, this is a significant shift. So we've continually funded aerial firefighting capability. What we've done this year is significantly increased the national capability for multi-use. So we currently have a large air tanker that is a C-130 ex-military style of aircraft that can be reconfigured to do resupply, for example, and under certain conditions can support the movement of personnel. We've got 3 now heavy lift aircraft, so in line with the Royal Commission Type 1 helicopters, which again can be reconfigured to move people around. So that's one, and that's a significant aspect, because one of the things that we've found is obviously drawing on ADF significantly, aircraft is a focus, and National Aerial Firefighting Centre has done a great job working with us to actually achieve that. The second part is our National Emergency Management Stockpile. Again, a significant shift in capability that we're continuing to develop. The first part is the emergency shelter capability, and in actual fact it was first deployed after Jasper up into North Queensland for use, and we can now house up to 700 community residents and up to 1,400 emergency workers or workers. So obviously that assists in actually both the response and the recovery. We've also now got power generation capability, water purification, flood mitigation, a range of consumables as well. And then the other key aspect is we've got what we call a virtual marketplace, where it is a panel that both states and territories, but the Commonwealth can reach into and expedite any emergency services or capabilities that are required. In addition to that, the funding of Disaster Relief Australia, a veteran-led volunteer organisation. They are increasing their volunteer numbers to about 4,500 at the moment, with a target of above 700, and they can be used by local government, states and territories, but also deployed by the Australian government when a particular threshold. So we're seeing this significant capability increasing from a physical capability. And then I might just see from Dr. Charker if there are any additions in terms of financial.
I think it's the capabilities you've already outlined.
Thank you.
Thanks, Joe. Yep. Chair, if I could just note, I had a very quick return on a question I undertook to take on notice from Senator Davey just before. Senator, this was in relation to your question about whether or not there's a time limit for a state to submit a Cat C or D request. Mm-hmm. The answer is there is no time limit to submit such a request, but typically we would not consider a request if it were outside that 2 years after the year in which the event occurred. Right. But within that period, there is no set time limit. Just on your other question, Senator, about the Eurobodalla projects, we suspect they may actually be programs administered by another department, but as promised, we're looking at this on notice and we'll revert in that manner.
Okay, thank you. And we will get the HASLUC press release to you so you can
That's terrific.
get us information back on that too.
Thank you.
Thank you.
Senator Davey, I understand that the HASLUC arrangements sit within a broader Federation funding agreement that's under negotiation with the West Australian Government, and we're working with the Cook Government on those issues.
Thank you.
Thank you, Senator Ghosh.
I've just got a few more questions and then I think I'm done. I've seen it reported that there have been a number of minor earthquakes and tremors in the Muswellbrook area, and my question relates to, does NEMA have a role, and do you interact with Geoscience Australia around these sorts of seismic events in terms of part of your planning or preparation?
Senator, thanks for the question. The answer is yes. We have a very close relationship with Geoscience Australia. In actual fact, they are embedded within our National Situation Room, and we also put out the notifications when they hit a specific criteria. So support Geoscience from that perspective, and then of course subject to what impacts those earthquakes have, then we will respond and support the jurisdiction accordingly.
Now, I understand that that's relatively close geographically to the Little Power Station and that there's a proposal potentially to put a nuclear power plant in the area. Can I just ask, from a disaster preparation or management perspective, have you given any consideration to what the impact of putting a nuclear facility in an area that has that sort of seismic activity would be?
Senator, the answer is no. We haven't been engaged and we haven't been asked to undertake any advice in relation to that.
Would you expect to be?
Senator, it depends. I mean, obviously that's a planning matter, both from a jurisdictional perspective and from a federal perspective. But normally historically we haven't been asked to provide advice on those types of events. But obviously if we were asked, we would consider it at the time.
And I noted that you referred to the interaction you have with community and volunteer groups in the disaster relief and management sector. Have any of them raised issues with you about the potential for a nuclear power plant to go into that sort of area, and concerns about seismic or other kind of...
Not at this point, Senator.
Okay, thank you.
Thanks very much. That's all the questions we have for you. So thank you very much for your time and for your work in the communities that we represent. We appreciate it. It's an ongoing, particularly for those disasters that have happened 12 months ago, and there's a lot of work still to happen to recover. So thank you, and all the best for the weather season coming up.
Thank you, Chair.
Thank you very much. We do have a swap at the table of a few officers, so we might just suspend the broadcast briefly and get that to happen as quickly as possible. Thank you. Well, the committee will resume its hearing. Thank you to Broadcast. I appreciate it. I now welcome officers from the Department of Home Affairs. Welcome, Ms Foster. And thank you, Senator McAllister, Minister McAllister, for staying here while we get the Minister to the table. No one really expects our committee to run on time, so I imagine. Well, we'll see how we go. I mean, I'll refer you back to those comments, Senator Scarr, later today. Ms Foster, would you like to make an opening statement before we go to questions?
Thank you, Chair. I want to start by noting that we farewelled Commissioner Outram last week to acknowledge his dedicated public service over many decades, most particularly his leadership of the ABF for the past 7.5 years. We wish him well in his retirement. We look forward to welcoming Gavel Reynolds into the role next week. While the Commissioner enjoys a brief period of leave prior to the end of his contract, Acting Commissioner Tim Fitzgerald and his team are ready today to support the committee. There have been many significant achievements across the organisation since we appeared before budget estimates in May, but this morning I want to highlight just one in particular: the work done across the organisation in support of the repatriation of Australians and their families from Lebanon. Our teams across immigration and ABF worked tirelessly to support the safe return, reception and settlement where needed of over 3,000 people in collaboration with colleagues in DFAT and Defence. I call out especially our team in Beirut, both our posted officers, our locally engaged staff and all those who deployed at short notice for their courage and commitment. And I welcome the committee's questions.
Thank you, Ms Foster. We now have questions in relation to cross-portfolio corporate and general matters. Senators, I'll direct or just politely ask you to make sure questions are relevant to that section of the committee program, which we have a short amount of time for this morning. I'm assuming, Senator Patterson, you're seeking the call. Thank you. We'll start with you and welcome Minister Watt.
Great to be here.
Thank you.
Thank you, Chair. Good morning, Ms Foster. And can I place on my record the Coalition's appreciation for Commissioner Outram's service to our country over many decades, and our congratulations to Gavin Reynolds on his appointment. He's also a very well-respected public servant who I have worked with in previous roles, and he's a great appointment. I do note it's a very well-timed departure from Commissioner Outram in avoiding one more painful session of estimates, but I won't hold that against him. He's done enough. Ms Foster, as is my usual practice, I wrote to you a week ago seeking some information in relation to this round of estimates and to give you advance notice of areas of questions that I'd be seeking specific information for. Are you in a position to table any document that responds to that letter? And Chair, could I seek leave to table my correspondence, which I've already provided to the Secretariat?
Yeah, I mean, you can table the correspondence. We already have a copy, so thank you.
Thanks.
So, Senator, no, I've brought the officers prepared to answer the questions in the appropriate outcomes in accordance with the advice that I gave you at the last estimates hearing.
Okay, so have they prepared a document to refer to answer the questions that I'll have to now ask in each outcome?
Senator, they'll have the information with them. They won't have it as a document.
Right. I mean, it would be much better use of the committee's time if they're able just to table the answers given that advance notice was given. Otherwise, we have to take up the committee's time asking questions which you know I'm going to ask, which you've already prepared answers for, which could just be tabled and save the committee time. Is there a reason why you can't do that to facilitate the committee's scrutiny?
So, Senator, I think I was very clear last time. I will give priority to preparing all questions across the range of issues rather than preparing documents to table.
Well, I don't really see the difference between preparing to answer questions and collating the information required to answer them and just not having it in a document that can be tabled because we have limited time in estimates in this session, and it obstructs the Senate's ability to conduct scrutiny of the department and the government if we have to go through a laborious process of asking factual questions when the answers are already ready. Okay. All right. Well, I look forward to doing that in the relevant outcomes. Just want to move on to another matter. Secretary, I couldn't help but notice that there was a change recently in the photographs of senior departmental officials on the Home Affairs website. Are you familiar with that change?
I think I am, Senator, if it's the one that I think you're referring to.
Well, why don't you describe what the change was, if you're familiar with it?
So, Senator, some time ago I asked my staff to redo the photographs of the senior executive without flags in the background. Is that the change you're referring to?
Yes, yes. So sometime between July and August, we noticed that the headshots of yourself and other senior officials in the department previously had the Australian national flag as well as the Aboriginal and Torres Strait Islander flags in the headshot, and then after that period they're no longer in the headshot. What was the reason for removing the flags from the headshots?
Senator, I wanted to have photos that were less formal.
Right. As far as I can tell, the photos themselves haven't changed. It's the same photos. The only thing that's changed is the flags have been removed. How does removing the flags assist with informal photos, and what's the purpose of having informal photos on the department's website?
Senator, I think having photographs against a background of flags gives a certain formality to the photo. As you know, as part of our cultural reform, I've been working hard to make sure that the senior executive are very accessible to staff. It was one small change that I thought might assist with that program.
The Department of Home Affairs, among other things, administers the citizenship test. If I'm right in recalling, I believe there are questions on the citizenship test about the Australian national flag and other flags. Is that right?
I believe that's right, Senator. I don't have the details with me.
Yeah. The department, more than any other department of the Commonwealth, is responsible for making sure new citizens understand the importance of our national symbols, are educated about our history, our national symbols. Why is the department uncomfortable appearing in photographs with the Australian national flag and other flags?
Not at all uncomfortable, Senator. I've explained the rationale between me removing them.
Right. It doesn't look to me like new photographs were taken. Presumably you've assigned someone to Photoshop and remove these flags from the backdrop of the existing photos, is that right?
I don't know how it was technically done, Senator.
Okay, well, you obviously issued the instructions for it to happen. What did your staff tell you when they said they would go on? But they obviously didn't tell you, well, you need to get a sit down for a new photo, so how did they tell you they were going to do so?
They didn't, Senator.
Right. So you haven't wondered, how many of your staff have spent time on photoshopping these?
No, Senator.
Which function of the department performed the task?
I'd have to ask Ms Sharp if she could help me with that, but we have an area, Senator, which maintains our website and does sort of external-facing media.
If Ms Sharp could assist, that'd be great. And for the assistance of the committee, I might table the before and after photos. Thank you. Ms Sharp, could you shed light on who was assigned to this task of removing the flag from the headshots?
Senator Sophie Sharp, Deputy Secretary Executive. It's our Media and Communications area, Senator.
Yep. Are you familiar with how they removed the flag? Did they use Photoshop or some other service?
Not the technical detail, no, Senator.
No, but presumably they digitally altered the photos because new photos weren't taken?
Presumably, yes.
How long did it take to complete the task?
Senator, we'd have to take that on notice.
Yeah. Did you have any conversation with the minister, either the previous minister or the new minister, about this issue?
No, I didn't, Senator.
And what about the minister's staff?
No, Senator.
No, so this is a spontaneous initiative of your own to remove the flags?
It is indeed, Senator.
In July and August, the department was dealing with some pretty big issues, continues to deal with some big issues, whether it's the released cohort of non-citizen offenders or whether it was Palestinian visas or boats getting through to the Australian mainland. Was this really a high priority for the department at a time like that?
So, Senator, in terms of executive focus, it occupied very little time, and whilst I'll have to take on notice how big the technical job was, I'm struggling to believe it was much work.
I think it's an interesting demonstration of priorities that taking the flag off the headshots on the website was a priority for you and the department at a time when the department was failing to refer AAT cases to the minister. You had to surge extra resources to a part of the department to make sure that that happened after going for hundreds, if not thousands of days in some instances of failing to refer cases. This was really the priority for the Department of Home Affairs at a time like this?
Senator, as I said, it was a very small issue which took very little of my time and effort. I have no concerns about my capacity to focus on the big issues facing the department and do that.
On previous occasions where I've questioned you on the performance of the department on things like the AAT referrals issue, you've said that resources is a factor, that you're very constrained. And yet again, this is the priority that you've assigned employees of the department. There's nothing better that they could be doing with their time rather than photoshopping the flags out of headshots?
So, Senator, I think the folks who assisted with taking flags out of the photographs clearly would not have been able to assist us with AAT referrals. As you note, we have surged a considerable number of resources, and we're looking forward to talking to you about our progress on that issue when we get to outcome 2.
Likewise, thank you. All right, moving on to another matter. Who's the Cabinet Minister who has responsibility for counter-terrorism?
The Minister for Home Affairs.
Okay. Who's the Minister responsible for the high-risk terrorist offender scheme?
The Attorney General.
Right. Why was the Minister for Home Affairs not present at the announcement with ASIO of the increasing of the terrorism threat level?
Senator, I think we'd need to ask ministers
need
that.
to take that on notice.
I don't know the circumstances of that.
So the Prime Minister was there, the Attorney General was there, the Director General of ASIO, Mike Burgess, was there, but it's hard to think of a more important announcement in counter-terrorism policy than an increase to the threat level. Was the Minister for Home Affairs busy that day? Was he not invited? Why wouldn't he be there for an announcement as significant as that?
Well, I've already said I'll take that on notice.
Okay, thank you. What do the administrative arrangements orders say about the Minister for Home Affairs' responsibility on national security?
Senator, I think they refer to policy for national security, but I'll ask again Ms Sharp to come and assist me with the exact wording. And if she doesn't have it to hand, then we will get you the exact wording.
Senator, from memory, and I'll get the exact wording while we're here, it's National Security Policy Coordination.
Right. This may be out of date prior to machinery of government changes, but I understood it said National Security Policy and Operations, unless the and operations part has been deleted recently.
As I said, I'm getting the exact words while we're here, Senator.
Okay. Be helpful if there's anyone in the room who has that information could come forward. Surely someone in the department knows what the administrative arrangements orders say about the department's responsibility for national security policy and operations, or not?
I'm sure they do, Senator. I think they're probably just quickly checking to make sure that they provide you with completely accurate information.
Okay. Let's proceed on the basis that it still says and operations, and that wasn't changed in the last machinery of government changes that the government chose to make. How could the Minister for Home Affairs be responsible for national security operations with no operational national security agencies in the portfolio?
So, Senator, I think it's very difficult to answer that until we know what the AAO actually says, and Ms Sharp has assured me that people are working on it as we speak.
Yep, I would have thought this would be something that would be not hard to get to the bottom of, be probably in a public document somewhere, and probably should be within the knowledge of senior officials of the department anyway. But I'll persist until you please interrupt me if that answer comes through.
And it may be, Senator, that the staff in Outcome 1 are not actually present in the room at the moment, which is where obviously that policy role sits.
Well, we're moving to Outcome 1 straight after this outcome, so I hope they're not far away.
So do I, Senator.
Okay. The Counter-Terrorism Coordinator still works in the Department of Home Affairs, don't they?
That's correct, Senator.
Does the AFP or ASIO have a responsibility to brief the Counter-Terrorism Coordinator?
So, Senator, there is a distinction between the operational role that ASIO and AFP play and the policy coordination role that Home Affairs plays. And so we have very close collaboration with both ASIO and AFP on all matters to do with counter-terrorism policy coordination across government. Where, for example, one of those agencies is running an operation, they will make a choice at what point they advise, taking into account all of the operational needs, security, etc.
Yeah. Hence why I've asked this question about the administrative arrangements orders and whether or not the department and the minister are still responsible for national security operations. It's kind of a key issue that really no one in the room who knows the answer to that question. Speak now or forever hold your peace.
Sorry, Senator, just to confirm, you asked me to jump in when we did have it
Yes.
confirmed. It is national security policy and operations in
Right,
the AAOs.
there we go. Okay. So, if the Minister for Home Affairs is responsible for operations, why is it discretionary that the AFP and ASIO can brief the department and the Counter-Terrorism Coordinator on operations?
So, Senator, I was very careful in describing the issues that might make the operational agencies choose their timing in when they actually brief about operations. And so at the broad level, we work very closely together, and it's very unusual for either the head of AFP or the head of ASIO not to give me a heads up when there's something significant in train.
Well, I hope it would be better than a heads up if the department and the minister are responsible for national security operations.
So, Senator, I think the operational responsibilities of both the AFP and ASIO are well articulated, as is the independence of those agencies. And I can only assure you, Senator, that the relationship is close and strong and that we work very well together, no matter what our organisational structures.
Yes, but
Patterson, I have to share the call if you have
Sure.
one question.
Thank you. Just a final question on this. I might need to come back later, Chair. How then can the minister actually be responsible for national security operations if the two key operational agencies are no longer in his portfolio and they report to and are responsible to a different minister?
So, Senator, I can only repeat the evidence I've given you. It's a very strong, close working relationship with a lot of architecture to support collaboration between us. I was obviously not present at the time that AFP moved out of the portfolio, but I was when ASIO did. And if anything, DG Burgess and I speak more frequently, engage more frequently under these arrangements than we did before.
Thank you, Chair.
Thanks, Senator Patterson. Senator Shoebridge, you have the call. And just to let, we're due to go to a break at 10:30. We can go a little bit longer if you've got a block now, and then we'll come back after the break as well.
Oh, I can take us to 10:30 and then continue after 10:30 would be useful. Thanks, Chair. Secretary, did you bring a copy of the employee census for 2024 with you for Home Affairs, the one that was, I think, in the field between the 6th of May and the 7th of June?
I don't have the whole census with me, Senator, but my staff do.
All right. Well, you're familiar with the outcomes, though?
I am, Senator.
How would you describe the outcomes?
So, in the broad, Senator, we've made some progress in some of the key metrics that matter most about staff engagement, about SES communication. We clearly have significant work still to do, and that's not surprising to me in the context of a very large agency operating in a very complex environment.
Home Affairs is in the bottom 10% of every rating for the public service, an agency in the bottom 10%. And in fact, on one of the critical ones, Employee Engagement Index, you come 100th out of 104 agencies. This is an agency that's deeply unhappy, isn't it? Your team, your staff, compared to the APS, are deeply unhappy.
No, Senator, my staff aren't deeply unhappy.
100th out of 104. That's...
And
who's doing worse?
This time, did this employee engagement come up this time?
I can talk to So, Senator Charlotte Dressler, Chief Operating Officer. In relation to our employee engagement scores, every one of the factors compared to last year improved. Some of them only marginally, one at least by 4 points on last year. So yes, we acknowledge that there is some room, certainly room for improvement, but we are headed in the right direction.
Do you adopt that position, Secretary?
I'm sorry, Senator, do
you adopt Ms Tressler's position?
Senator,
does she speak on your behalf too?
I am very... I'm reassured that we are moving in the right direction. I'm also pragmatic, and I know that it takes time to change perceptions, and it takes significant time in an organisation of 15,000 people. And we are continuing to talk with, consult with, listen to our staff about what they want and need, and that's the fundamental underpinnings for the transformation program that we're running.
One of the fundamental underpinnings for a transformation program in an organisation that has such poor ratings would be people feeling empowered to raise inappropriate behaviour. Do you agree that would be one of the fundamental underpinnings?
Senator, I think putting in place practices and behaviours that have people feel comfortable to raise any concerns is really important, and we've been doing a significant amount of work to talk to our staff about what are barriers to them raising things and how can we work together to address those.
Can you provide the committee with a copy of the survey? Be useful over the morning tea break.
Senator, I think the survey is publicly available on the APSC's website.
It's not actually published yet.
I thought the APSC published it. So, Senator, I understand it's a summary that's up on the APSC website. I'll take on notice whether or not it's feasible for us to provide a copy to the committee.
Over the morning tea break, can you provide it to us over the morning tea break? You have a copy, I assume. Ms Tressler, have you got a copy there with you?
I'll take on notice, Senator, whether or not it's possible to provide it.
Ms Tressler, do you have a copy there with you?
Senator, I've answered the question.
Ms Tressler, do you have a copy there with you? Secretary, you cannot direct the questions.
I can choose to take questions, Senator.
No, you can't.
Well, Senator
Tressler, do you have a copy there with you?
Senator Shoebridge, the Secretary has taken your question on notice.
Ms Tressler, do you have a copy of the survey there with you at the desk? Ms Tressler.
Senator, it is my prerogative as a senior officer.
No, it's not your prerogative to not answer questions to witnesses who are at the table. I'm asking Ms Tressler, and I'm seeking your assistance in this, Chair, so we don't get obstruction from the Secretary.
Senator Shoebridge.
Does Ms Tressler have a copy of the document with her at the table?
Senator Shoebridge.
The Secretary's not assisting, she's obstructing.
Senator Shoebridge, I'm speaking. Senator Shoebridge, officers are able to refer matters to a more senior official for that question to be answered.
Well, then Ms Tressler can do that. Ms Tressler, do you have a copy of the document there with you? Ms Tressler, do you have a copy of the document there with you? I'm not asking you, Secretary, with all due respect. Ms Tressler, you're sitting at the table, you're here for Senate estimates, and I'm asking you, do you have a copy of the document with you?
Point of order, Chair. I just think we need to be mindful not to put our witnesses in a difficult position. Ms Tressler is sitting next to the Secretary of the Department. I just think we just need to consider Ms Tressler's position.
But the Secretary is putting Ms Tressler in that position by refusing to let her answer.
No, that's...
And the Secretary should be aware of that.
Senator Shoebridge, I'm going to let Ms Foster answer your question. She's the senior official at the table and she's able to ask your question, and if that includes taking it on notice, coming back to us after the break, then that is a reasonable answer, Senator.
But you see, Chair, it's Ms Tresler who has the document in front of her, and Ms Foster who is
the senior official at the table, and you should really be mindful of the language that you are using. Senator...
I am mindful, because it's what's happening.
Senator Shoebridge, Ms Foster can answer the question. We're due to go to a break, which we agreed we would do at 10:30. Ms Foster, I think you've agreed to take that on notice.
I have, Senator.
Okay, thank you. The committee will now break for morning tea, and we'll return just after 10:45 a.m. Thank you. Well, the committee will resume its hearing, and we are still in cross-portfolio and corporate and general matters. Senator Shoebridge, you have the call for a short amount of time, and then I'll hand back to Senator Patterson. Thank you.
Thank you. Secretary, I asked you earlier about whether you thought one of the key indicators for positive organisational change was whether or not people felt confident to speak up and raise concerns about inappropriate behaviour. Do you think that's one of the key indicators for organisational change?
I do, Senator, and as I said to you in response to that question, we've been working hard to provide an environment in which staff feel that they can do that. And in fact, one of the things that came through in our census was an increase in the number of people reporting things like bullying and harassment. I note that anecdotally, people are comfortable emailing me to talk to me about what's happening in their workplace, and that's all part of the change that we're trying to drive.
You see, that's not what the survey says, though, is it? That just isn't what the survey says.
I don't agree, Senator.
All right, well, I'll assist by giving you a copy of the survey I tried to get out of you earlier and table it.
Thank you, Senator.
Yeah, no, I'm here to help. Could I ask you to look at page 24 of that?
I'll just ask.
If you've got a copy there, maybe Ms. Trezor could give you a colour copy. Mine's only black and white.
I think it's being circulated now, Senator, so I'll just make sure that I've got exactly the version that you've got, because there are different ways of presenting the data.
Yeah, as I said, Ms. Trezor may have a colour copy, which might be easier to read.
We heard you. Smarty pants remark the first time.
Sorry, Minister?
I said we heard your smarty pants remark the first time.
That's your contribution, is it, Minister?
It is.
Yeah, I'm glad you're here. Yeah.
So, Senator, could you remind me which page you wanted me to...
Page 24. Now, you said that people feeling confident to speak up and raise concerns of inappropriate behaviour, and that indicator improving would be important indicator for organisational change. You've got it there in front of you. What happened to that indicator? Well, I'll give you a helpful summary. It dramatically got worse, didn't it? It got dramatically worse last year.
It dropped by 10 points, Senator.
Yeah, and in this survey, that is, I think, in a very bad survey for your agency, that is the single worst outcome. Under your leadership, Secretary, people feel much less confident to speak up and raise concerns about inappropriate behaviour than they did before you became Secretary, and the previous Secretary was not a shrinking violet. How do you explain that?
So, Senator, I'm just asking my staff if we've got any background to that which would assist me to answer the question. But all I can say is that it's absolutely not my experience of the way that staff are engaging and feeling comfortable to speak up.
Did you read this survey?
I did, Senator. That particular data point was not front of mind this morning.
But when you read the survey, I mean, it's only 25 pages long. I assume you read it cover to cover. Did you read it all?
Senator, as I said, we have different presentations of the survey material. I must have by now participated in many, many hours of analysis of the data and discussions about how we will respond to it.
Is this the first time it's been brought to your attention that there's such a dramatic fall in the number of your staff who feel confident to speak up and raise concerns of inappropriate behaviour under your leadership? Is this the first time that's been brought to your attention, Secretary?
So if I can, Senator, certainly in the presentations that we've gone through with the broader executive team, we have had a look at the bullying and harassment results, and we did see that there was a decrease between years. We, as Ms Foster was talking about earlier, we do believe that in part that's because of the confidence of people to actually be more open about what has been occurring within the department. and we have indeed been going through an integrity cultural reform exercise so that we can continue so we can actually see some improvement in this through this next year.
Ms Tresler, this is the opposite of people feeling more confident and
sometimes,
able.
Senator, you do
Just let
see
me finish the question.
Going backwards
Just let me
before
finish
you
the question.
see them going forwards.
This is the opposite of people feeling more confident to speak up and raise concerns or raise concerns. If that's one of the indicators for organisational change, things have got a lot worse. And Secretary, I ask you again, is this the first time that it's been brought to your attention that you've had such a dramatic fall in the proportion of your staff who feel confident to speak up and raise concerns of inappropriate behaviour? Is this the first time it's been brought to your attention?
No, Senator. I look at the census results in totality, and if I can direct you to page 18, you'll see that there has been an increase in the number of people reporting harassment or bullying in accordance with the agency's policy and procedure. And there has also been an increase in the people saying that they have been subjected to it. Sometimes you will see anomalies in data in census, but this is only one tool that we have at our disposal, Senator. I engage with staff on a monthly basis. We typically have about 5,000 of those staff dialing in. Each month they are able to ask any questions, and they do. That's why I feel confident that they have a fairly good sense of the confidence that people are feeling.
But Secretary, you weren't even aware that there'd been this dramatic drop in the confidence of staff to speak up and raise concerns about inappropriate behaviour until I took you to it in this meeting.
Senator, what I said was it wasn't front of mind this morning. I have spent many, many hours going through the data, and as I said to you, I look at the data in total, and I've been focused on what we do in response to it.
Well, the other data point you take us to is that there's been an increase in the reports of harassment and bullying, for the survey, quite a significant increase. And I'd suggest to you, Secretary, that the fact that the number of reports of harassment and bullying have increased at the same time that people feel less confident in raising it with you suggests, rather than a good story, a far more problematic story, because not only are people less confident in raising it with you, they're also telling you about more bullying and more harassment. Those two data points make it worse for you, Secretary.
So, Senator, I don't think it's correct to personalise it. This is a survey which is about the organisation, not about the Secretary. And whilst absolutely I am the leader of this organisation, there are many levels at which people will be responding when they answer surveys. I am very confident that the work that we're doing with the organisation is helping to build confidence, and that people are, in fact, coming forward.
Individual staff are not going to raise concerns about inappropriate behaviour.
I'll share the call after this question. Thank you.
Secretary, individual staff are not going to speak up and raise concerns about inappropriate behaviour in an online meeting with 5,000 staff in attendance and you chairing it. That's a farcical suggestion, isn't it, Secretary? And if that's your suggestion of how you get a gauge of what's happening in your department, you've really got problems, haven't you?
So, Senator, all I can say is people do. So the questions come in online and people raise all sorts of issues in that forum. They also, Senator, as I said, email me and my senior staff directly. We have a pretty good sense of people's confidence in talking to us.
Secretary, 11,400 staff responded.
Senator Shoebridge, I gave you a really clear direction that you had one last question and then I would share the call. You don't need to speak over me when I'm trying to do that. Senator Patterson, you have the call.
Thank you, Chair. Perhaps the new informal headshots, Senator Shoebridge, will fix this problem and staff will be inspired to come forward now there are no Australian flags in the headshots. Moving back to the issue of counter-terrorism responsibility, so we've established that the Minister for Home Affairs is responsible for national security policy and operations and is the responsible Minister for counter-terrorism. but not the responsible minister for the high-risk terrorist offenders scheme, and presumably not responsible for the terrorism threat level, given the minister had no involvement in that announcement?
The minister was briefed by the Director-General before the announcement, Senator.
I would hope so, but why wasn't he at the announcement?
I've already taken that on notice.
Right, well, it seemed that Ms Foster had further information, so I thought you might have got to the bottom of that as well.
I'm not sure if Ms Foster has additional information.
Senator, no, I didn't pursue that over the break.
Okay. Who's the minister responsible for the listing of terrorist organisations?
So, Senator, legislatively, the Attorney-General has the legislative authority to bring forward the listing of organisations. I'm not trying to duck the questions. I just wonder if it might be better to do it in outcome one when we've got the counter-terrorism experts at the table with us.
I may have further questions in outcome one, but cross-portfolio is the traditional area to ask about division of responsibilities between ministers across portfolios, so I won't persist for now. So the Minister for Home Affairs is responsible for counter-terrorism or national security policy and operations, but it's not clear to me that the minister has any operational levers because they don't have ASIO or AFP in the portfolio anymore, nor do they appear to be responsible for three of the key counter-terrorism policy levers, including terrorism listings, the threat level and the high-risk terrorist offenders regime. What actual levers does the minister or the department have on counter-terrorism?
So, clearly, Senator, the minister continues to have responsibility for the operational arm of the department, the Border Force colleagues who work with other agencies as appropriate on issues. I think there is also, it's also relevant that, for example, on an issue like listing of terrorist organisations, it is the Department of Home Affairs who does the work to pull together the case for whether or not an organisation should or should not be listed, provides advice to the Minister of Home Affairs on those terrorist listings, who corresponds with the Attorney-General on that issue, and the Department of Attorney-General supports the Attorney in terms of the procedures.
Why is the department still responsible for preparing a brief on a new terrorism listing, and why do they need to brief the Minister for Home Affairs if the Minister for Home Affairs is no longer responsible for terrorism listings?
So, Senator, it fits with the department's role in coordinating counter-terrorism policy across government. And so if I can make an analogy, for example, where there's a counter-terrorism incident, clearly the operational response is run by the police and ASIO, but the stepping back a bit, the ensuring that we have the right architecture and processes in place to respond effectively at a whole of government level, and in the moment ensuring that the right information is going to the right people is a role that Home Affairs plays. And so it's consistent with that coordination across government that we would collate information from a variety of sources about the case for a terrorist listing.
But that's causing delays in the listing process, isn't it?
I don't believe so, Senator.
Well,
we work very closely with Attorney-General, so we're both doing our work in collaboration.
Why did the Minister for Home Affairs sit on a recommendation to list the Houthis for 6 weeks?
Senator, I'm not aware of the circumstances around the listing of the Houthis. I'll take it on notice for now and see if we can assist in outcome one.
You've previously answered questions on notice on this and provided a timeline for consideration, and it is the case that the former Minister for Home Affairs, Claire O'Neill, sat on a recommendation to list the Houthis as a terrorist organisation for 6 weeks. The Prime Minister also waited a month before he wrote to state and territory leaders about it. Isn't this an inefficiency that's caused by the government's machinery of government changes, which bizarrely divides counter-terrorism responsibilities between two ministers?
So, Senator, I'd like the chance to refresh myself on the details of the listing for the Houthis.
Okay. When did work commence on updating the national strategy on counter-terrorism?
Senator Patterson, I think you're straying into questions that may be relevant in the next outcome. We are in cross-portfolio general matters. We'll get to outcome one as soon as you finish your cross-portfolio and general matter questions.
Okay, I'll return to that matter in outcome one. One other matter.
Of time.
Thank you. One other matter. Is the department still responsible for the protective security policy framework?
We are, Senator. That in fact transferred to the department relatively recently.
And under the PSPF, is the department responsible for the protection of classified information of the Commonwealth?
So we have the overarching policy responsibility, Senator. Again, I know that these are questions about responsibility, but the actual operation, the way we operationalise that would, I think, be more, it would be easier to cover in outcome one.
Let's see how we go, and if need to, we can revisit it in a subsequent outcome. What classification does a cabinet document generally attract?
So, Senator, it depends a little on the subject.
What's the minimum classification
matter
for a cabinet document?
I think it's typically protected cabinet.
Right, and can range up to?
Can be up to top secret, Senator.
So would the department be involved in an investigation if cabinet documents are lost?
So my memory from PM&C, Senator, is that it was actually Cabinet Division in PM&C that were the sort of custodians, whilst Home Affairs, as the PSPF owner, sets the policy. But I think, and I'll have someone check this for me, my memory is that investigations into cabinet documents, loss or whatever, are done by PM&C.
Well, presumably that's set out in the PSPF?
I'll take that on notice and see if I can get you an answer.
Thank you. So it's been reported by Capital Brief that Minister Watt's staff member left classified documents on a plane, I believe in Doha, on a Qatar flight, that were lost. Was the department involved in investigating those loss of documents?
Not to my knowledge, Senator, but I'll check and I'll let you know if we were.
Do you know what classification those documents had?
No, Senator.
Cabinet documents are assigned under the PSPF, I assume, correct me if I'm wrong, not to individual staff members but to the Minister. The Minister's responsible for cabinet documents, aren't they?
So, Senator, the process in the department is that cabinet documents are assigned to the officer that needs to read them. So it could be that any one given cabinet document is assigned to me and 3 of my staff, for example. I'm not familiar with the process in the office. Technically, of course, it's the Minister to whom the document
Indeed, because it's
is
only
assigned,
the Minister who's a member of Cabinet.
But I don't know how the process works in terms of handling the document within the office.
Right. Perhaps, Minister Watt, you can assist us. Do you know what classification the documents were that were lost?
I would have to go back and check the exact classification. But I think it's already been reported that these were not matters involving national security.
I would hope not. Were they being stored in a secure parcel to transport them?
They were.
Right. And so no further information has come to light about where they ended up?
I'll double check that, but not to my knowledge, no.
Right. Under the PSPF, can classified documents be taken out of Australia?
I'll need to check that detail, Senator.
Right. So protected maybe, top secret presumably not, secret?
So, Senator, as you'll be aware, there are handling requirements for various levels of documents. And what I'm not sure about is if it specifies handling in and outside Australia, and whether that distinction matters in terms of the arrangements in the PSPF.
Remind me of the definition of the classifications. I'm struggling to recall off the top of my head. I think starting at top secret down, it quantifies the sensitivity of the document based on the harm to Australia if they were leaked. Is that right?
That's correct, Senator, but what I don't have is the exact words in my head about how those are actually quantified.
From memory, it starts with kind of gravely detrimental to the national interest if they are lost at top secret, and then detrimental and other kind of modifications of that language on the way down the spectrum.
Senator, in the broad, you're right. What the actual language is, I'd need to get the document in front of me.
Right, so you don't know what classification these documents have, and therefore you can't say what the damage to the national interest was by losing them?
That's correct, Senator. And as I said, I'm asking folks to check whether or not we actually have any role in the investigation.
I would hope as the PSPF holder that the department would have some involvement.
Senator, I think and again, I'll ask my staff to correct me if I'm wrong, what the PSPF does is set the policy and then the responsible authorities, whether it be the department itself or a central area like PM&C, then implement
Does the
policy.
PSPF specify any role for the AFP investigating if documents are lost?
So, Senator, there are processes, protocols around how the AFP engages with investigations relating to classified information. Whether that's set out in the PSPF or not, I'll need to check.
But presumably, certainly if it was sensitive, I mean that in the general sense, not in the classification sense, if it was secret or top secret, the AFP would have a role in investigating that, surely.
Senator, I think it would depend on the circumstances, and I'd like to check how that's documented before I answer you.
Could you also take a notice whether in this instance it was referred to the AFP for investigation?
I certainly will.
Minister, are you aware if it's been referred to the AFP?
I'm getting my office to double check exactly what reporting occurred, but certainly the matter was reported to a number of officers within government, and my understanding is it was referred to everyone who needed to be or should have been, but I'll find out the exact details and come back on notice.
And have any of those bodies that you referred it to come back to you with a report to say this is what we've learnt about the loss and the consequences of it?
Not to my knowledge, but again, it's some time ago, and we'll check the answer to your question.
Yeah, wouldn't you be interested to follow up? Wouldn't you be curious to know?
Certainly, from my perspective, the minute we found out about this, it was referred to what I understand were all the relevant and required agencies within government, and all action in response to that was taken. That is my recollection. It is some time ago. It was obviously in my previous portfolio, so we'll check all those details and come back on notice.
And you don't know the classification of the documents, but do you know generally what they referred to, what they related to?
I remember the matters, but without obviously going into matters that have been considered by Cabinet. It was a matter that was to be discussed in Cabinet that I was the lead minister on when I returned from overseas.
Did it relate to national security in any way?
I've already said it didn't.
Right.
Senator Patterson, I have to share the call.
Okay, just one last question, if that's okay, Chair. Why was it necessary to take the documents overseas?
I'm just trying to be a bit careful about what I say, given we're talking about Cabinet matters, but it related to a submission that I was bringing to Cabinet, I think on my arrival back from overseas, and to meet clearance processes within government, I needed to approve the submission. Okay. And this was the only way to meet those timelines.
Okay.
That's my recollection.
Thank you, Chair.
Senator Patterson. Senator Shoebridge, you have the call.
Oh, thanks, Chair. Secretary, do you agree that you would like a culture inside Home Affairs where corrupt behaviour is reported?
I do, Senator.
Do you know what the survey said about your results in that regard?
Senator, if you can direct me to the page, I think it's page 19. So we had a small percentage increase of people who said that they had witnessed behaviour, and a small decrease in those who said that they had reported it, offset by the number of people who suggested it was reported by someone else.
That's your key takeaway from that page, is it, Secretary, what you just told me?
I was answering your question, Senator.
You see 58% of people who responded to your survey said that they did not report potentially corrupt behaviour. 58%.
And you'll see, Senator, that that's only slightly below the extra large agencies with whom we correspond. It is absolutely something that we continue to work on, and it's not an acceptable result, and we will continue to promote reporting of and creating a safe environment in which people can report that.
It's at least 5% less than the comparators across the APS. It's 3% less than comparable large agency, than large operational agencies. It's more than half of the people who witness corruption in your organisation don't report it. Do you think that's a problem?
So, Senator, I think whilst we look at all of the comparable metrics, the most relevant in terms of our size is the extra large sized agencies. Absolutely, I don't want that gap there, and I don't want 58% of people saying that they didn't report the behaviour.
Have you asked why they didn't report corrupt behaviour that they saw?
So, Senator, we are currently in the process of engaging across the organisation at a whatever size team makes the most sense, and asking people what we can do to create an environment in which they feel more comfortable. But as I said before, there are a range of things that we are doing across the organisation to try and tackle this and other relevant issues. Ms Tressler might take you through some of the things we're doing specifically around corruption.
If it relates to my question, did you ask them about why they didn't report corrupt behaviour? I'm happy for Ms Tressler to answer if it relates to my question.
So indeed, just last week, the Secretary asked each of us in our Senior Leadership Committee forum to ensure that we were personally going through each of our results and identifying where there were hotspots and having those conversations. We are working through a process to better understand, because as you know, it'll be different in different areas of the department, to understand what our staff are telling us in terms of problematic behaviours and how we can improve that. But we have been implementing a range of improvements in alignment with our integrity culture refresh, including the establishment of what we call a fusion hub, which actually is providing a one-stop place where staff can actually bring their problematic behaviours or complaints that they have. One of the issues that we believe we've had in the past is staff not knowing where to bring their complaints, and we are actively looking to change that through a range of activities in that space.
Secretary, were you aware that the survey indicated that 58% of your staff didn't report corrupt behaviour they saw before I raised it with you?
Yes, Senator, as I've said to you before, I have been through this data for hours and hours, including in sessions with my senior leadership team, with analysts who have not only looked at the information that's in front of us, but have tried to unpack the drivers for it. And we are working both at a whole of department level on the response plan to this. But as I say to my staff, at all of the monthly webinars, each time I visit the regional offices, the thing that really matters is unpacking this at a team level and making sure that we're dealing with it, as Ms Tressler said, in the context in which people are working, and making sure that we understand what the issues are at a local level so that we can support people to fix them.
Well, you see, your staff aren't telling you that it's fixable at a local level. They're telling you the problems are cronyism and nepotism in senior management. That's what this page tells you. That's not going to be fixed at a team level. You've got a problem of cronyism and nepotism in your organisation that this page of the report makes clear. That's not going to be fixed at a team level. It's a senior management issue.
So, Senator, most of the recruitment activity actually takes place at a local level, and indeed it will often be a team leader or a junior SES officer who is responsible for recruitment. it's not helpful for us in many cases to try and genericise quite specific things. We need to get to where it's perceived to be happening, whether or not that perception is real, and what we can do to address the issues. Sometimes, as I said, there will be actions that we take which are department-wide. Sometimes there'll be things which are in each individual group or branch or team plan that will work on the things that are disturbing the most.
What are you doing to deal with the cronyism and nepotism that has been highlighted in these corruption responses in the survey?
So, Senator, Ms Tressler referred before to the refreshed approach we were taking to our integrity framework, and that has very much a focus on supporting people to do the right thing, and ensuring that everyone understands their responsibilities, that we are having open and active conversations about what's right and what's not right. It will, as I've said on a number of occasions, it will take time to drive cultural change in an organisation this big, but we are absolutely committed to doing so.
You see, Secretary, when I asked you about the corruption that was identified in this report, you referred to the fact that I think some 4% of survey respondents said that they had witnessed conduct that was they considered maybe serious enough to be viewed as corruption. Do you know how many people that actually represents?
I'm sure my crew can do the maths for me quickly, Senator.
It's more than 450.
Senator, that's because we're a large organisation.
That's because
if you look
there's a lot of it going
at the
on.
Statistics, it is a very small percentage variance above other agencies.
Secretary, not only did more than 450 of your staff say that they'd witnessed behaviour that they could consider maybe serious enough to be viewed as corruption, but more than 500 indicated that they weren't sure whether what they saw was serious enough to be viewed as corruption, and another 2% didn't feel safe to answer. That's well over 1,000 deeply problematic responses about corruption, isn't it?
So, Senator, any level of corruption in any organisation is unacceptable. That's why we measure it. I refer you back to the corresponding data for other agencies. Home Affairs is not significantly different from other agencies.
Secretary, you're not trying to minimise over 1,000 incidents which your staff reported in their survey where they either didn't feel confident in responding or did identify conduct serious enough to be viewed as corruption. You're not trying to minimise that in this exchange, are you?
Senator, there is nothing I have said today which could indicate any intent to minimise. I have said repeatedly, this is unacceptable and I am working really hard to tackle it.
Have you given a direct communication to your staff urging them to report potentially corrupt behaviour, noting that this survey found that almost 60% of them wouldn't do that?
So, Senator, both Ms Tressler and I have referred to the refreshed work we're doing around integrity culture, and there are a range of activities, including direct communication with staff that Ms Tressler's staff are prosecuting, which go to the heart of encouraging people to identify and speak up about corrupt or inappropriate behaviour.
But you see, that's not working, Secretary, is it? Because we started this whole line of questioning off about the fact that there's been a collapse in the number of people who are willing to report inappropriate conduct. That's fallen by more than 10%.
Sorry, Senator, draw your attention to the data period that this was from, which was back in April, and indeed Ms Foster only being Secretary since December last year. One of the very first priorities of Ms Foster was to indeed implement this integrity culture refresh that we have been leading since April, which you'll see is a similar time period. We are going to then see some time before these things actually take effect. It is obviously something that the Secretary takes very seriously. We all take very seriously, and we do want to see a shift in the results, as you are indicating.
Ms Tresler, the Secretary commenced in December of last year. And this census survey was conducted between May and June of this year. Am I wrong in that?
So, Senator, I actually commenced, I think my appointment was in late November, and looking at the integrity culture was one of the first pieces of work we picked up. So in the early part of this year, in fact, our integrity team came on an almost weekly basis to our senior leadership meeting, where we discussed as a senior leadership team how we were going to refresh the approach to integrity in the organisation. I just divert for one moment, Senator. Clearly the circumstances in which my predecessor left had an impact on the staff, and I thought it was incredibly important that we tackle issues around integrity head on. As Ms Tresler said, that work that we did with the senior leadership group came to fruition in around April.
We published the strategy in June, but well before then we were consulting with staff about the changes.
And so to see a change in the census results I think would not be realistic. But
there has been a change. From the previous Secretary, who I said before was hardly a shrinking violet, and I think you'd agree your leadership change is meant to produce some kind of positive response. It's got worse. People feel less confident to speak up and raise concerns about inappropriate behaviour under your leadership than former Secretary Pizzullo. You don't think you should reflect on that?
Senator, we are absolutely reflecting on that. We have a number of measures in place to make sure that we are encouraging and supporting people to speak. I also said that sometimes we can see anomalies in surveys, and I am not minimising that result. I'm simply saying that there are other results in the survey which will indicate positive progress in this regard.
You see, Secretary, if I was one of the 11,400 staff who'd reported this data to you, told you they didn't feel confident speaking up about inappropriate behaviour, told you that they didn't report potentially corrupt behaviour, I'd be troubled by you suggesting that these are data anomalies. Do you not realise what a bad message that sends to your staff?
Senator, I disagree with that characterisation. I said I am not minimising that result. I'm absolutely accepting it. I'm also conscious that it's not consistent with other data in the survey, and we need to take the survey as a whole, engage with our staff, tackle the issues it raises. We are absolutely committed to do that, and we will.
Thanks, Senator Shoebridge. Senator Patterson, cross-portfolio.
Yes. Thank you, Chair. I just want to place one question on notice in cross-portfolio, and then I'm ready to move to outcome one. And that question on notice, Ms Foster, is for any document or communication relating to the change in the headshots and the flags. So for the avoidance of doubt, emails, WhatsApp, Signal, text messages, memos, minutes, anything that you have that refers to that change.
Of course, Senator.
Thanks.
Thank you, Chair.
Senator Patterson. Senator Shoebridge, do you have questions for cross-portfolio? No. Okay, thank you. Well, that's all the questions we have for cross-portfolio corporate and general matters. Thank you to those officials. The committee will now welcome officials in relation to outcome one. I don't suspect there's too much of a change, so we might go straight into questions. Welcome. Thank you. Senator Patterson, you have the call.
Thank you, Chair. I want to return to those questions I flagged in cross-portfolio about the national strategy on counter-terrorism, if the relevant officials could come forward.
They're here, Senator.
Thank you. Okay, when did work commence on updating our national strategy on counter-terrorism?
So, Senator, I think the former minister first announced that at the end of 2022, and we have been working since then.
Right, thank you. Who is leading this work?
So it's being done out of our National Security and Resilience Group, which is headed by Mr Smythe.
Thank you. To date, which departments and agencies at the Commonwealth level have contributed to this?
Senator Nathan Smythe, Deputy Secretary of National Security and Resilience. I'll just go to my notes to go through all of the engagement that we've had in relation to the strategy.
While Mr Smythe is looking for the details, Senator, it's been extensive over that period.
It certainly has, Senator. The departments and agencies at the Commonwealth level that we've engaged have been the Australian Federal Police, the Australian Signals Directorate, the Australian Geospatial Intelligence Organisation, the Australian Security Intelligence Organisation, the Australian Transaction Reports and Analysis Centre, the Department of Foreign Affairs and Trade and agencies within that, the Attorney General's Department, obviously our portfolio across the entire portfolio, the Department of Infrastructure, the Safety Commissioner, the Office of Youth, the Office of National Intelligence, the Department of Defence, the Department of Health and the Department of Prime Minister and Cabinet.
Thank you. What about state and territory governments which have contributed to the work so far?
All state and territory governments have contributed to the work so far, Senator.
Could you provide me with this might need to be on notice, but a list of dates of your engagements with state and territory governments and the form of that engagement?
Sure, Senator. I'm happy to table when we did the formal consultation overview, but of course the strategy has been discussed at the Australian-New Zealand Counter-Terrorism Committee and its subgroups through that. But Queensland was on the 29th of July, the Northern Territory... The
29th of July this year.
This year.
Just let's pause on that for a second. I mean, Ms Foster said before this process commenced at the end of 2022. Why did it take 18 months before you engaged with the state and territory government?
I'm referring to when we were just in the final stages of finalising the current strategy arrangements. There was another round of formal consultation, but there were workshops, discussions that were held with all states and territories since the announcement by Minister O'Neill in late 2022, Senator.
Okay, so you provide those breakdowns on notice. So we can have a look at that then. Thank you. You said it was that you'd had final meetings in July. Does that mean that strategy is nearly ready?
Yes, Senator. Final is perhaps a too definitive a word. We are very well progressed with the strategy, Senator.
How far away is it?
So obviously its release will be a matter for government. We are working on some final elements in collaboration with state and territories because, as you know, they actually deliver a lot of the programs on our behalf.
Indeed.
I don't think it's too far away.
Because it's been underway for almost 2 years now. So one would hope that a strategy would be able to be turned around a little bit more quickly than 2 years. What's the reason it's taken so long?
So, Senator, there's been obviously a lot of evolution in the context over that 2 years, which is probably best illustrated by DG Burgess's revision of the terrorism rating this year. And so we have been working internally across the Commonwealth, but also with states and territories on how we respond and adapt to that changing environment. We absolutely have not been standing still while the strategy is being developed, and so we've been making sure that what we're doing over that period has been fit for purpose.
Sure, but I mean the terrorism threat environment is always evolving. Since 9/11, it changes with geopolitical events and technology trends and all those sort of things. It's not an excuse to say that it's an evolving environment, is it?
I wasn't proffering it as an excuse, Senator.
Well, I asked for why it's taking so long and you offered that as the explanation.
Senator Patterson, can I remind you that under the coalition government there were 2 counter-terrorism strategies in 10 years and one took 7 years to develop?
Okay. Are you familiar with the article by Jason Katsoukas in the Saturday paper on the 28th of September?
Yes, Senator.
Mr Katsoukas is a close observer of the Home Affairs portfolio. It was a pretty alarming article, wasn't it?
So, Senator, on its face value, it was indeed alarming. We were concerned at what Mr Katsoukas reported. So Mr Smythe and his staff went back out to states and territories to see if there were concerns that we were missing. I also took an opportunity to consult with the heads of the Premier's Department in each state and territory, or the Chief Minister's Department, in a forum which Secretary Davis runs regularly. Secretary Davis asked each state and territory explicitly if they held concerns, and they said no, nobody raised a concern, and in fact the New South Wales participant who co-chairs the ANZ CTC that Mr Smythe spoke about before said that states and territories were as bemused at the article as we were.
So where do you think that it came from then? I mean, as I said, Mr Katsoukas is not an ill-informed observer of this portfolio and these matters. He has a number of off-the-record sources. He's talking detail about the haphazard and flawed process in developing the strategy and concerns states and territories held. Presumably he didn't just make it up.
Senator, I'm not in a position to understand where Mr Katsoukas was taking his information. What I can assure you is that we have spoken to the very states and territories that he referred to. None of them has indicated a problem. In fact, all of them have indicated that as we make the final tweaks, they're happy to support the strategy.
Well, I hope the article assisted in making sure that was the case. And were there any issues at all with the states and territories? Any disagreements about the counter-terrorism strategy?
So, Senator, there is always a healthy debate about what should be done, what the responses should be, but there has been nothing of a nature that would support the assertions made in that article. And in fact, as I said, the state's response was they were as bewildered as we at where it came from.
Well, what were those areas of disagreement that you referred to?
Senator, I didn't say disagreement. I said there was always...
I think you said healthy debate.
Healthy
what were the
debate.
areas of debate?
Well, I would say that it's more of an emphasis issue in the documents around issues of violent extremism, online issues, radicalisation, etc. But there was no disagreement in relation to what was actually coming forward. Each state and territory has slightly different populations that they have. They have slightly different offenders that are within their system, people that are on particular programs, etc. So it was more subtle nuance around some of the wording, Senator.
Well, can you be a bit more specific than that? What were the areas of subtle nuance or emphasis that were different between the states and territories and the Commonwealth?
Senator, we are still in the final stages of finalising the strategy, so I don't think it would be appropriate for me to go into all of the details at this particular point in time.
Why not?
Senator, I think the sorts of things that we discussed that Mr Smythe takes up with his counterparts will go to what emphasis we should place on differing aspects of programs, for example. So states and territories clearly have the front running in dealing with their communities and with people who are subject to radicalisation, and they each have different experiences. And so it's that, what I said, healthy debate about what things are going to make the most difference that everyone contributed to in a really constructive way.
Yeah, I understand that, but I'd be helpful if you could drill down a bit more on what those different areas were, or different focuses were, or different emphasis was. You know, for example, Victoria. In what way did Victoria seek a different emphasis or focus?
Senator, I don't have the specifics of each of those conversations, but in the broad, the ones that I actually have with the jurisdictions related to national versus state level programs, and whether there might be the opportunity to move a well-performing state-level program into a national context, etc.
Can you give me an example of a program?
There will be announcements that go to the strategy that will be delivered by government when it chooses to release the strategy.
But Senator, in the broad, states have different approaches, for example, to how they provide access to parents and families. And some states have more comprehensive programs than others. And so part of the discussions were, would it make sense to nationalise or to have a national approach to some of those things, or are the differences, do they warrant different approaches in different states?
So presumably that's access of family members to detained
No, sorry.
people?
What I meant was places that people can go to seek support, for example, when they're worried about their children or people they know being radicalised.
Right. So de-radicalisation programs, right? Any other areas where there are any differences?
And I think, Senator, I know that it sounds like I'm passing words, but I was talking about healthy debate about what works best rather than differences or disagreements.
I'm not seeking to put words in your mouth, Ms Foster. You can characterise it however you choose. I'm just interested in elucidating what that was.
And so that's one area that I know of where there were different approaches.
Were there any others?
Sure. So, Senator Alexander Goldie, Acting First Assistant Secretary of the Counter-Terrorism Coordination Centre. One of the things that we discussed with jurisdictions in our consultation was the impact of geography. So obviously the difference between our states and territories and the realities of their physical space that they administer has changes to their operational implementation. Queensland, West Australia, Northern Territory all have very large jurisdictions, and that makes impacts on their allocation of resources across those jurisdictions, and that has an implication for the kinds of programs and supports that we offer to them and how they implement them versus more condensed states that have perhaps more experience in metropolitan environments.
Sure.
One of the other things that we discussed was, as the Secretary outlined, in our disengagement programs, there is some implementation differences between states and territories and who provides the services. So whether that be delivered by a Department of Communities and Justice or Corrections or a police force or otherwise, that can vary in jurisdictions, and that changes how we message and also the allocation of resources.
Following the publication of this article, did you brief the Minister for Home Affairs on this issue?
We certainly had discussions with the Minister, Senator, and I know that I advised him, I can't remember if it was before or after the fact, but that I was engaging with states and territories at the most senior level because I was concerned to understand what, if anything, was behind it.
So did the Minister or his office request a brief after the article was published?
Senator, I don't recall. Can I take that on notice?
Yeah, please do, because I would have thought, this article is published by someone who follows these things closely, that the counter-terrorism strategy is completely off track. Would have thought the first thing the Minister would do is ask you for a brief as to whether or not that's the case.
So this, I'm just recalling the discussions that we had after the article. Minister Burke was indeed concerned. He raised it with me in a meeting shortly after the article was published.
How long after?
Oh, Senator, it was around the same time as the article.
Why don't you take that on notice so you can be specific?
I may not be able to pinpoint the day, Senator, because we talk very regularly.
Sure, but I mean, you can look at your meetings with the Minister. Presumably that some kind of minutes or notes are taken of those meetings.
Senator, sometimes they cover a broad range of issues, and I'm not trying to prevaricate. I'm just saying I will seek that. I'm not sure I'll find a particular date.
Patterson, I have to share the call.
Thank you. Just one last. Yeah, thank you. At any point, if you brief the Attorney General on these matters or his office?
Certainly we haven't briefed the Attorney General or his office. I don't know what's happened office to office level, Senator.
Okay. All right. Thank you, Chair.
Thanks, Senator Patterson. Senator Polly.
Chair, I just want to just make it very clear in relation to Senator Patterson's line of questioning that there is no issue between the Commonwealth Government and the states, and that the article did not accurately describe the relationship between the tiers of government in this area.
That's correct, Senator. And, you know, I did a final check, as I described to Senator Patterson, by going to the policy, you know, the head of each state and territory. But in fact, Mr. Smythe and his staff had called their counterparts at an operational level as well, just to see were we missing something, because we thought we were on a very good trajectory with states and territories, and that article came out of the blue. All of our feedback indicated that there was some confusion that led to its publication, but we could find no evidence to support it.
So can I ask then what the Counter-Terrorism Coordinator Centre's priorities are and what their key focuses have been up until now?
Certainly, I'll get Mr. Smythe to take you through that, and Mr. Goldie.
Sure. So, Senator, my role as the Commonwealth Counter-Terrorism Coordinator is to provide national leadership and coordination on national strategies, policies, plans related to advice across government in relation to counter-terrorism, to look at national approaches to programs to counter violent extremism, which is a key concern of ours, national counter-terrorism capability development as well, and then the identification and management of emerging counter-terrorism risks, which really does require us to work extensively across intelligence, law enforcement, security and police organisations. And that also goes to international context as well, with our international security dialogues, talking to counterparts across the Five Eyes and broader as well. And the role is effectively formalised through three key governance arrangements. The first is that I chair the Australia-New Zealand Counter-Terrorism Committee alongside New South Wales at the moment. That is a rotating chair on part of one of the Premier State and Territory Premier departments. I also chair the Capability Steering Group that sits under the ANZ CTC. I then chair the Joint Counter-Terrorism Board, which is effectively a board of all of the agencies in the Commonwealth that have an equity or a role in counter-terrorism from an operational point of view as well. So that includes ASIO, AFP, the Department of Foreign Affairs, etc. And then I also lead the Commonwealth senior officials for domestic terrorism incidents under the newly re-released Australian Government Crisis Management Framework.
Thank you. If I can, I'd just like to move on to the cyber security legislation that was introduced into Parliament in October, and I just want to know what consultation had taken place prior to that being introduced, and also was there any findings around or anything that perhaps you weren't expecting the interaction between private enterprise and the impact that cybersecurity is having on them?
Thanks very much, Senator. Hamish Hansford, Deputy Secretary, Cyber and Infrastructure Security. So the consultation for the cybersecurity legislative reforms actually began back in February of 2023 in the context of consideration of the cyber strategy. A number of policy propositions were put out to the Australian people, everything from broad policy questions about should Australia actually ban the payment of ransom, right through to what would the appropriate settings on critical infrastructure policy be. So quite a broad consultation. That was then narrowed down, and ultimately the government produced the cyber strategy and released it publicly in November of 23. On the 19th of December 2023, the government then released a consultation package on the Australian Cybersecurity Strategy legislative reforms consultation paper, And throughout January, a number of town halls were held by a range of Home Affairs staff. A number of roundtables actually were also held in February, and a number of bilateral meetings. I can't tell you how many meetings there has been. Running alongside that was also our SOCI-related Security of Critical Infrastructure Act-related town halls, so lots of consultation and lots of engagement and roundtables. The government then approved the legislative package, and we developed, sometimes in the case of the telecommunications industry, co-designed, I'd argue, the legislative package, and then ultimately consulted in a targeted way, given we'd had a lot of people engage with the process, with the actual legislation and the exposure draft package prior to its introduction into the Australian Parliament. And so quite a lot of consultation and engagement. I think on your question about what did we learn, there was a range of different views and input by industry that we did pick up and try and make sure that we got the consensus of industry and other stakeholders to make sure that we listened, we actively co-designed, and then responded and put forward legislation through actually trying to get the balance of issues put forward in the hundreds of consultations, and so that ultimately is the package that's before the Parliament and before the consideration of the Parliamentary Joint Committee on Intelligence and Security at the moment. And we did make changes, just to take one example, to how we categorise legal professional privilege from the exposure draft legislation right through to the legislation that was presented to the Parliament.
Thank you for that. The Australian Signals Directorate has been very clear that in relation to how important this legislation is. How do you characterise its importance and why this legislation is so critical for the national security?
Thanks, Senator. Mr. Anstey and Mr. Bell, I'm sure, might have things to add, but I think it depends on the lens in which you come to the legislation. If you're thinking about crisis management, the consequence management direction power to be used as a last resort is particularly important to make sure that the Australian economy and the Australian government has all the powers needed in a last resort scenario if there's some sort of major incident in the Australian economy. If you're the National Cybersecurity Coordinator, and the Lieutenant General might have views as well, the limited use provisions protecting people's information for early engagement with the National Cybersecurity Coordinator or the Australian Signals Directorate is an area of particular focus and priority. If you're an average consumer in the Australian economy, relying on secure Internet of Things products, everything from baby monitors to internet-connected fridges, actually having the baseline cybersecurity settings in the Australian economy might be an area of particular importance. If you're looking at an area of ransomware reporting, trying to get to a sense about what the quantum of payments on ransomware and extortion in the Australian economy is, then that might be particularly important to look at the impact that is having on the Australian economy. So I think can put a range of different lenses as to the importance of the legislation, but Coordinator?
Senator Lieutenant General Michelle McGuinness, National Cybersecurity Coordinator. This is a really important next step in implementing the strategy. We're halfway through Horizon 1 of the strategy, and this really speaks to the ambitious goal set in that strategy of being a world leader in cybersecurity by 2030. Mr Hansford has outlined how this affects the economy. Ransomware continues to affect large sectors of our economy, from small to medium businesses. The vulnerabilities are constantly found in our Internet of Things devices, so this really does harden us and move us closer to that goal.
I might add to that as well, Senator Peter Anstey, First Assistant Secretary, Cyber and Technology Security Policy. Another element that the legislative package provides is, for the first time, we'll have a centralised framework for cybersecurity reform in Australia. So subject to its passage, we will have a Cybersecurity Act. And what this means is, along with the specific measures that the Coordinator and Mr Hansford outlined, it will provide a reference point where we can build further cybersecurity reform in future years, such that future governments are minded to do that.
Thank you for that. In relation to ransomware reporting obligations, do you think this is going to have an impost on industry?
Mr Anstey or Mr Bell might like to comment on that.
Thank you for your question, Senator. Ashley Bell, Assistant Secretary for Cyber Policy and Programs. Senator, ransomware reporting obligation, in the policy development for that measure, we have done extensive consultation with industry. The key tension or policy tension here is around balancing the need to get a good sense of ransomware payments made across the economy, with, of course, not adding to the reporting load for small businesses, businesses operating critical infrastructure and others. So what we've sought to do within the calibration, and particularly as Mr Hansford mentioned before in response to consultation, is look to change the policy parameters for the reporting regime. So in our initial consultation framework, we had looked at potentially a two-step reporting requirement, where that would be where the attack was made and then the ransom demand was made, and then the payment was made. Following consultation with industry, we have made changes to the legislation to just apply to payments, thus reducing the reporting load. The threshold to which the reporting requirements would apply, that is a matter for the rules to be determined. But as per the evidence we provided on Friday at the Parliamentary Joint Committee, this is something where we have provided, I guess, an indication of where we think that threshold might be best set. There was a range of views, so some had suggested the original threshold that we put forward was around $10 million, and I think the projection we put forward was around a threshold of $3 million, which aligns also with the framework for reporting under the Privacy Act. That will, of course, be, should the bill pass, subject to further consultation with industry. It is around getting that balance right between a good coverage of entities and potential ransom payments, and obviously reducing the burden on businesses.
And just to tease that out, Senator, so as Mr Bell testified, the threshold is for businesses. The proposed rule that we put forward to the committee is that businesses with a revenue of over $3 million Australian dollars would be required to declare if they have made a ransom payment. That accounts for about 6.5% of all Australian businesses. I think that's right. So in terms of the burden on industry, it will only be those businesses that declare. So it's a sort of very small number of businesses actually will be required to comply with the obligation, and we're confident following consultation that that won't be overly burdensome.
Thank you. Can someone explain to the committee the term limited use as it relates to this package and what that actually does and why it's important, and perhaps to clarify what it doesn't do?
Yeah, thanks, Senator. I'll take that at the start. Lieutenant General McGuinness, National Cybersecurity Coordinator. The limited use applies to the information that's provided to myself and the Australian Cybersecurity Centre at the outset of an incident. It's designed to increase trust and transparency for an entity undergoing an incident. We consider them in that stage as to be a victim entity, and to allow them to confidently engage with the right amount of detail for, in my case, in my team's case, the ability to rapidly and efficiently recognise the equities and the second, third, fourth order consequences and minimise harm across the Australian economy. And for the Australian Cybersecurity Centre, that's more of a technical remediation focus.
Senator, I might add that what we're trying to do here in 2022, we introduced a mandatory cyber incident reporting obligation, which is a regulatory obligation. And so when people formally report, particularly critical infrastructure, and there's other reporting regimes across the Commonwealth, it's a formal legal report. So companies obviously want to make sure that that's right. What we're trying to do is divorce that concept with early intelligence and insight that might be wrong, early information. And so we're trying to create this regime called limited use to inspire people to report early in terms of what's going on, so that the proverbial cyber fire truck can respond to an incident given the interplay between government and industry, and that response can be unfettered, if you like, or fettered within the legislation, so that people can actually actively come forward to the government to resolve an incident, as opposed to the formal legislative obligations in terms of regulatory obligations as well. So we are trying to divorce those two concepts as a matter of principle and policy.
I have one final question in this bracket. How does the Cyber Incident Review Board in this package compare to the United States equivalent, and what did we learn from the US, and why do you think the model is actually a preferred model that we've adopted?
Senator, we've certainly engaged closely with US and other partners on this, and we've taken what we think is the best from it. It is modelled off the Cyber Safety Review Board. I'll hand over, I think, to Mr Hansford on his team who works through the details.
Thanks so much, Senator. And we have, I think we've almost spoken to every single Cyber Safety Review Board member and gained a lot of insight to inform the model. I think the first observation is that it's a lot of work, particularly for the industry members on the Cyber Safety Review Board. And so that's why the model that the government's put forward really has an expert arrangement where individuals from industry can surge into individual inquiries, with a core of the board being APS employees, to maintain the corporate history, the common focus from the government on both the administration of the board but also the deployment of powers such as information gathering powers, and then to be able to bring industry in and arguably a much more diverse range of industry that's inquiry specific. So if you take a particular example about the healthcare industry and an inquiry about a whole of economy incident that has happened in the health sector, you'd want a different complexion of industry members to support that quite technical area of understanding and expertise, as opposed to expecting industry to be across a broad range of issues and to tailor that to that particular inquiry, and to be able to draw on a much broader range of industry partners. So really I think that's the key conceptual difference. But Mr Anstey and Mr Bell, would you like to add any points?
That's right, Mr Hansford. Senator, there was extensive engagement, as has been covered, with the US system. They were sort of one of the leading jurisdictions to set up this kind of review board in the first place. So we've taken a lot of learnings and guidance from them. There were sort of really three principles that I think came out from those engagements. The first is around composition of the board, so the blend of private industry and government members on the board, and how to manage the interaction and advice that derives from those members. And certainly, as Mr Hansford just covered, we've been informed strongly by their learnings. The second is on the nature of the incident that the board contemplates. So the US system has undertaken, I think, 3 or 4 reviews to date of major systemic cybersecurity incidents. 2 jump to mind: the Log4j incident that I think we've discussed in previous testimony, as well as a recent major Microsoft breach. In the construction of the policy parameters around the Australian board that's currently in the proposed legislation, we've looked not to duplicate the kind of incidents that the US board would look to examine, so make sure that they're specific to the Australian context and the interest of Australian citizens and organisations that would be informed from the learnings of the review board. And the final area I think we've learnt from is the context of the advice that the board will provide. So we've deliberately made sure that it's a sort of no liability advice. We're not seeking to point fault necessarily with the nature of the incidents, but really to sort of lift all boats with the kind of advice that will derive from the board, such that we can prevent future similar incidents occurring.
And if I could add to that, I think in consultation with industry, speaking with one Australian business, they found the use of the CSRB reports to be quite helpful for their own system. So while it's not necessarily going to be a technical issue that perhaps draws their attention, it could go to things like corporate governance, it could go to broader policy issues. So I think one of the things that, looking at the CSRB model, we were looking to emulate is around that broad review of issues, not just the technical nature. And so to Mr Hansford's point before, that's why within the structure of what was proposed, we want to ensure there's a wide selection of experts that can inform that. And it could be that relates more to competition law or to corporate governance than it does necessarily to a technical element, noting the wide nature of cyber security threats and incidents.
Thank you.
Thanks very much, Senator Foley. Senator Patterson.
Thank you, Chair, and thank you, officers, for just answering again all the questions you already asked in the bill inquiry on this matter on Friday. Moving on to the 5-country ministerial meeting, where was that held this year?
Senator, that was in... the meeting between the 5 ministers was held virtually, and I'll get Ms Sharp to come and help me with that, and Mr Robinson.
Thank you. As you're coming to the table, Ms Sharp, where was it supposed to be held?
So, Senator, the meeting had been scheduled to be held in Sydney.
On what date?
I'm sure Mr Robinson can help us with the date.
Thank you, Senator. James Robinson, First Assistant Secretary, Strategic Policy Division.
Could you just lean a bit closer to the microphone? It's a bit hard to hear.
Excuse me, sorry.
You're
James Robinson, First Assistant Secretary, Strategic Policy Division.
And what were the dates it was supposed to be held in Sydney?
It was originally scheduled to be held on the 3rd to the 5th of September.
The 3rd to the 5th of September. And when was it held virtually?
On the 25th of September.
Right. How long has it been since Australia hosted in person one of these meetings?
The chairing of the 5-country ministerial rotates annually, so it would have been 4 years ago. We would have been originally scheduled to host.
I think it was, in fact, 2018. I think it was 6 years ago. I believe we held it on the Gold Coast then. How many people in Home Affairs were working on hosting this meeting?
I'd have to take the specifics on notice.
How big's your team?
I'd also have to take that on notice. There's a specific team that was responsible for the organisation, but we work across the entirety of Home Affairs to pull it together because it covers a range of different thematic leads.
So you don't know how many people were working on it?
It's varied over the course of the planning.
Was it 1 or 2? Was it half a dozen? Was it a dozen? Ballpark?
I think ballpark around about 7.
About 7 people were working on this. And how long would they have been working on hosting this meeting?
So as it transitions from year to year, we adopted the hosting of it probably at the beginning of the year when we received it, I think, from our New Zealand colleagues.
Roughly 7 Home Affairs departmental officials were working for a year on hosting this meeting in Sydney?
That's correct.
Yep. Why didn't it proceed in Sydney on the scheduled date?
Roughly half the ministers were unavailable to travel to Australia due to a range of different factors.
So, Senator, you recall that there was a change of government in the UK not long before that, and very shortly before the meeting was scheduled to be held, there was significant civil unrest in England. And so what we did was essentially repurpose the arrangements that had been put in place, and senior officials met, and so the agenda was prosecuted to the extent it could be by senior officials in Sydney, and then fed into the ministers when they had their online meeting a little later that year. So we did everything we could to take advantage of all the preparatory work that had been done.
When was the decision made to cancel the in-person meeting of the ministers?
It was somewhere between a week, 2 weeks before the meeting.
And I would also just add that the decision wasn't to cancel it, it was just to defer it.
Sure. Well, the in-person meeting was obviously cancelled, right? Sure. So presumably people's flights had to be cancelled and they were no longer travelling. So there weren't any other ministers or officials able to represent the ministers who couldn't be there?
Senator, those options were explored. I think our judgment was that the meetings are significantly enhanced by having the senior ministers around the table, and that if we could achieve that virtually, then that was the best outcome.
Is there a more important annual meeting with our international counterparts for the Minister for Home Affairs than this one?
Senator, I'd have to look at the range of meetings that the Minister participates in. That certainly is a very important meeting, but I should emphasise that the advice about transitioning from an in-person meeting to a virtual meeting with the principals was mine.
Okay. You said that about half of the ministers were not available. Given that there are 5, was it 2 or 3 who were not available?
It was 2 of the... So it was
in addition to the UK, who else was unavailable?
The US Senator.
Right. The US is a big system. They've got a lot of touch points on issues like this. They weren't able to send a different person?
Senator, they were able to send a different person, but and absolutely grateful to them for looking into their system and identifying someone. Again, it was my judgment that the level of official who was able to travel meant that it was more effective to have Minister meet with his counterpart.
So obviously the US was happy for the meeting to proceed and they were offered to send someone else instead of presumably Secretary Mayorkas. So really it was only the United Kingdom that couldn't send a relevant minister?
The United Kingdom could also have sent a substitute minister, Senator.
So they offered to send a substitute minister as well?
They did, Senator.
Right. So why could the meeting have not proceeded with the substitute ministers in person?
It could have, Senator. As I said, it was my judgment call and my advice to Minister Burke that the most effective mechanism for him to progress the very significant issues discussed at that meeting was to meet with the principals who had the most influence and impact in their systems.
So you don't have the exact date that the decision was made to cancel the meeting?
I'm sure we can find that for you, Senator.
Yep. Like now? Can we find that now? Surely that's not that hard.
I can find that, Senator.
Thank you. And particularly when the Canadian and New Zealand ministers were told, given that they were able to attend and intended to come, are there any limitations in holding these meetings by video conference?
No, Senator. We were able to use a classified system, so the discussions were free-ranging and at an appropriate level.
So it was a TS video conference?
I'll have to check the level of the conference, Senator. I just know that it was classified.
And you're confident that had that meeting been in Australia, would the ministers have been meeting in a skiff?
Senator, there were arrangements made to hold different parts of the meeting in different locations.
Were any elements of the meeting planned to be held in a skiff?
And one element of the meeting would have been in the skiff.
Okay. So a TS video conference is not as secure as meeting in a skiff, is it?
So Senator, there were no issues that ministers felt unable to discuss via...
That wasn't my question. My question was, a TS video conference is not as secure as meeting in a skiff, is it?
Senator, I'd have to seek advice from my physical security folks on that.
We wouldn't go to the expense of tens of millions of dollars of building skiffs all around the world and in Australia if they were equally secure as a video conference, would we?
Sorry, Senator. So top secret systems are held within a secure compartmented information facility, and they're across both Australia and 5 other countries.
Okay, so was this meeting held in a skiff, the video conference?
Our meeting was held at official, virtually.
Official, right, so it's not classified? Not even secret?
Sorry, Senator, I had thought it was held at a secret level.
That was the impression I got from your answer. Mr Robinson's shaking his head. That Hansard won't pick it up, so I'll put it on the record.
The meeting was held at official.
Right.
I'm sorry, Senator, I was mistaken.
So, Ms Foster, clearly the ministers could not have discussed really anything of any sensitivity at official levels.
So, Senator, my advice remains that ministers had an open and frank discussion and none of them indicated any constraint.
Well, why then, when it was planned to be in person, did you plan to hold some of the meetings in a skiff if everything they needed to be discussed could be discussed at an official level on a video conference?
So, Senator, some of the activities that we had planned for the face-to-face meeting involved briefings rather than being the direct subject of the discussions.
So presumably those briefings didn't take place?
Not if they were at a classified level, Senator.
No, not if they're only at official.
That's correct, Senator.
Just in plain terms, can someone explain what the official level of classification is?
Basically, it's able to be shared easily over open lines of communication.
So it's the least sensitive form of communication, right?
I think unofficial is actually technically the least
Good point. Good point. The second least. Right. So we're at the bottom of the tree in terms of sensitivity. You couldn't discuss any classified information at that level, could you?
You can convey a range of different things in veiled comments, and we rely a lot on
Mr.
veiled terms.
In veiled comments, right. So we're going to meet officially, which is not secure, and we're in veiled terms going to allude to classified information? Is that your advice to the Minister about how to protect classified information of the Australian Government?
No, it's not, but we also rely on a range of other conversations taking place concurrently between bureaucracies.
Let's do a thought exercise. Tell me how you'd share a classified piece of information with me in a veiled way that would be secure.
Senator, I think what Mr Robinson was trying to express was that we had had significant discussions amongst officials at more highly classified levels, which meant that ministers could conduct what was essentially a policy rather than an operations-based discussion at official level.
Okay, what classified information was referred to in a veiled way in this meeting?
So, Senator, the other thing that we often do is that we rely on exchange of previous pieces of information that are exchanged between our bureaucracies as well. So we're all operating on a common understanding. That doesn't
answer my question, though. What classified information was referred to in a veiled way at this insecure video conference meeting?
Senator, like I was trying to express, alluding to classified pieces of information at an official level is a common practice.
Right. Were you in the meeting?
I was.
Yeah. Did you take notes?
I did.
Are there minutes?
Yes.
Okay. So what classified information was referred to in this meeting?
I'd have to take that on notice, but like I said, I don't think that we communicated any classified information in the meeting itself.
Right, we just alluded to it.
Senator, as well, I have that information about when it was officially cancelled.
Thank you.
Yeah.
I think advice was formally provided to partners on the 20th of August.
The 20th of August. Okay. I'm not filled with confidence that either this meeting met its intended objectives, given that the secure conversations couldn't take place, or that indeed that ministers were given good advice about how to conduct a meeting internationally, referring to classified information on an insecure channel.
So, Senator, I think what Mr Robinson was trying to express, and correct me, Mr Robinson, if I'm putting words in your mouth, is that when the context is known and understood, it's possible to have a conversation without revealing any classified information.
Well, I hope anyone who was listening in on the meeting, who wasn't invited to participate in the meeting, as we know some of our friends seek to do, didn't understand the context either and couldn't pick up the inferences that were shared on that call. So is it still your evidence, Ms Foster, that this meeting fulfilled all of the objectives of a 5-country ministerial meeting would, had it been held in person, there was no difference?
Senator, I don't believe my evidence was that there was no difference. What I said was I thought that it was more important that ministers met as principals to come to a shared understanding of challenges and issues, if that had to be done virtually, than having representative ministers meet face-to-face.
I know we'll be about to go to the lunch break and we're short for time. So just on notice, could you provide to me where in the PSPF it says it is okay to refer to classified material in non-classified settings?
So, Senator, I think I corrected that point. No classified information was passed in the meeting.
Right. So it's not in the PSPF that you can refer to classified material in non-classified environments?
I'm sure the PSPF wouldn't say that, Senator, but
I would hope not.
That's not what happened.
Okay, good to know. Thank you, Chair.
Thanks, Senator Patterson. And Senator Patterson is correct. We are about to go to lunch. So the committee will suspend for lunch and return at 1 o'clock with outcome 1 continued. Senator Patterson? We're still in outcome 1.
And
thank you.
Senator, can I just quickly advise Senator Patterson that...
Sorry, we won't suspend yet. You've got a follow-up or...
Sorry, just an answer that our notes have been checked, and that the first discussion I had with Minister Burke around the Kutsukas article was in fact the following Monday. So the article was the 28th of September, and we met on the Monday, and that was one of the subjects that we discussed. I'm pretty confident that we also discussed it informally over the weekend, but Monday.
Okay, thank you. Thanks,
Thank
Chair.
you, Ms Foster. Now the committee will suspend. Thank you. Thank you, everyone. The committee will resume its hearing, and we are in outcome 1. Continuing with questions, to outcome 1. Senator Chandler, you have the call. I think the Minister will be with us very shortly, but I don't think your questions necessarily relate to what the Minister's realm of knowledge is, so we should be okay for a little bit. Thanks.
Thank you very much, Chair. I just have a couple of questions about foreign interference and then move on to the IRGC listing, which I know I've discussed with officials here previously. But firstly, at estimates earlier this year, I asked the Department of Foreign Affairs and Trade about the government's response to the Iranian ambassador's involvement with Australian universities and direct promotion of pro-Hamas student protests. And DFAT said at that point in time that that was a matter for the Department of Home Affairs. I was wondering if the department could provide me with an update on any follow-up that you've undertaken on those issues.
Senator, I don't have any particular updates in relation to those actions. Anything that would go towards discussions between DFAT and the ambassador is a matter for obviously the Department of Foreign Affairs and Trade. Anything that would go to potential operational matters as to whether or not acts of foreign interference or that kind of occurred would be a matter for operational agencies. But in general terms, I have had discussions with the University Foreign Interference Task Force about acts related to campus, I suppose, cohesion, and have certainly in those discussions with them emphasised the need to discuss with policing agencies if they feel that something may have been overstepped or that someone was looking to potentially incite particular issues. That's in a general agnostic term as to being country specific. So I've had those discussions, but I don't have any particular follow-up on the issue that you've raised.
Has the department directly warned universities against engaging with the Iranian ambassador and the embassy, given the regime's deliberate promotion of anti-Semitism and pro-Hamas and Hezbollah protests?
I have not had discussions to that effect, Senator.
Okay. On to another topic. Is the department aware of an organisation called the Ahlul Bayt World Assembly, which was established by the Iranian Supreme Leader Khamenei in 1990? The former Secretary-General of Hezbollah, Hassan Nasrallah, sat on the organisation's Supreme Council. Are you aware of this organisation and the extent of its presence in Australia?
I'm not, but and Mr Blackman's just indicated to me that he's not off the top of his head. Can we take that on notice and come back to you?
I'm wondering, actually, Senator Chandler...
Sorry, Ms Foster, I can't hear you.
I'm wondering, Senator Chandler, if that might be a question that you might get more information from ASIO on tonight, because it seems to me that questions about, for example, the extent of their presence in Australia go directly to ASIO's security role.
Okay. This organisation has been identified as being ostensibly set up to promote Iran's revolutionary ideology overseas, but has also served as an effective cover for assisting with intelligence gathering, spotting and recruiting foreign students, and moving money and material destined for Quds Force and MIS operations. What advice would the department and the Counter Foreign Interference Task Force provide to other agencies or even ministerial officers about being alert to approaches by an organisation such as this or people connected to it?
So the Counter Foreign Interference Task Force is led by ASIO and the AFP. That would be obviously a matter for them to discuss at the operational level together with the other agencies that comprise that entity. When it comes to acts of foreign interference, manipulation, coercion, we discuss with a broad range of communities across Australia the opportunity to obviously inform government if they are worried about acts of coercion or foreign interference, where to report that to. If we do get any information that goes to the substance of a particular matter like that, we will refer it immediately to the Counter Foreign Interference Task Force.
Senator Chandler, Mr Smythe has also been undertaking a series of engagements with his ASIO counterpart, with senior executive teams in government agencies, for example, and he can speak much more eloquently to what he's doing. But that is about raising awareness and helping people know where to go when they are encountering activity of the kind that you're describing.
Yes, and I would say that countering foreign interference is a whole-of-nation endeavour, and particularly a whole-of-government endeavour to ensure that we harden all of our arrangements, environment to be resistant and resilient to foreign interference. It is one of the principal national security concerns, as Director General Burgess has mentioned on many occasions. So it's ensuring that we have a very coordinated, collaborative approach across the federal government, state and territory, but also with the community, the private sector through arrangements that Mr Hansford looks after as well, and industry as well as academia, where we are trying to ensure that we have hardened the environment and become more resilient to foreign interference, and that is an ongoing endeavour.
In May this year, according to media reports, Indian intelligence agencies identified that Al Ubaid World Assembly, which it noted has ties to the IRGC, Hamas and Hezbollah, has been actively recruiting for the purposes of spreading the IRI regime's ideology and conducting political, religious and economic warfare. From a national security and foreign interference perspective, do you agree that it's important for the Australian government to be aware of whether this group is operating in Australia?
Well, again, that would certainly be a matter for the operational agencies, ASIO and the AFP, and I think that they would be better placed to be able to answer your question, Senator.
Okay. The Al Ubaid World Assembly has close ties to the IRGC, a group which Home Affairs obviously has strong concerns about, given that you developed a nomination form and statement of reasons to list it as a terrorist organisation at the start of last year. What powers does the department have to act against an organisation in Australia which is providing support or cover to the IRGC?
Well, the criminal code vests the powers with the AFP to charge organisations or individuals who are breaching Australia's foreign interference laws.
Okay. Moving on to the IRGC proper now. In relation to the listing of the IRGC as a terrorist organisation, what is the Department of Home Affairs' understanding of why the IRGC has not been listed as a terror organisation by the Australian government?
So, Senator, I'm aware of the documents that have been kind of made available through FOIs. The view is that the IRGC is an organ of state, and therefore, under Australia's legislation, is not able to be listed as a terrorist organisation.
So it's a legislative barrier?
Well, I think that when it comes to issues as to whether or not an organ of state would be listed, that is certainly a matter for government, and I can really offer nothing further than what has actually been said, that in general, we do, as a general rule, we do not discuss whether or not we are considering for listing an organisation.
That's all right.
Until the organisation is listed.
It wasn't a trick question. You gave the response I expected you to. Thank you. According to previous answers given by the department, Home Affairs, as we know, began drafting a nomination form for the terror listing of the IRGC on the 20th of October 2022. The department proceeded to draft a statement of reasons document for the listing of the IRGC on the 11th of January 2023. The Department of Home Affairs has advised that you consulted with the Department of Foreign Affairs and Trade in the process of drafting both of those documents. Either in the process of drafting these documents or at any time subsequently, has the Department of Home Affairs been advised by any other part of government that it is not in the national interest to list the IRGC as a terrorist organisation?
Senator, the advice that we've received was that we were informed by the Attorney General's Department on the 30th of January 2023 that the IRGC cannot be listed as a terrorist organisation under the Criminal Code because it's an organ of the Iranian state.
And that is the only advice that has been provided to the Department of Home Affairs to justify not listing the IRGC as a terrorist organisation.
Senator, it goes to the broader issue that I raised earlier, that we don't comment on the specifics of the consideration of organisations that may be considered for listing. It goes to national security considerations. And I know that in relation to a number of orders for production of documents through the Senate that the attorney has claimed PII over those documents. So that's probably the limit of what I'm able to say.
That's all right. I just want to make sure that we're very clear here. As the department with the lead responsibility for counter-terrorism policy, you are not aware of any other reason that has been suggested to you by any other part of government as to why the IRGC shouldn't be listed as a terrorist organisation, other than the fact that the Attorney General's Department is of the view that it isn't possible under existing legislation.
Well, Senator, I would refer you back to my earlier response that it is long-standing government policy that we do not discuss organisations or the considerations that go into whether or not an organisation is to be listed as a terrorist organisation.
But the government hasn't progressed this listing, as we know. So I'm just trying to be crystal clear that the reasoning as to why that listing hasn't progressed is purely because the AGD is of the view that it isn't legislatively possible.
So, Senator, I think what Mr Smythe is saying is that he is unable to confirm the statement that you're making because he's unable to discuss reasons that are discussed around potential for listing and not.
Okay. The Senate committee report response to the Iran inquiry that I chaired, that is the reason or one of many reasons we're discussing this now. The government response to that said that the only reason for not listing the IRGC was the legislative issue. So I'm just trying to ascertain exactly what the reason is for not progressing that listing.
So, Senator, it's the government's prerogative to make a statement like that. That doesn't mean that Mr Smythe can speculate about that or other reasons.
Okay. That's all from me. Thank you, Chair.
Thank you very much, Senator Chandler. Senator Polly, do you have further questions?
I certainly do, if I can. Thank you. I just want to turn to the implementation of the cyber strategy and get an update as to where things are at the moment since our last round of estimates and the priorities you've had over the last 12 months, please.
I think Lieutenant General McGuinness will lead off.
Thank you, Senator. So the strategy is supplemented by an action plan for Horizon 1, which has 20 actions and 60 initiatives. They are being divided between 2023 and 2025 for that action plan. 38 initiatives are led by the department and 6 initiatives are co-led by the department with other agencies. 16 initiatives are led by other agencies. As at 30 October, 24 initiatives in the action plan have been delivered in full or are transitioned into a sustained work program that will extend beyond the life of Horizon 1. 19 of those are department-led or co-led initiatives and 5 are led by other agencies. The other 36 in the action plan have been progressed. That's where we stand at this point, which is close to halfway through the action plan. So we're pleased with the progress, that we're about halfway through that action plan and progressing through the initiatives as planned.
Could you tell the committee then, in relation to the government's commitment to developing a ransomware playbook, how that's going and what the purpose of that document is?
Yes, thank you, Senator. I might hand to my colleagues who drafted the playbook. The playbook was released a few weeks ago and available online.
Certainly, thanks so much. The ransomware, one of the key issues that we heard throughout the development of the strategy is there's lots of technical advice about what to do when there's a ransom attack or an exfiltration request. The missing piece, as outlined in the cyber strategy, was really around what are all of the elements in terms of a playbook that individuals and industry in particular can do to respond to ransomware. And that goes everything from communication, emotional response, right through to where do you go for advice, where do you report. So what we did in response is on the 11th of October, the government announced the ransomware playbook and its release, which is now available on cyber.gov.au. We actually briefed our international counterparts through the counter-ransomware initiative on the playbook, and I've got to say in the policy stream of the counter-ransomware initiative there was quite a lot of interest in the approach because it's an interactive playbook rather than a straight document, which again responds to some of the feedback about how do I go to the right places and get the right information. And so it is interactive, it is able to be navigated by individuals, and it really does provide what we are trying to achieve, a holistic resource for all of government to prepare, respond, recover and report. And really it's an approach to see, have we used a lens of behavioural economics to respond to industry concerns about information that's static and do it in a much more interactive way. And perhaps the final point from me is that Canada has set up a public-private partnership under the counter-ransomware initiative, one of the elements of which industry and governments will be looking at whether or not we can do some sort of global ransomware playbook under the counter-ransomware initiative.
Great. Can you elaborate for us or outline and describe to us the combined efforts between the cyber coordinator, the cyber strategy and now the proposed legislation? Where's that going to take us? Where we're at?
Well, thank you, Senator. You know, as the coordinator at a strategic level, my job really is to help harness, motivate and direct us all towards that goal of being a world-leading cyber nation. In more practical sense, the National Office of Cybersecurity, my office, we really focus on three functions. That is to prevent, prepare for and then respond to incidents. And the strategy drives those three functions and the legislation contributes greatly. In doing so, we're seeking to have all Australians uplifted, help them understand their own cybersecurity posture and how they can have a role in that. We're constantly strengthening our public-private partnership to capitalise on our respective strengths and help minimise the impact of cyber threats, particularly on small and medium businesses, which has been a key focus of Horizon 1. And also coordinating the government's response to major cyber incidences in support of the affected entity or the victim. Throughout the 9 months, I've been working with CEOs, IT professionals, boards, cybersecurity professionals across the nation, the government and with international partners on this technical and security challenge and as part of our journey that we need to overcome. I'd say of note, we've strengthened the public-private partnership. The Minister met with the Executive Cyber Council for the second time in August this year and continues to drive through that partnership absolutely genuine, transparent co-leadership of industry initiatives, including initiatives under the strategy. And we've also continued our National Cyber Exercise Program and made advances in that this year as well.
Thank you for that. I just wanted to get an overview from the department's perspective about what the Commonwealth Cyber Security Uplift is actually looking like now, what our key priorities are going forward, and those key priorities that have been actually achieved and accomplished.
Senator, I'll hand to our colleague, Mr Neil, on cyber uplift.
Thank you, Coordinator. Tim Neil, Assistant Secretary, Government Cyber and Protective Security. We're very pleased with the level of progress over cyber uplift over the past 6 months. We've had 7 direct interventions with agencies covering foreign ownership and control, individual exploitations, advice on individual procurers, and we've established the gateway policy. We've also, in July of 2024, issued 3 directions to accountable authorities of non-corporate Commonwealth entities covering foreign ownership and control, a stock take of all internet-facing endpoints, and excuse me, sorry, and a project with ASD to better use threat intelligence sharing. Over the past 12 months, we've also developed a robust government structure that allows effective management of cybersecurity issues. That's included the Protective Security Board, the Government Security Committee, the establishment of the Private Sector Cyber Forum, the Whole of Government Working Group on Zero Trust, the Whole of Government Working Group on Gateway, and Working Group on Clearance Issues. We've also, over the past 12 months, accelerated the hosting certification framework, which has included 24 assessments or certifications. We've scoped our first Systems of Government Significant pilot with the Australian Tax Office, and we've worked with the Digital Transformation Agency to provide guidance through cyber uplift procurement plans for accountable authorities.
Can you just explain a bit more about the current thinking around Zero Trust?
Sure. Zero Trust is a fundamental policy. It's a North Star for us. Zero Trust is the policy that allows us to take cybersecurity from its existing situation, which is a perimeter-based defence that is largely the bounds of cybersecurity and technology professionals, and move it into an organisational approach that is culture-based. We are embedding this Zero Trust culture through an extensive governance program. We have 15 partner agencies that we work with on a daily basis. We have an excellent relationship with ASD, who are our technical authority partners. That work has led to 5 guiding principles to embed Zero Trust culture, which are identify and manage cyber risk at an enterprise level, understand accountabilities and responsibilities at all levels, know your most critical and sensitive technology assets, maintain resiliency through a comprehensive cyber strategy and uplift plans, and go beyond incident planning, assume breach. We've seen some fantastic uptake within agencies across both their uplift plans and their submissions over the past several months on the basis of that engagement.
There's been some concerns expressed about reporting duplication in relation to the cybersecurity legislation. What's the government doing to address that? Is this been addressed in the strategy to date?
Senator, there is an initiative for a single reporting portal, and certainly as we progress the legislation, there's been strong consideration on balancing the regulatory burden with the security outcomes that we're seeking. That single portal is in phase 1 and developing, but the intent is that any entity reporting an incident can go to one place and report their incident, and the stakeholders who need to see that report, depending on the information that is selected in that performer, will receive that information.
We did just touch on that in some evidence this morning, but I just wanted to get a bit more clarity around some of the sensitive industries like hospitals and healthcare providers around the engagement and how we're developing this strategy in those areas, which are fairly sensitive.
Yeah, thanks, Senator. We certainly see the health sector to continue to be an attractive target for criminals given the rich data that they hold, and we are seeking to drive uplift. One of the initiatives is working on a national health exercise in order to drive that uplift as we collaborate across the health sector. I might hand to Mr Hansford for some other initiatives that are captured within the strategy that are being progressed.
Certainly, and one of the key ones is the development and continuation of the trusted information sharing networks, because there are a range of different sector-level groups that come together to talk about what best practice looks like. Even in the last week, the energy, liquid fuel and gas and electricity as part of the energy sector came together to really look at how they could work collectively to uplift their own security settings, and how do we work both across industry, across the industry. Equally, we've put a lot of effort into our Systems of National Significance Trusted Information Sharing Network, and having now 214 systems of national significance, this is a place where the most highly interdependent infrastructure in the country can collaborate. And it's been really heartening to see companies come forward who have suffered major incidents and actually collaborating on what they learned and how they shared this information so that we can prepare the most interconnected assets in the country for incident response. And a bit like the coordinator, we've also been engaging at the board level. Even this year, we're close to 20 board engagements about not only the threat, but how do we collaborate on response for each of those systems of national significance. And that's just at the critical infrastructure layer. If you take the collaboration in the cyber strategy, there's a whole range of different partnerships that we have. One of those actually is the Executive Cyber Council that the coordinator or deputy coordinator might like to comment on.
Very happy to chat. The Executive Cyber Council, as I mentioned earlier, convened for the second time in August this year under Minister Burke. That is a group of leaders from across the nation that are sharing and collaborating on cyber threats and best practice. It doesn't, at the board level, it's leaders, and it's a really strong message that we're sending that this is a leadership issue. Cybersecurity, if you're not addressing it in your corporate risk plans, at the leadership level, then you're missing the point here. Having said that, there are a range of working groups where cyber experts, be them CISOs, CIOs, technical experts, are actually convening around some of the major challenges and opportunities in the strategy, including our sovereign capability, our emerging technologies, our cyber workforce, and how to better support small and medium businesses. Very active community, and that working groups convene, one of them convenes almost each week since I've been in the job.
Thank you for that. So, in terms of the Trusted Information Sharing Network, how important is that and why is it so important? And in terms of critical infrastructure risk management program, can you make some comments in relation to where we've progressed in that area as well?
Certainly can, and I think we've put a lot of effort into our Trusted Information Sharing Network, and it really does reflect our administrative arrangement order, which goes to critical infrastructure protection coordination, not only as a regulator and a regulatory authority, but more as a collaborator and national coordinator of critical infrastructure. How do we use the government's convening power to bring industry together and share information? And our view underpinning that is that security isn't really an area for competition or competing, but it's actually an area where we can learn from each other because we're always striving for best practice. But Ms Grant and Ms Pfeiffer run those trusted information sharing networks. I might ask them to elaborate on specific details.
Sure. So the question was in relation to the risk management program, was it?
Yes.
Yeah. So Emily Grant, Assistant Secretary, Critical Infrastructure Security Branch. So the Critical Infrastructure Risk Management Program came into place last year, and we've been working collaboratively with all of our stakeholders in the Trusted Information Sharing Network to make them aware of their obligations under the Act. We have just over 2,000 participants in the TISN. That's up from about 600 12 months ago. Yeah.
I would just add that to Ms Grant's answer, Sally Pfeiffer, First Assistant Secretary, Critical Infrastructure, Partnerships and Policy, and also probably to enhance what Mr Hansford said as well, we work very hard with our TISNs, which are sector-based, as well as we have cross-sector collaboration. Our first position is to educate, inform, share information, work on lessons learnt, rather than look at it as a strict compliance regulatory regime. We're very keen in this early stage of the implementation of risk management plans and the other elements of the framework to really work with industry to make sure that we can collaborate and get that uplift that's required.
So can I ask then what the key issues within critical infrastructure, what are the key issues that need still to be addressed?
We're doing a lot of different work, mainly across the interdependencies between the different critical infrastructure groups. We have a resilience expert advisory group that sits alongside all of the TISNs that has 8 experts on it to provide advice to government and to also the Critical Infrastructure Advisory Council. So the Critical Infrastructure Advisory Council sits above the TISNs and has states and territories represented, as well as all of the chairs from the different TISNs. One of the most recent things that we've been looking at is the impact of copper theft and sabotage to critical infrastructure. So we've convened under Mr Hansford's leadership a cross-jurisdictional group to look at the impacts of those those crimes to critical infrastructure. There's also the more broad issues that are covered in the risk management program. So obviously cyber and information, the physical threats to critical infrastructure, personnel hazards. So making sure that people that have access to the critical components of the critical infrastructure are appropriately vetted to work on a particular aspect of the CI. And then we're also looking quite deeply into supply chains. So making sure that there's supply chain resilience across the critical infrastructure assets.
So I'm aware. Okay. I'm aware that the Executive Cyber Council has met recently. What's this organisation and their role in overall cyber strategy?
Yes, Senator. The ECC is that leadership body that's helping us to partner with industry and to get the best that industry brings. Government and industry each have their strengths. When we come together, I think it's the most powerful approach. They are committed to supporting us with industry initiatives for industry under the strategy. As I alluded to before, there are 4 working groups under that council that are driving options for strengthening small to medium businesses. They are looking specifically at emerging tech and looking at the lens in that working group as to how to review and adopt safe AI into businesses. For the sovereign capability working group, they're looking at enhancing sovereign capabilities within supply chains and looking at a showcase that we're looking to host next year. And then in the small and medium, in the cyber workforce working group, looking at how do we increase our pathways, strengthen our diversity across our cyber workforce and increase that workforce to meet the goals we need under the strategy. I think the power of the ECC is really that it's industry driving industry. So whilst on the actual ECC committee there are government officials, those working groups are purely industry led and driving solutions to share across partners and doing this because they can and because it's the right thing to do and because their obligation as large businesses across the Australian ecosystem.
I'll come back to some more questions.
Thank you, Senator Polley. Senator Patterson, we're coming back to you.
Thanks, Chair. Just a couple of quick follow-ups on a previous line of questioning, and then I'll move on to a new topic. Just on the cancelled in-person 5-country ministerial meeting, can you say which officials the UK and US government offered to send instead of the substantive ministers or secretaries?
Senator, I'll just get the relevant officers to the table.
Who did the UK and US propose to send instead of the relevant ministers and secretaries?
The UK proposed to send the secretary responsible for domestic security, Dan Jarvis, and the US was proposing to send a senior official of the department. I can get the proper details for you.
If you could, that'd be good. If it's to hand, that'd be helpful. While you're looking for that, it sounds to me, Secretary, like they were pretty senior substitutes available, and as you said before, the Canadian and New Zealanders were available. Was Tony Burke as Minister for Home Affairs available for this meeting?
Yes, he was, Senator.
Right.
And if I can just clarify, whilst the UK proposal was indeed the junior minister in that portfolio, I think the US official, and it's difficult because our systems are so different, was more akin to a departmental officer than a minister.
Right, so it wasn't a US Senate confirmed level official?
That's correct, a departmental equivalent. Adam Hunter.
Right, so what's Mr Hunter's position in the Department of Homeland Security?
I'll just get the actual details, sorry, Senator.
Thank you. While you're doing that, Ms Foster, were any costs incurred on the Australian side from cancelling the in-person meeting?
So, Senator, that's one of the reasons that we repurposed and used the venue and the facilities for the senior officials to meet to progress the agenda. I don't have a final breakdown. I'm sure my staff can help me, but I think we were able to absorb most of the costs in the repurposing of the meeting.
Okay. If there was any costs incurred as a result of the cancellation, you could provide that on notice. Who were the officials that did come in the end and participate?
I'll let the
Sure.
officers...
Happy to run through the list of officials that were able to participate. If just I can return quickly, the position of the US official that was proposed was the Deputy Assistant Secretary for Immigration Policy, and that official did attend alongside other officials from other countries.
Right, so correct me if I'm wrong, I'll be a bit rusty on this, but a Deputy Assistant Secretary is not a US Senate confirmed level official in the US system?
That's correct.
Right, so it's a professional public servant level, not a political appointee of any kind?
Correct.
Okay. All right, run through the officials for me who did attend.
I'll just pull up that detail, Senator, and come back to you.
Thanks.
Get my team to provide it. Otherwise, I can take it on notice. So the relevant heads of delegation that attended from a variety of different countries were Pip Swaney from New Zealand. Would you prefer their titles or their names?
Probably the titles are the most relevant.
So the Manager for Security and Intelligence Policy from the Department of Prime Minister and Cabinet from the from New Zealand. The Director of International Strategy, Engagement and Devolution from the UK Home Office. The Deputy Assistant Secretary for International Affairs from the US Department of Homeland Security, and the Senior Assistant Deputy Minister for Public Safety Canada. Actually, I don't think that last one is correct. Please let me just get the correct detail for that last.
I actually think it was my counterpart who came from Canada.
And would these officials have travelled in any event for this event with their ministerial representatives?
They would have, and their flights were already booked at the time we cancelled. Or deferred.
Well, any further notice, information you can provide on notice will be helpful. Thank you. Moving on to another topic. What are the potential national and cyber security risks of connected or smart vehicles?
Thanks, Senator. Like any connected vehicle in the Australian market, I think the analysis says by 2030, 95% of vehicles will be connected. And so you take the step back and think about the data that is acquired and potentially provided to people who manage and own connected vehicle manufacturers and the information that goes back. So that's kind of one area of potential cyber risk, more data acquisition and aggregation risk, I suppose, in one sense. Equally, the ability to change software may well provide some sort of risk if it's updated not in accordance with standards or in accordance with what the vehicle is intended to do. So a range of different cyber risks, both for people who connect their mobile devices into the car, for example, but also at the manufacturing and software level.
There's been media reports about the ability of some of these vehicles to listen in to conversations that occur in the vehicle because they have audio recording. Is that one of the risks?
Certainly is, and I think Choice also did a study of the range of vehicles in Australia and the data that is acquired, and we obviously are looking at connected vehicles more generally as well.
And some of these vehicles have external cameras and collect video footage of where they travel. Is that a relevant risk?
It could be, yes.
Including random passers-by or sensitive facilities or sensitive locations?
It could be, yes.
I note the Chinese government has banned some EV vehicles from their sensitive national security sites as a mitigation measure. Can you confirm that, to your knowledge?
Well, I've read reporting about that, yes.
And of course, the movement of these vehicles around our cities can be tracked as well. They can be, they have mapping software, for example, that can track their movements.
Yes.
And you said earlier, you alluded to ownership earlier. Are you suggesting that the country of origin where they're made and owned is a relevant consideration in the risk?
It may well be, but equally, if 95% of connected vehicles will be connected, there's a range of different both ownership and country of origin issues that would have to be navigated.
But for example, if it came from an authoritarian foreign country, which is Australia's #1 source of espionage, foreign interference and state-backed cyber attacks, that would be a relevant consideration?
It may be.
And the possible relationship between some of those companies and the foreign government from the country that they originate from would be a relevant factor?
It may be.
Yep. Our United States counterparts have taken some specific actions to mitigate against this risk. Is the Australian government considering doing any of those?
Senator, the Department of Home Affairs is looking at the security issues of connected vehicles. We have taken the opportunity, personally on the 20th of September, I met with a range of US agencies in the Department of Justice, Department of Commerce and in the White House about connected vehicles specifically, and Ms Ryan is talking to a range of different counterparts as well.
That's right. Britt Ryan, Assistant Secretary, Technology Security Policy. As Mr Hansford mentioned, we have been engaging closely with our US counterparts to understand the implications of the proposed regulations. So we've attended multilateral briefings and meetings with US counterparts on a number of occasions since the notice of proposed rulemaking was published on the 23rd of September. In particular, on the 2nd of October, we met with the US Department of Commerce and the US Department of Justice. And on the 8th of October 2024, we also attended a multilateral briefing which was convened by our US counterparts.
And in addition to the United States, my understanding that Canada and the European Union have flagged similar actions, not exactly the same as what the US has flagged. We discussed it with those partners.
I understand that we have been engaging with a range of different countries on some of the issues that are arising from connected vehicles, including Canada in particular, but I'll just confirm that for you in the briefing.
And just to clarify, Senator, the US has put out a notice of proposed rulemaking, so that legislation or regulation is not in force yet. The other jurisdictions you refer to, it's a mixture of economic interventions, tariffs in the case of the EU, as well as national security interventions in some jurisdictions. So it's
and the US has put forward tariffs as well.
Indeed, 100% tariffs, that's right.
What would the effect be if most or all of our like-minded partners took action on this issue, particularly in relation to Chinese manufactured EVs, and Australia took no action?
I think that's speculation on the nature of the action, Senator.
Well, if they're all putting up barriers or tariffs or other protections and we don't, surely Australia will become one of the dumping grounds for these vehicles.
Well, it depends, Senator. If different countries around the world take action, it may lift the international standards, and I know our Department of Infrastructure is looking very much on the international standards in relation to road vehicle safety, which also covers cyber. So it may well have an end result to lift cyber security and security standards across the world as well.
Right. Have you explained these risks to the Minister for Home Affairs and Cyber Security? Have you briefed him at any point on this issue?
Yes.
And on how many occasions we've briefed him on this?
More than one, Senator.
Multiple occasions.
We'd have to take the exact number on notice, Senator.
Thank you, if you could.
My memory is a couple of occasions, but we'll check.
If you could take that on notice and the date that it is. For obvious reasons, I won't name the make and model in this forum, but I've been told that the Minister, at least previously, as his personal vehicle, drives a Chinese electric vehicle. Does the Department have any knowledge of that?
I think that's a matter for the Minister.
Well, we just talked before about the national security risks posed by these vehicles. Perhaps the Minister's made different arrangements. Perhaps the information given to me is not correct. But you've said that some of the risks that these vehicles pose is that they can record the audio of the occupants who are driving around. Wouldn't it be of concern if the Minister's driving around in a listening device?
Well, I think there's a few assumptions in there that aren't necessarily borne out.
Well, if I can be corrected, I welcome that. If at any point the Minister has driven or owned a Chinese-made EV.
I'll see what information I can get for you.
Okay, I look forward to that. When you can provide it. Chair, that's sufficient questions for me in outcome one. I'm ready to move to outcome two.
Okay, great. Thank you. Senator Polly, did you have some to finish up on?
Yes, I do. Thank you very much. I just want to go back to learn a little more about the Executive Cyber Council. I was just wondering, in terms of I understand that there are cyber sanctions, and I Just wondered if you could inform us about whether there's been any imposed on any individual, and whether they, if there were, did they relate to cybercrime, and if you can outline the sort of sanctions that would be applied.
Thank you, Senator. Look, as outlined in the 2023-2030 Australian Cybersecurity Strategy, Australia will employ all arms of statecraft to deter and respond malicious actors. We have had a range of attributions and sanctions and technical advisories presented this year, and I would like to hand over to my Deputy, Mr Chapman, to discuss them.
Thank you, Senator. Tony Chapman, Deputy National Cybersecurity Coordinator. Pleasingly, by May of this year, Australia had participated in more deterrence responses than the whole of 2023. This comprises of 7 technical advisories with attribution, 1 statement of support, 2 amplifications and 3 sanctions.
So in terms of, can you outline to us, in terms of a sanction, what does that actually mean?
Thank you, Senator. As the coordinator outlined, this includes a very small team within the National Office of Cybersecurity, working across Commonwealth agencies, together with our international partners, to take action to impose costs on individuals, including calling out instances where states act to undermine or breach international laws and norms, and imposing sanctions where we have sufficient evidence and it is in the national interest to do so.
Would you be able to outline to us, there's obviously, cybercrime has no barriers, there's no borders, it's impacting on the Australian economy, so can you outline to us the various initiatives by the Australian government to combat cybercrime? What sort of offences have been undertaken, and how are we working with our international partners?
Well, thank you, Senator. In terms of combating cybercrime, our colleagues in the Australian Federal Police have a key role, as well as the Australian Cybersecurity Centre partnering with the Federal Police under Opaquila. The Australian Federal Police participate with my team and I in every incident that we seek to manage, every coordination meeting. They're there. I get regular briefs from the Australian Federal Police, and I actually have a liaison officer in my office. In terms of combating cybercrime, it's multi-layered and multi-tiered. Like the strategy, it starts with uplifting, as a nation, individuals and businesses to be alert to and more resilient to bouncing back to incidences, all the way through to the deterrent and attributions framework that Mr Chapman has outlined. This year we have applied under our new sanctions framework 3 sanctions that have sanctioned 5 individuals, which has financial and travel impacts on those individuals. We continue to, the legislation, for example, is also a contributor to combating cybercrime. Once we close vulnerabilities and continue to lift standards of Internet of Things devices, then that's another vulnerability that we close in uplifting the nation across IT, information systems, operating technology, and our own cybersecurity practices.
So what are the trends that you've seen since you last appeared before this committee, and what are you seeing in the way of a threat on the landscape at the moment?
Thanks, Senator. Since the last hearings, so from May until the 30th of September, my office and I have engaged specifically in 16 cybersecurity incidences. They have ranged from the health sector through to a range of small businesses. Some of them have been in the media, some of them haven't. Most of them revolve around data exfiltration, ransomware, encrypting the data. We are seeking to combat it through a range of initiatives, including general uplift, but also the playbooks that we're working on by sector to share across the economy. We're working with sectors to build those playbooks and constantly iterating on them. And as I mentioned earlier, we're running exercises. Exercises are super important, so the first time that we're actually dealing with a crisis, we're not understanding each other and figuring out what we each do. So exercises have been hugely impactful across the economy, but we're continuing to see those trends. The 2023-24 report from the cyber threat report from the Australian Cybersecurity Centre said that there is an incident reported every 6 minutes. I'm looking forward to the updated report later this year. I don't believe there's any indications that that would have gone down.
So can you tell...
Sorry, 2022-23 report. We're expecting the 2023-24 report soon.
Yeah. Can you outline to us what the key messages that you'd like to share with the Australian economy for uplifting their cyber security? Because governments can't do it on their own.
No, that's correct, Senator. Look, it might be useful to share some of the key lessons that I share across the economy over the last 8 months in supporting incidences. Some of the things, we've developed insights from our coordination and consequence management exercise program and also from supporting incidences. It's really important, I think, for companies to have understood the nature of incidences, including reviewing lessons learned and other information that's been proactively shared by victims. I think it's hard to understand the nature of an incident without hearing from victims, and often we do have entities speak across sectors about their incidences. Well, we've learnt that flexibility is critical. No incident that we've dealt with has been the same as any other. Understanding your stakeholders is really important. Quite often in an incident, data's not where it's supposed to be, connections aren't where they thought they were, and stakeholders who might suffer consequences need to be mapped. I think during an incident, it's really important to understand the classification of the incident, as in how significant it will be for people and the economy. Understanding all of your external stakeholders, all of your connected entities, and then also understanding that e-discovery, if you have had information that's been encrypted and taken, takes a very long time to understand what information has been taken. I think that it's very easy to be consumed by an incident, and once it's technically remediated and consequence management has been conducted, you can have very fatigued staff, and yet that staff should be preparing for a post-incident review and then sharing lessons with others so that across the economy we can drive uplift.
So the National Office of Cyber Security is still a very young organisation, and a lot of work has been achieved in the first 12 months. What's the priorities going forward for the next 12 months?
Oh, thank you, Senator. Pursuing Horizon 1 of the action plan there remains a key priority. We are a new organisation, and we continue to build our processes, build our training and our skills. I was delighted to have my deputy arrive just in July this year, so there has been some foundational building and we're expanding on those foundations. We're continuing to build our partnership across all sectors of the economy, focusing on those that are highest risk and require our greatest support in exercising and developing playbooks.
So in terms of your experience over this 12-month period, how would you describe the government's relationship with industry around cyber security?
Senator, I've been incredibly inspired, actually, on every level in my engagement with the public sector. I think indicative through both the Executive Cyber Council participation and the National Cyber Intel Partnership that I chair, we have an incredible private sector who are well-skilled, well-qualified and committed to uplifting the nation. Both of those forums are voluntary, and those folk are working, and I would estimate that participants in that working group would spend hours a week collaborating across sector with their peers to drive outcomes under the strategy. Mr Chapman, did you have anything further to add with private sector?
Thank you, General McGuinness. As the coordinator outlined, I've been in the role for 4 months. Since that time... An old hand already. Yes, 6 years previously with the New South Wales Government leading cybersecurity. In that 4 months, I've been really surprised by the calibre of the people within the National Office of Cybersecurity, together with our colleagues more broadly within the Department of Home Affairs, and really the breadth of the work that the small office is really undertaking as well.
It is quite incredible to think that all of this work has been done in the last 12 months. One surely must ask what happened in the previous decade, but trying to be positive and move on. I'd just like to learn a little bit more about CrowdStrike incident, how that unfolded, and what the government's role was in that and the agencies working together, and what lessons have come out from that experience.
Oh, thanks, Senator. I think it was a excellent exercise in coordination. On the day involved, a Friday, we started to receive calls, and indicative of the relationship we've established across the sector, I think we first received a call from one of our television networks who advised us they thought they were under cyber attack. Very quickly, utilising our networks, we were able to identify the extent of the incident and seek really to understand whether it was a cyber incident. Fairly rapidly, within the hour of actually the incident starting, we had insight that it was a technical issue through CrowdStrike, and I was able to speak with the Australian head of CrowdStrike, who's located here in Australia, who confirmed for me fairly quickly that it was a technical outage. By that time, I had contacted colleagues at the National Emergency Management Agency, NEMA, and sought to convene a government national coordination meeting. And once we learnt that it was not a cyber incident but a technical outage, I handed the management of that over to Mr Hansford, who maintains that strong threat information sharing network with critical infrastructure sectors. So I'll hand over to you.
Certainly, and for the last couple of years we've been maintaining and practicing what would happen during incidents, making sure that we've got the right people to quickly invite to a national coordination mechanism meeting, and that happened at 6 o'clock on that Friday quite quickly. And of the 17 different markets that CrowdStrike operates in, they've told us that we were one of the easiest, perhaps the easiest market to work with, given we could combine every state and territory government, local government and industry and the Australian government agencies together to get a situational briefing about what's happening, and then immediately communicate that to the Australian public, ultimately supporting Minister O'Neill's press conference the day after on Saturday. We held 7 or 8 national coordination mechanism meetings to try and troubleshoot issues, including one very specifically in relation to transport and logistics. Really, it showed us the opportunity to exercise what was a technical outage of, I think, only 1% of Microsoft systems globally. So you can imagine what an outage of something that was much more significant would be, and a really good testing ground for us to work out how do we communicate and how do we bring industry and governments together in the national interest. I think the formal after-action review is being undertaken at the moment by the National Emergency Management Agency, and we're working to work out how do we create a much more perfect response to the extent that that's possible.
In terms of that particular incident, can you outline to us what would have happened if we didn't have the coordination mechanisms already in place at that time?
Certainly, Senator. I think the biggest pressure would be a lack of information and confusion across the Australian economy, people trying to guess what had happened, whether or not, as General McGuinness said, we're under a cyber incident or attack. So actually the first thing is decluttering, understanding what was going on, and really importantly, I think, hearing from CrowdStrike about what were the remediations and how they might be able to be affected across the economy. It also allowed us as a government to understand where are the touch points in the economy that are disproportionately impacted. So one of the supermarkets in our country had over 20,000 systems impacted. Airlines were disproportionately impacted. And so there was pockets across the Australian economy, and we could help CrowdStrike prioritise response to the most impacted. And I think without that, there would be a fundamental confusion and actually a detrimental impact from the perspective of CrowdStrike that they can't prioritise their response. I think if you think forward to a large-scale or perhaps catastrophic incident in the Australian economy, that's where we may well have to think about, and who do you prioritise first, and how does the government be the arbiter of trying to make it much more seamless in what's potentially a congested and fluctuating environment, and you know the outlook is potentially very demure in the sense that that there's a lot of things that might happen in the economy. So the more well tested we are, and the ability to respond through practices and through incidents like this, I think, are very important.
I just offer that the other thing the coordination mechanism allowed was actually for industry to respond to industry gaps. Mr Hansford said that some sectors, some aspects of each sector were disproportionately affected, and we were able to communicate that in a way that wasn't about competing, it was about collaborating and preventing and mitigating the circumstances across the Australian economy, so that when one was disproportionately affected, others could pick up and identify how they could prevent Australians from not being able to access the services and items they needed.
Just, I get a sense I'm going to be closed down, so while I can, I just wanted to explore what's actually happening in relation to aviation and maritime transport around cybersecurity. We know there are already targets for other organised crime. I'm just wondering if there was any legislation in the pipeline. Are they, as they should be, a priority in terms of cybersecurity?
Certainly, Senator, thank you. And our International Civil Aviation Organisation, at least in the first half of 2023, saw that there was a 24% worldwide increase in cyber attacks in the transport sector, but generally in transport, we've seen major cyber incidents impact the port environment. We've seen a range of global threats, including, I might say, the global issues in relation to air cargo and the recent arrests in Poland, just to take examples. So an environment that is quite congested in terms of the risk landscape. And in response, the government has been consulting the transport industry, both aviation, maritime, air cargo, on what a legislative response might be, including for cybersecurity, and Ms Pfeiffer has been leading that work.
Thank you, Mr Hansford. Senator, we have been tasked with looking at transport security reforms, and that really is to look to make amendments to ATSA and METOFSIS, the Aviation Transport Security Act, and the Maritime Transport and Offshore Facilities Security Act. What we're really looking to do is to deliver a dynamic and modernised transport security framework that will actually improve our security outcomes. Transport sector is an incredibly important sector to the economy and incredibly vulnerable. It is one that has long had the ATSA and METOFSA legislation around it, and we're really looking to modernise some of those frameworks and bring them forward. You are absolutely correct. Cyber is a particular vulnerability, and that is a target of the amendments that we are looking to do. We're looking to manage an all-hazard security risks in parts of what we are doing with this approach. We're really looking to also make sure that those risks are we're managing those risks that are originating outside the physical boundary or geographical location of those facilities, and that's where cyber is really one of our single most urgent reforms within the package. We're also looking to implement effective system testing programs that's risk-based and responsive to the intelligence that we receive, and making sure that our compliance and enforcement frameworks are robust and fit for purpose in this environment. It's a very challenging environment, and it's really important that we bring it forward into a more modern framework. So we have been doing consultation with industry sectors across the aviation and maritime span of industry from May to July. We've held several town halls and done sector-specific roundtables as well, and individual meetings with industry participants. We received 23 submissions on the legislative measures from industry participants, and we also had 4 entities contribute to the impact analysis. And that has really helped us to refine the package of measures that we are looking to put forward as part of our legislation.
And have we got a time frame for drafting of that legislation?
So we're in the drafting process at the moment, and we hope to have introduction very shortly, obviously subject to government's agreement for introduction.
Thanks, Senator Polly. I was about to cut you off.
I thought so.
Now, if I can just double check, Senator Shoebridge, do you have questions for outcome 1?
No, keen to get on to outcome 2.
Oh, great. Well, lovely. I think Senator Polly's going to put the rest of her questions on notice.
Yes, I will. Just to help the committee.
And
could I just correct a date? I told Senator Patterson I had meetings on the 20th of September. It was the 2nd of October in the
there
US.
you go. And you had a follow-up, Senator Patterson.
The Minister had an answer to the question you took on notice earlier about the Minister for Home Affairs' personal vehicle.
Yep. I have received some advice from the Minister's office. Let me just pull it up for you. Immediately on being appointed to this portfolio, Minister Burke informed his department and security agencies that he had a Chinese-made vehicle. He was given advice on the appropriate precautions to take and has taken those precautions.
Okay, that invites some follow-up questions, Chair. I'm sorry, I was ready to move on to outcome 2, but I think we have to persist with this for a moment. What vehicle does the Minister drive?
I'd have to take that on notice. I don't have those details.
What mitigations has the Minister taken to protect himself and the Commonwealth from the security risks of driving a Chinese-made EV?
Again, I'll take that on notice, but repeat the point that he has taken the precautions that he was advised to take by his department and security agencies.
Does that include not plugging his phone into the vehicle?
Again, that level of detail I'd need to take on notice.
Does that include not driving the vehicle to any sensitive locations?
I'll take that on notice.
We just heard from Mr Hansford earlier the large number of national security and cybersecurity risks posed by these vehicles, including that they can listen to the occupants, that they can film people outside the vehicle where the vehicle is travelling, that it can track where the vehicle is travelling, that it's a risk to a mobile phone that is plugged into the vehicle. Is it really appropriate for the Ministers for Home Affairs and Cybersecurity to be driving a Chinese-made connected electric vehicle?
Well, again, immediately on being appointed to this role, the Minister sought advice from his department and security agencies, and he has taken the precautions that he was advised to take. So I guess what that would mean is that, subject to taking those precautions, the security agencies and the department had no other concerns.
Okay. I'd rather hear that from them than from you. But just to be clear, our closest national security partner and ally, the United States, regards the national security threat posed by these vehicles as so grave they've effectively banned or proposed to effectively ban the importation of these vehicles into the United States for use by anyone, let alone a minister in a national security portfolio. Are there seriously mitigations that can remove this risk?
Well, it would seem, according to security agencies, the answer is yes.
Right. And what's the basis of your confidence that that risk can be eliminated? If our American friends think that the only way to deal with this problem is to effectively ban them from the whole country, how does the Minister for Cybersecurity driving around in a Chinese listening device protect Australians?
Well, perhaps you don't share this view, Senator, but I have confidence in our security agencies and the advice that they provide to ministers.
The dominant provider and manufacturer of these vehicles is China, and they regard the threat so serious that they have banned these vehicles that they themselves make from sensitive national security sites. No one would know more about these vehicles than China, and they regard it as such a national security threat it shouldn't be allowed near sensitive sites.
Well, again, this may be a curious position for us to take, Senator, but we take advice from Australian security agencies, not from Chinese security agencies.
Or from American security agencies, apparently. So it's your evidence then that our national security agencies don't agree with their American counterparts about the national security risk.
I haven't said that. What I've said repeatedly is that Minister Burke took advice from his department and Australian security agencies and has acted in accordance with that advice. And I think that's the appropriate action for any Australian minister to take, not to go to overseas countries looking for advice from them, but to seek advice from Australian departments and Australian security agencies.
Wouldn't the most prudent course of action be to put it beyond doubt and just not drive a Chinese-made connected vehicle?
I think the most prudent thing for Australian ministers to do on national security matters is to rely on the advice of Australian security agencies, and that's what Minister Burke has done.
I'm sure they'd be glad that the ministers followed their advice, but I'd be willing to bet they'd be even more comfortable if they knew the minister wasn't driving one at all.
Well, I'm not aware of them having advised him to not drive that car.
No, we weren't aware at all until a few minutes ago at all about him driving this vehicle.
I've told you that Minister Burke sought advice from his department and security agencies. He's acted in accordance with that advice. I can only assume that if their advice had been to stop using that car, then they would have provided that advice and he would have acted in accordance with that.
Prior to taking up this portfolio, the Minister was still a member of Cabinet and as a result of that privy to a whole range of confidential and classified information. Why didn't he seek advice as a member of the Cabinet prior to taking up this portfolio about any mitigations? Why didn't he put these mitigations in place before then?
You're asserting that he didn't, and I don't know if that's the case. What I did was request an answer to the question you posed earlier, which was related to his vehicle use while he was a minister in this portfolio.
And as you yourself have said, when he was appointed to this portfolio, he sought the advice of national security agencies. I think it's pretty clearly implied with that he had not sought their advice prior to that when he was just an ordinary member of Cabinet.
I'm not sure about that. I haven't checked that.
Okay, well, can you take that on notice? How many other members of the Albanese Cabinet are driving Chinese-made EVs?
I'd have to take that on notice, and I'd question whether this is even the portfolio to ask that question.
Well, you'd be pleased to know it is, because the Department of Home Affairs recently became responsible for tracking Australian government exposure across the board to connected technologies like these.
The point I'm making is that the government fleet is owned by, serviced by, whatever the correct word would be, by a different department, and they would be the department that would have the sorts of records that you're seeking about the make and model of every minister's vehicle.
I have checked this. It's the Department of Finance. There are no Chinese-made EVs available on the list of cars offered to members and senators through the lease process. So has Minister Burke gone outside the Department of Finance process to arrange his own private vehicle because it wasn't available on the list?
I think there's several leaps of logic in that. I mean, I don't know. I mean, if what you're saying is correct, then what we're talking about here is Minister Burke's private vehicle rather than a fleet vehicle. I'm not saying that's correct. That's what you're implying. But again, I'd need to get details of any of that before I can properly answer.
Why do you think no Chinese EVs are made available through the fleet process?
I'm not going to speculate about what another department, who I'm not here to represent, what the basis of their decision-making is.
Mr Hansford or any other officials, has Finance ever sought your advice about appropriate vehicles to have on the fleet choices available to members and senators?
We are actively talking with the Department of Finance as recently as last Friday about connected vehicles and the fleet policy, and so we are actively talking to them about that.
But there are no Chinese-made EVs available on the finance fleet, are there?
I'm not sure. I have to check.
Okay.
What I can tell you is there is a wide variety of vehicles that are not available on the fleet list, presumably for a variety of reasons.
So just to be clear, Mr Hansford, you or any other officials who have this in your state of knowledge, has Finance ever sought your advice about national security risks of any particular vehicle or brand for the fleet offering to members and senators?
Not to my knowledge, no, Senator.
No. Are there any other officials in the room who have knowledge of this?
No, Senator. I suspect if they're looking for threat information, that might be a question for the Australian Signals Directorate.
Right. But the department is the holder of the PSPF. I presume this falls under the PSPF?
Procurement settings and standards as they relate to security fall in one element of the protective security policy framework, yes.
Right. So what input, if any, has the department had into the fleet choices available to members and senators through Finance?
I'll take that on notice, Senator. I don't recall specific advice that I've provided, but my team may well have over time.
Well, is there
and I think, Senator, I'm sure the officials here will do what they can, but I do think the better place to put those questions would be Finance, because you could then be finding out about any agency that they may or may not have requested that advice from. Some of the agencies that you might be involved aren't even here and sit in other portfolios.
Well, we may well direct questions to them as well, but this is the department of government responsible for providing security advice to other departments of government on things like this through the PSPF. It would surprise me if by happenstance the Department of Finance has just arrived at a list that excludes a whole range of brands. For example, BYD is not on the list of Department of Finance approved vehicles to be made available for members and senators. That's one Chinese-made EV brand that's been excluded from that list. It could be just a coincidence, or maybe they've sought advice to someone and that's why it's not on there.
Well, they could have read the protective security policy framework and looked at procurement and risk and looked at the levels of risk and applied it to the fleet policy.
Yeah. Yeah, which obviously the Minister for Home Affairs didn't do when he bought whichever Chinese EV he's driving.
Well, this entire discussion is speculative, and I think you'll get better answers about why finance did or did not include certain types of vehicles by asking finance. And fortunately, they haven't appeared yet, so you'll have every opportunity to do so.
In the course of his duties, does the Minister ever need to drive to any secure facilities to receive briefings? When he's in his electorate, for example, when he's out of Canberra?
Oh, again, I'd have to take that on notice. I don't keep track of...
Perhaps I'll direct it to Ms Foster. In your experience, you would have arranged briefings for ministers outside of parliamentary sitting weeks in their home electorates. They ever need to attend a secure facility or premises in their home state or city?
So, Senator, I can only recall engaging with the Minister or organising things in either the CPO or the electorate office. Mm-hmm. There's one occasion where we did need to have a sensitive discussion, and that was done here in Canberra.
Mm. Yeah, as far as I'm aware, there's no electorate office that's set up to have TS briefings, and I'm not even sure CPOs are set up for that. Maybe some have them. I'm aware that many don't. And certainly in my previous duties as Intelligence Committee Chair, I've had to go to secure facilities to receive TS briefings. I had to drive myself to those secure facilities to receive those briefings. I imagine a Minister for Home Affairs would receive just as many, if not more, sensitive briefings than a Chair of Intelligence Committee. So has the Minister ever had to drive himself to a secure facility for a briefing?
That's what I just said, Senator, not to my recollection.
Okay, could you take that on notice, please?
I will.
And if the Minister had to do that, did he travel there in his privately arranged Chinese EV, or was he conveyed by some other means?
Understood, Senator.
Thank you. Thanks, Chair. That's sufficient questions from me now for outcome one.
Thanks, Senator Patterson. Senator Shoebridge.
Thanks, Chair. Just in relation to that series of questions, Secretary, are you aware, if any, do you or any of the senior officers drive a Tesla?
I don't, Senator. Mm-hmm. And I don't believe any of my executive group drives a Tesla, but I invite them to correct me if I'm wrong.
Well, and I ask this question because Choice, of course, has done some recent detailed research in relation to not just Chinese-made electric vehicles, but a variety of other electric and non-electric vehicles. And for example, Tesla, which is obviously owned by Elon Musk, who some people would say is a walking threat to democracy, reportedly gathers voice command data along with short video clips and images using onboard camera systems fitted to the car and shares that data with third parties. Has a risk assessment been done of Tesla vehicles?
So, Senator, the question around risk assessments is one for Mr Hansford.
Certainly. So we are looking at the security threats posed by connected vehicles generally. We have not at this stage gone down to vehicle by vehicle analysis. We are looking at the security implications. I might add though that from a safety perspective there are other portfolios who are looking at vehicle safety standards as well, and I'm aware that there are yet other agencies such as the Australian Office of the Information Commissioner that are looking at data related elements of connected vehicles as well.
Was Home Affairs aware that Tesla actually gathers voice command data as well as short video clips and images from people as they use the vehicle and shares them with third parties?
The department is aware both of the choice reporting, which outlines a range of different vehicle providers obtain a whole range of different types of information based on that analysis, so aware of the general security risk, yes.
Minister, do you accept it's an issue if a foreign car maker is gathering voice command data, short video clips and images from onboard vehicles being used in Australia and then sharing them with third parties?
Well, yeah, I think as a general proposition that would be a concern, and this is again one of the reasons the government is preparing a framework around how to deal with these types of issues regarding connected vehicles.
Well, of course, Minister, one of the ways this could be dealt with is some decent privacy laws that made it illegal to do that. do you realise that there are significant national security concerns by failing to progress privacy laws to outlaw this kind of data gathering?
Well, I'm sure we'll have a long discussion about privacy laws when we get to the Attorney General's Department estimates. But as I say, this department has already talked about the work that it's doing to prepare a national security framework around these issues.
Well, Secretary, through you to whichever appropriate officer, does Home Affairs realise that privacy and data protections, as this exchange is showing, is actually critical also to national security? If these companies can't collect this data about ordinary Australians going about their business, if we had effective privacy laws, they also wouldn't be able to collect this data about ministers going about their business. Has your department urged rapid movement on privacy reforms because of the national security benefits?
So, Senator, I'll let Mr Hansford and Mr Anstey, and if she has anything to add, Ms Sharp, who manages our privacy area, assist with that question. As you heard me, invited any of my deputy secretaries to advise me if they drove a Tesla. I'm advised that there is potentially one acting deputy in the ABF who drives a Tesla, but I haven't had that confirmed from the individual.
Secretary, I won't ask you to name who that deputy secretary is, but will you undertake an urgent security review given the detail released by choice that Elon Musk would have access to data, video and voice collected in that Tesla?
Senator, let me take that on notice and discuss that with the relevant officials, and I'll see what is consistent with our current policies and what is available to us. And in the meantime, I'll hand back to either Mr Hansford or Mr Anstey.
And just before you do that, just to avoid having to bounce back and forth with other car makes, Toyota also collects significant data, not voice and video image like Tesla, but movement data, which may also allow them to track where people have been. Ford collects and shares data. They don't specify what data it is, but they share them with third parties. And Mazda collects and shares data as well as Chinese car manufacturers who collect and share data. Sorry, I'll let you direct the question.
Certainly, and as the Minister said, we are developing a national security vendor risk framework as outlined in the cyber strategy. We're also doing work on data brokers, data sets of national significance from a security perspective, and we obviously talk to the Attorney General's Department about privacy issues as well, but Mr Anstey is leading those bodies of work.
Mr Anstey, you're going to tell us how you urged the Attorney General's Department to speed up their privacy reforms because it's not only good for individuals' privacy, it's good for national security. Is that right?
Senator, that's a barrister question.
I hope the answer is yes.
I leave the administration of the Privacy Act to the Attorney General's Department.
So you weren't. So Home Affairs wasn't consulted in terms of the cyber security issues with getting privacy laws right. There are you leave it just to the AG's department.
No, we are consulted. Yes.
So what is it? Is it your answer, Mr Anstey, or is it Mr Hansford answer?
There are three sort of related points, Senator, I think worth teasing out. The first are the privacy, personal identification materials that can be generated through not only connected vehicles but other technologies. That's administered, as you rightly recognise, under the Privacy Act. What we look after is the national security considerations and concerns in a policy sense that relates to this data collection and transfer. In that context, we're doing a number of measures, but as Mr Hansford said, we look at the legal transfer of this data to third-party brokers and what the relative or respective policy regime might be around those third-party brokers that on-sell the data, as well as the appropriate sort of national security data restrictions that may apply to these technologies. So you're right, privacy sits with AGD. As it relates to national security, it would sit with us. And that could include sort of foreign ownership and control, for example.
But there are no legal restrictions for Tesla passing it on to third parties under any laws you administer or under the privacy laws. And that's a problem, isn't it, Mr Anstey?
That's a question for the Attorney General's Department, Senator. It's a privacy.
Are there no restrictions under any laws administered by Home Affairs for Elon Musk to just feed people's personal data, ministers' voice conversations, data recording to third parties? There are no restrictions on any legislation you administer, are there?
Mr. Anstey answered your question that these questions are relevant for a different portfolio, Senator.
Well, I'm asking, you said that third party, transfers to third party was a matter for Home Affairs, and I'm asking, is there any legal restriction that you're aware of?
To be clear,
Mr.
Senator,
Hansford can answer it.
From legislation the department administers, there's obviously data security requirements in the security of critical infrastructure legislation, and as a matter of framework, data-related issues in the protective security policy framework, but we don't administer the Privacy Act.
All right, perhaps you can take on notice what, if any, advice you gave or were requested in relation to the national security implications of the privacy reforms.
We will take that on notice, Senator.
That's it.
Thanks very much. That's all the questions we have for outcome 1. And I now call officers from the Department of Home Affairs in relation to outcome 2. I'm sure they're not too far away, but we'll give them a moment to come to the table. Okay, you ready? Ms Foster, are your officials ready to go?
We are, Senator.
Thank you. Senator Patterson, we'll start with you.
Thank you. I'd like to return to my correspondence as it relates to outcome 2, Secretary Foster, and I'm going to go through these questions in the order I wrote to you them with. And if you could provide the information, that would be greatly appreciated.
So, Senator, for the first group of questions
Yep.
Relating to Israel-Hamas conflict,
Yes.
Michael Willard and Michael Thomas and Andrew Kiley are the 3 officers who will assist with those questions, and they are all at the table.
Thank you. Could I please have the number of visas granted, refused, cancelled or reinstated for Palestinian document holders, and whether these were done onshore or offshore?
Senator Michael Willard, Group Manager, Immigration Operations. In the period 7th of October 2023 to the period 15th of October 2024, there were 3,041 visas granted to holders of Palestinian travel documents. 126 of those were granted onshore, and the remainder, 2915, were granted offshore.
Let's just drill down on that quickly before I move on. How could someone be granted a visa onshore? Have they transferred from another visa? They've gone from a tourist visa to another visa, for example? Or
That covers all Palestinian travel document holders. So there was a population onshore prior to the 7th of October, which was around about 900 people. Right. So some of them may have applied. Also, what you just described is possible as well.
Okay. So, but the vast majority were granted offshore?
Correct.
How many were refused onshore and offshore?
So for refusals, Senator, I'll provide this by a few different visa categories because one of them goes to less than 5, and if I provide the whole number, it will give away that number. So in total, 7,252 visitor visas were refused, and I'm talking about the same period that I outlined previously, of which 7,248 were refused offshore.
So 4 were refused onshore. Again, just explain to me how someone could have a visa refused onshore.
Similar set of circumstances. It's open to anybody to apply for a visa if they think they meet the criteria. It's then assessed against the relevant criteria, and it's refused if it doesn't meet.
What has happened to those 4 people, given they've had a visa refused onshore?
I don't have that information in front of me.
Does anyone have that information? I mean, presumably given they refused a visa, they no longer have a valid visa to be here, so they would either need to be deported from Australia or taken to detention.
So there's there's a number of circumstances where someone could be refused a visa, where they may still hold a valid visa. For example, they could have a long-term visa and being applying for another visa, which they don't meet, in which case the original visa would remain in effect until.
Okay, and what happened in this instance?
Sorry?
And what happened in this instance?
This is a particular instance.
Yes.
I'm giving you an example of what.
No, I don't want an example. I want the specific.
I don't have the specific.
Does anybody here have that?
I don't believe so.
Okay. Can you take that on notice, please? But if you can answer this now, that would be good. Were any of those 4 refused for security or character grounds?
No.
Okay.
In addition, so I talked about the visitor visas.
Yep.
In addition, another 45 other migration and temporary visas were refused, in addition to 8 protection visas and less than 5 humanitarian visas.
And how many of those were offshore versus onshore?
Senator, I don't think I have the breakdown on the 45. Protection visas are onshore visas and humanitarian visas are offshore visas.
Okay, could you provide that on notice, whether they were refused offshore and onshore, and if they were refused onshore, what has happened to those people, and if any of those were refused on security or character grounds, unless you can answer that now?
Sure, no, I can't answer that now.
Okay, how many were cancelled onshore and offshore?
Senator Michael Thomas, Group Manager, Immigration Compliance. 44 people had their visas cancelled offshore, with 21 of those cancellations subsequently revoked.
Yes, I'll come to that.
And less than 5 individuals had their visa cancelled onshore and placed in immigration detention, with 0 of those cancellations revoked.
Okay, so let's just focus on those 5 for a second. So those 5 people have had their visas cancelled onshore and they're now in immigration detention?
It was less than 5, Senator.
Less than 5, okay.
As you're aware, Senator, the department's convention
That's fine.
to not give numbers below 5.
Yep, you don't need to explain that, Minister.
I'm prepared to say it involves 1.
Okay, all right, well that's helpful, I appreciate that. So that one person has had their visa cancelled onshore and is in immigration detention. What were the grounds for that cancellation?
I'll leave it to the department to determine what level of detail can be provided about that particular case.
Senator, normally we don't talk about individual cases because we're talking one person in this case, it will give away information about the individual.
Yeah, okay. Well,
Senator, can I also just, for context, point out that it's not unprecedented for people who have been granted a visa to come to Australia to then have that visa cancelled because of security information. And in fact, it happened, I understand, on 20 occasions when Mr Dutton was the Minister.
Sure, I'm not, we haven't even got to that yet, Minister.
Just before we start going where I know you're going to go.
We haven't even got there yet, Minister. You can lean on those talking points if and when we get there. So, has this one person whose visa was cancelled onshore, can you tell me whether it was for character or security grounds?
Senator, it was cancelled under Section 501 of the Migration Act.
Okay, explain that in plain language terms for people watching who don't know the provisions of the Migration Act.
So those are the character provisions in the Migration Act.
Okay. So can you shed any further light on what the nature of the cancellation was on character grounds?
No, Senator. Again, it's an individual case and we won't talk about the details for privacy reasons.
There is enormous public interest in these cases. Ministers have been asked about these matters in question time, and from my recollection, they have previously said that no visas have been cancelled onshore for security or character. So this is a new development of which I think there'll be interest. When was this visa cancelled?
Senator, again, because we're talking about a single case, we won't go into the details.
Okay, but ministers have gone into more detail than you are now in the House of Representatives when answering questions. They've said categorically no visas cancelled onshore for character or security, et cetera, et cetera.
Senator, I can confirm, to the best of my knowledge, everything that ministers have previously said was correct at the point in time that they said that. If what I've just said to you is incorrect, someone will let me know. But
sure, I'm sure they wouldn't have knowingly or intentionally misled the House on that. I'm not suggesting that they are. It seems to me perhaps this has happened since then.
That would probably be a fair assumption, but what I can say is that, to the best of my knowledge, all previous information provided by ministers is accurate.
Okay. Well, Minister, perhaps you could assist. I understand the department's reluctance in doing so, but you've just disclosed more information for the assistance of the committee. If you could assist in providing further information from the Minister's office about this cancellation, I think there'll be genuine interest in what has happened in this case.
Yeah, again, I'm happy to take that on notice. I suspect that my position would be the same as what the department has said, which is that we're unable to give details about an individual case. Noting again, this is not unprecedented and occurred while Mr Dutton was the Minister for Home Affairs.
Sure. And that's why I'd like to know as much as we can about this. It may well be that this person's visa was cancelled because of something they did after they came to Australia. And if that's the case, well then no minister could be held responsible for knowing what someone would do when they got here. If that's the explanation, the government should provide it. Or it might be that more information came to light about their character that wasn't available when they applied. Whatever the reason is, I think it would be helpful to put that on the public record so Australians can have confidence.
I'm happy to disclose whatever is appropriate to do so, noting both the privacy and the security issues involved here. But as we've also said previously, I'm not trying to say that it was information that was new and came to light or about something that happened onshore. I actually don't know the answer to that. What I do know, and we've said before, is that we continually are updated, or agencies are continually updated about individuals.
Sure.
And should information come to light, whether it's something that happened while the person was onshore or before they got here, then the appropriate action is taken.
Yeah, well, whatever the reason is, I think the public would be interested to know, given the interest in this program and the controversy around it. Okay, so you said they were in immigration detention. That's obviously pending their removal.
Yes, Senator.
What steps need to occur now before they can be removed from Australia?
Senator, I can talk in a general sense about the steps to enable someone's removal.
Yep.
Again, I won't comment on the individual case, but their individual circumstances will be assessed and where they are in the migration process to determine how and if and when they can be removed. They may wish to depart voluntarily, for example, to a country that they have a right of entry to, or they may not want to, but those processes will be ongoing.
Minister Burke has publicly said that Australia can't send anyone back to Gaza, given the circumstances on the ground. Does that mean that this person in detention has another place they can be removed to?
Senator, again, I won't talk about the individual case, but it will be a discussion with the person to understand which countries they do have a right of entry to and where they might wish to depart to or be returned to.
Because if the minister is right, and if they can't be sent back to Gaza, then couldn't this potentially trigger the NZYQ provisions on indefinite detention? There has to be a reasonable prospect that they can be removed under the High Court's decision. What is the reasonable prospect for this person to be removed?
And so, Senator, we'd be again going into details of an individual, but speculating on a situation which we have not yet exhausted.
Okay. Well, I look forward to what further information you could provide on notice, because otherwise, if this person can't be removed and if the NZYQ obligations are triggered, then they would have to be released into the community, wouldn't they?
Senator, we'd be speculating about that. We don't know the circumstances
Well, it's not speculation
yet.
to apply the High Court's reasoning to someone's circumstances. If they can't be removed, they have to be released from immigration detention. That's
Senator,
right, isn't it?
That's a statement of fact. That's
correct,
general.
and that's all I'm asking for officials to agree to, that statement of fact.
But we're not,
shedding
any light on the implications of that for this individual.
Sure.
There's clearly a lot more work that has got to occur before any decisions can be made. But the person is in detention.
Okay. All right. So just going back to those numbers, it was 44 that were cancelled offshore.
Yes, correct.
How many of that 44 or this additional person have been subject to an adverse security assessment or a qualified security assessment from ASIO?
Senator, ASA's adverse security assessments are a matter for ASIO, and that question will need to be directed
Well,
to
they
them.
provide them to the department. It's one of the criteria you would use to cancel a visa if you received it. So how many ASAs or QSAs have you received?
Again, Senator, the number of ASAs is a matter for ASIO.
Why can't you provide that? You're in possession of this information. You need to provide it unless you have a valid reason not to provide it. Saying again that it's a matter for ASIO is not grounds under the Senate's resolutions to refuse to answer a question. You have to make a public interest immunity claim.
I will need to take it on notice so I can discuss with ASIO what information we can provide.
Okay.
Senator Patterson, just one more question.
Thank you.
And the call around.
All right, so the last was the reinstated. 21 were reinstated, you said?
Yes, that's correct, of the offshore cancellations.
So what was the reason for them being reinstated?
Generally, Senator, further information was provided to the department to resolve any concerns or issues, and the cancellation was subsequently revoked.
And they've then come to Australia, presumably?
Not all of them, Senator.
Right, how many of them have come to Australia?
15 of those individuals then subsequently came to Australia.
Okay, thank you, Chair.
Thank you. Senator Shoebridge.
Thanks very much, Chair. Secretary, last estimates, I asked you questions about an FOI that your department had provided that showed that between October 2015 and between September and October last year, the first month after the conflict commenced in Gaza, more than 2,000 Australian residents left to go to Israel, with the bulk of those being aged 16 to 35. Do you remember those questions?
Yes, Senator.
Yep. And we asked if you could, on notice, provide the total number of people who have travelled, and we also separately asked those questions, which you took on notice. And despite the material that's provided in the FOI, we were told that the department doesn't hold the data. Are you still tracking like you were in the first month?
So
indeed, the months that followed,
Senator,
the number of people leaving to go.
Can I just clarify, we're talking about Australian citizens?
Just people? People who have left Australia and travelled to Israel.
So, Senator, if they were Australian citizens, that would not be a matter for our immigration function, and questions around that would probably be addressed in Outcome 1 as a national security issue. In terms of tracking visa holders who leave Australia, I don't believe
born
that's something we commonly do. So
carrying an Israeli passport was the numbers you tracked. Travellers identified as being born in or carrying an Israeli passport. You're able to track that data for the first few months, but then you cease to track that data and you refuse to provide answers. Why is this?
So, Senator, I think looking also at my immigration officials, that this is information that was canvassed in Outcome 1 in a national security sense, and obviously I no longer have those officers available to me.
Is anyone providing information to... Well, can you take it on notice then, Secretary?
Of course I can, Senator.
Are you aware if any data is being tracked about individuals who are leaving from Australia to fight for, say, the Russian military in the Ukraine?
So again, Senator, that would be a question for Outcome 1.
Well, we did ask and we were advised this would be Outcome 2. So we asked through, I don't want to dob anyone in, but we asked where the appropriate spot to ask was.
We can't, I mean, the officials are here and you...
Well, given we've only just left, would it be possible, Secretary, Because we were under the apprehension this would be an outcome too.
Sure, and I can understand that, and I don't want to also... I'm not sure about the advice that you've been given, but Senator Shoebridge, if I could assist you, the Secretary and the Department does provide a pretty good breakdown of the way that the outcomes are sorted throughout the program and the official... No, hold on a second. And we can't traverse back to a previous outcome because we've moved on from there. I'm sure that I keep calling you Senator Foster. I don't know if that's in your future, but Ms Foster...
Do tell.
Ms Foster will try to
want
assist you as much as we can, but if the questions aren't relevant to this outcome, I can't assist you further than that, Senator Shoebridge.
And I think, Senator, perhaps if you could outline the questions, we'll see if there's anything we can do to assist you in this outcome.
Thanks,
but I think that they sound like they're falling into outcome 1 territory.
Well, to the extent you can provide the information now, I'd be grateful. To the extent you can't, if you take it on notice.
Of course.
That can be done.
As I indicated, the data showed some 2,000 people, data collected by your own department, showed some 2,000 people who were either born in Israel or had Israeli passports, travelling to Israel, and the bulk of them aged 16 to 35 in the first month or so of the conflict. Have you continued to collect that data since, and if so, can you provide it to the committee?
Take that on notice, Senator.
Given the very real concerns that have been identified by, amongst other institutions, the ICJ, are you providing advice to individuals who are leaving Australia to travel to Israel, or indeed to travel to Russia? If they are of potential military age, are you providing them advice about concerns about war crimes and crimes against humanity that are being committed by the military forces in those conflicts?
So, Senator, normally travel advice to Australians going overseas would be coordinated through the Department of Foreign Affairs and Trade. So I'll certainly take your question on notice and advise if there's anything we can do to assist, but I think it will be more appropriately addressed to them.
Well, in other answers given, the department indicated that the Australian Border Force had reportedly intervened to question at least 3 Australians who were suspected of leaving the country to serve with the IDF. Since that advice was provided, are you aware if the ABF has intervened to question any other Australians suspected of leaving the country to serve with the IDF?
Senator, that's certainly a question which we can tackle in outcome 3 when the ABF colleagues are here.
All right. Has Home Affairs sought any advice from any other department about the potential security concerns of Australians fighting in conflicts, including the conflict in Gaza and the conflict in Ukraine, where there have been repeated reports of gross human rights violations and war crimes?
So again, Senator, to the extent to which Home Affairs would contribute to that, that would be an outcome 1 issue. I'm assuming if we were, it would be in collaboration with colleagues, but I'll take it on notice.
And again, can you explain why the department indicated in answers to media some 6 weeks ago that it didn't track Australians who were travelling to fight for the Russian armed forces in the conflict in Ukraine, and also didn't track Australians who were fighting for the IDF, given the repeated reports of potential serious war crimes and crimes against humanity committed in both those conflicts by both the IDF and the Russian armed forces? Why are you not tracking that?
So, Senator, again, I think that would be something we would canvass in outcome 1. I'll take it on notice and see if there's anything we can do to help.
Are you aware if it's been tracked, the number of Australians fighting in conflicts which are so notorious for egregious breaches of international humanitarian laws and the laws of war?
Senator, I'm willing to speculate without the relevant officers here who would hold that information.
But to the extent that there may be some advice at the border being given, that's something that ABF can answer later, is that true?
That if indeed there is something happening at the border with ABF, then we can address that in outcome 3.
All right, thank you. Could I ask about the meetings that have been held between Australia and PNG regarding the MOU in relation to, I think they're called the residual caseload or the residual, the poor people who have been left abandoned in PNG after Manus Island got shut down. There have been, according to Answer's question on notice, multiple discussions between the Australian government and the PNG government. Can you shed light on what those discussions were about?
Certainly, Senator. I'll ask Mr Thomas if he'll talk you through where that's at.
Senator, since we spoke at last estimates, further support has now been agreed between PNG Australia, that occurred in July this year, to assist PNG implement and deliver a sustainable settlement framework.
All right. What is that support?
It's to help them build their settlement framework through a community integration model, through their efforts to enhance case management, for example, to assist the cohort to build their independence and engage in a durable migration pathway, as well as PNG support to the individuals themselves.
So is the support to the PNG government for it to process and manage the caseload? That's part of the support?
Yes, that's right, Senator.
And you say there's other support that go to the individuals themselves?
No, it's all with the PNG government to implement their settlement program.
When was that agreement reached?
It was in July this year, Senator.
Has payment been made under that agreement?
Senator, no payments have yet been made under that agreement.
When does the agreement, well, can you provide a copy of the agreement?
Senator, as with previous agreements, the details of any arrangement between the PNG and Australian government are confidential.
All right.
So we'll seek PIO over any details of that.
All right. Well, consider me having pressed for it and you having reserved your position subject to PII claim. Is that where we've got?
Yes.
What is the sum of money that's agreed to be paid to PNG?
Again, Senator, that's part of the confidential detail between the two governments.
And again, that'll be the subject of the PII claim?
Yes, correct.
Are you aware, Mr Thomas, of the very disturbing reports of the some 40, I think it's 42 refugees who were abandoned by Australia when Manus Island was shut down? The very disturbing reports about their conditions?
Senator, through our discussions with the PNG government and through agencies like UNHCR, yes, we are aware of the remaining residual cohort.
Are you aware that those 42 refugees, some of whom have children and families there, number have recently been issued with eviction notices and are now facing homelessness?
Senator, we have raised that matter with the PNG government and they've assured us that no one is homeless.
When did that assurance come to you from PNG?
Earlier this year, Senator. Obviously a point in time, but certainly during previous discussions.
But the eviction notices have only quite recently been issued, and there were reports indeed that the rental arrears that were owed were in the order of $110,000 as recently as early September this year. So that would post-date that assurance you got from PNG, wouldn't it?
We understand, Senator, from the PNG government that they've provided alternative accommodation support to any affected individuals. And that was in August, I think was the last conversation.
What is the alternate accommodation that you say PNG has provided to these poor and desperate people?
I'm not sure, Senator. That's a matter for the PNG government.
Are you aware that the UNHCR has said that some of these people who were detained in Manus Island under a direction from Australia, who suffered appalling conditions in Manus Island and have now been abandoned by Australia, are you aware that the UNHCR says that some of them are now too ill, too sick to to even engage with any government or UNHCR process?
Yes, Senator, in discussions with UNHCR, they have outlined their concerns around medical issues and health.
What's Australia doing to assist, given Australia was in significant part a cause of these people's appalling conditions?
Senator, what I just outlined is where the discussions are between Australia and PNG.
Have you been advised that the situation indeed is so dire that some of these individuals' lives are at stake? There's a real risk that their lives will be lost because of their destitution, their health conditions, and the lack of support?
Senator, again, both the PNG government and UNHCR have outlined concerns with us.
And Senator, as Mr Thomas outlined, we have taken steps to support the PNG government with this cohort.
But Ms Foster, you haven't provided them with any money. We're now in November. This was the state of the condition of these people was known to be appalling at least at the end of last year, which is what led to the pressure for some of the discussions that appear to have led to some form of agreement in July. But we're now in November and not a single dollar has been provided to help some of the most desperate people whose desperate situation was caused by the Australian government. Why has nothing been provided?
So, Senator, Mr Thomas may be able to answer questions about the next steps, but we are obviously working with, in support of the PNG government to manage this cohort.
Senator Shoebridge, I'll have to share the call after this question.
Mr Thomas, is there a time frame under which any kind of material support is obliged to be provided under this agreement?
Senator, we're working with the PNG government at the moment on the details of the arrangement to make sure it's right and it's suitable. Money will be expended as soon as possible once both governments agree on the way forward.
I just have one question to finish this line of question, if that's possible.
I'm passing the call to Senator Payman, so it's on her indulgence.
All right. Thank you, Senator. Has anybody from Home Affairs, and if not Home Affairs, is Home Affairs aware of anybody from the Australian government who has actually gone and met with and seen these people, the people who were abandoned by Australia following the closure of Manus, who are in such destitution? Has anyone actually gone and met with them?
Not that I'm aware of, Senator.
Thanks, Senator Shoebridge. Senator Payman, you have the call.
Thank you, Chair. Good afternoon. I was just going to ask about the toll group that was selected in November of 2023 by the Department of Home Affairs to deliver assisted passage, medical and related services for Australia's offshore humanitarian program.
We'll just get the right officers to the table,
no worries,
Senator.
That's fine.
So he was on my left. I didn't see him. Sorry, Senator.
That's okay. Thank you. So I was just curious, what was the selection criteria that the department went through to choose Toll as their contractor for the refugee transition?
Yep, thank you, Senator. We went through a full request for tender process in accordance with Commonwealth procurement rules to undertake this process.
And what functions are Toll responsible for under this contract?
So as you stated, the Assisted Passage Program provides travel, medical and related services globally for Australia's refugee and humanitarian program.
Has an evaluation of Toll's performance since taking up the contract been completed or commissioned by the department?
So Toll began operations on the 1st of November last year. Given the complexities of the services that are provided under the Assisted Passage Program and the locations around the world where these services are provided, we've gone through quite the transition process. That transition process concluded on the 30th of September. So in answer to your question, no, we have not yet undertaken an assessment.
And can you elaborate on what locations they've been involved in? Or?
I don't have the full details of every location around the world, but essentially where we where we grant visas to refugee and humanitarian entrants, that's where Toll would need to provide those services to support their medical and then travel to Australia.
Would you be able to tell how many refugees Toll has processed since the contract took effect?
I don't have the details on me of how many arrivals Toll has facilitated.
No worries. And what metrics is the department using to determine the success or shortcomings of Toll's work?
Again, there's a range of metrics and key performance indicators in the contract with Toll, and we'll be using those over the life of the contract to measure their performance.
Will you be able to provide that on notice?
I'm happy to take on notice, noting it's a commercial agreement, what we can provide.
Of course. No worries. Okay, and so last month, I know this secretary has popped out, but it's about, my next line of questioning is about the developments in and around Afghanistan. Last month, reports from Iranian human rights group Halvesh suggested that between 200 to 300 Afghans had been killed by Iranian border guards. And in July, a young Afghan woman who was being held in a Taliban jail for protesting was reported to have been filmed being raped by guards. I just wanted to know how concerned is the department regarding these developments?
They're deeply concerning allegations, yes.
Has there been any movements in terms of humanitarian visas being granted? And can you outline how many since the Taliban's takeover in 2021?
Yeah, happy to. So since the fall of Kabul, so the period 15 August 2021 to 18 October 2024, 22,546 offshore humanitarian visas have been granted. Over that same period, 61,553 applications have been lodged, covering over 272,000 individuals. And of the total offshore humanitarian applicants currently on hand, Afghan nationals make up 62.1% of the total on-hand caseload. The government committed to continuing to support Afghans through the humanitarian program, and the department's delivered those numbers in full over the last few years.
Thank you. And Minister, does the government intend to expand that visa program in the near future?
Well, I think you'll remember, Senator, that the government did expand the humanitarian program in general. I'm not aware of any further plans at this point in time.
For Afghanistan?
Correct.
Yeah, thank you.
If I'm wrong about that, I can update the
No
committee.
worries. Thank you, Minister. Just finally, the Asylum Seeker Resource Centre reported last month that the majority of people held in closed detention on Nauru have recently been moved into the community, with many now struggling to afford 3 meals a day, clothing, drinking water and basic necessities. People in the community are allocated just $230 per fortnight to survive on. Has the government or the department heard reports that this allowance is not enough for people to survive on, and is there any consideration to increase the allowance?
Thank you, Senator. I'll ask Mr Felg to answer that question.
Thank you.
Senator, my name is Joe Feld. I'm the Acting First Assistant Secretary for Regional Processing. Yes, the department is aware of the media reporting. There are a range of services provided to transferees currently living in the community on Nauru. They are provided by the Government of Nauru in accordance with the regional processing arrangements. They include a number of welfare services, health services, and other sort of general activities to support the arrangements, the accommodation. There is no cost to the transferee for the accommodation arrangements for people on Nauru. That is all covered under the arrangement. And of course then there is the stipend you mentioned. which is assessed and determined in line with living standards on Nauru and is appropriate to the circumstances to support people in that environment.
Thank you. People seeking asylum held in the community on Nauru are reporting that only those found to be refugees have eligibility for work rights. What is the rationale for this decision, and what support will people be given to ensure they can meet their basic needs if they don't have any working rights?
So, Senator, Mr Feld can correct me if I'm wrong.
But if people are found not to be refugees, then I think the government of Nauru would then take action to return them or remove them to a third country.
Okay, so the department is looking at transferring people to a third country settlement options for people who don't qualify as a refugee?
So as you mentioned, if someone is found to be owed protection, then generally by that stage they are living in the community, of course, which they would have access to those services I mentioned, but also in addition have work rights. And we already understand that those people living in the community who are owed protection have sought work and are currently employed. For those people who are still going through their refugee status determination process, particularly those who might have had an initial negative hand down around that refugee status determination process, then they will be given the same services and support that is available to every transferee living in the community, but with the absence of work rights. And as the Secretary said, if a person is been found finally determined to not be owed protection, then the Government of Nauru would make arrangements for that person to either return home or find some other durable solution for them.
And that durable solution is a settlement in a third country?
That would be determined on a case-by-case basis, Senator.
Okay, no worries. Thank you very much.
Thanks, Senator Payman. Senator Pocock.
Thank you, Chair. Thank you for your time this afternoon. I wanted to dig in some questions along the same lines of Senator Patterson about visa applications for Palestinian nationals.
Certainly, we'll just get the right officers to the table.
Thank you. I'd like to find out how many visa applications of any kind are currently on hand for Palestinian nationals who have connections or family in Australia.
Senator, I can give you a figure on-hand applications. I don't think I'll be able to distinguish between those who have no connection and those who have a connection. We'd have to look at the individual cases.
Sure. Thank you.
And this figure's end of September, Senator. The figure's 200 applications outside Australia.
200. And how many of those applications are currently located outside of Gaza or the West Bank, Egypt, Jordan, elsewhere?
Senator, again, we can report on inside Australia and outside Australia. When you have to go to address details, it's not something we have readily available. I can say though, Senator, what we have seen in terms of the applications we've been receiving from outside Australia is the majority are in the occupied Palestinian territories, and the majority of those have been with addresses in Gaza.
Mm-hmm. Okay, thank you. I'll put some others on notice then, given the difficulties with the data. My understanding is that one of the reasons a humanitarian visa pathway 449 or 786 has not been provided for people from Gaza is due to the closure of the Rafah crossing and the subsequent difficulty in escaping. Is that correct?
Senator, that certainly provides a difficulty for individuals in terms of travelling opportunity to apply for visas is open to any applicant to apply for any type of visa that's available. So it doesn't relate so much to the closing of the Rafah crossing.
Okay. And so how many humanitarian visas have Palestinians applied for?
Senator, and the figures here are between 7th of October 2023 and the 15th of October 2024. There's been 240 applications outside of Australia.
And for tourist visas?
Tourist visas, 10,309 outside of Australia.
And so of those 240 humanitarian visas, how many have been approved?
Senator, in the period between 7th of October and 15th, 2023 and 15th of October 2024, that figure I have is 13.
13. And have the rest been rejected, or are they still just...
My understanding is they're on hand, but I'll correct the record if needed.
What's the expected processing time of a humanitarian visa?
It's difficult to comment on how long it would take to process any particular visa, given it would depend on the circumstances of individual cases and how it aligns with government priorities.
What are the government priorities at the moment with people applying from Gaza?
The humanitarian program is primarily focused on those who've been displaced from their country or place of residence, and we focus primarily on UNHCR referrals in the program.
Sure. Does that include Gaza?
By way of UNHCR referrals, we don't tend to have UNHCR referrals for Palestinians, given UNRWA's responsibility for managing Palestinians.
Senator, can I just add a point in respect of the earlier evidence I gave? That was in relation to all visa categories around where we've seen people are. In terms of a large proportion are in Gaza. I just make the point, though, that in all of those statistics, when it's outside Australia, it could be an application anywhere in the world that's lodged by someone who's holding a Palestinian travel document.
Sure. Do you know how many Australians have Gazan family members who are either in Gaza or have fled Gaza and not in Australia?
I don't have the figure.
Why not?
Senator, we respond to, obviously, applications from individuals rather than tracking Australians with family. And so the way in which we establish whether someone seeking to travel from Gaza has family in Australia is when they apply for a visa and we assess their application.
Sure. Thank you. And just to go back to those 240, what's the breakdown between 449s and 786s?
So those applications would relate to the 200 subclass humanitarian visa. The 786 visa that you're referring to is only available to people who are onshore on a case-by-case basis when offers are made by the Minister.
How many of them have been approved or given?
Yes. So as of 1 November, 68 offers of a 786 visa have been made by the Minister. 4 of those offers are still outstanding. Of the remainder, 48 have been granted the 449, which is the first visa in that 2-step process. And of those 48, 31 have been granted the 786 visa, which is the 3-year temporary humanitarian visa.
Thank you. And am I correct in saying that it was 449s that were predominantly used for people fleeing Afghanistan and Ukraine?
For Afghanistan.
Yep. Minister, what's happening here with 449s? Why aren't we seeing a consistent approach when it comes to humanitarian visas?
Well, I'm not sure that what we've heard necessarily says that it's an inconsistent approach.
We saw 5,000 humanitarian visas allocated in Afghanistan.
Well,
I'm hearing we've had 240.
That's but to be fair, the number issued for people from Afghanistan is over a much longer period of time.
What period of time?
I think it's several years, isn't it? That people started. I mean, people started leaving Kabul. Well, the fall of Kabul was from memory 2021. So I'm happy to be corrected, but the numbers that we've been given about Afghan visas would be over that period of time rather than a much shorter period of time when it comes to Palestinian visas. I remember the discussion we had about this point at the last estimate, Senator Pocock, and since that time the government has made a longer-term visa available for Palestinians coming to Australia, and there have been some take that up.
How many have received that?
I'd have to get the department to give you the figures, noting that it's pretty early days, and again, the figure's not going to be huge. But
that's the data that I just provided.
Okay. Minister, these are tiny numbers compared to what we saw the coalition do with Afghanistan. It's been well over 12 months now. Why is the Labor government so slow in actually recognising the horrendous plight of people in Gaza and Australians who have family there who are desperate to get them here?
I don't accept the view that the government has been, I can't remember the word you used to describe the government's actions. We have already granted, I think it was a couple of thousand visas. We've opened up a new category.
Tourist visas.
Yeah, and we've opened up a new longer-term category, which people are now applying for and are being granted, and inevitably that number will grow as time goes on. I don't think it's fair to compare those numbers to any other world event which has happened longer ago, and where, of course, the number is going to be higher because people have been granted visas over a longer period of time.
The thing I'm hearing from people is that they are really disappointed at just how long it's taking to actually recognising what we're seeing unfold over there and the desperation people are feeling to get family out, and yet we're hearing about numbers of 240. It just doesn't seem to. It doesn't seem to stack up.
Sure, but I mean that's 240 of a larger group that have been given a visa, albeit a shorter term visa. But Senator Pocock, unfortunately, I am in no way diminishing what people in Gaza are going through. It is appalling, and our government is committed to helping as much as we can, but unfortunately the reality is that in every world travel spot there are far, far more people seeking to get out than any one country can take in. There are, while the number of Afghan visas we have granted is much higher than the number of Palestinian visas, I know that there are members of the Afghan community who are desperate to have family members able to get visas in Australia as well. We're doing what we can. We've opened up a new visa category, and I'm sure that number will increase as time goes on.
And Senator, if I can add, we are working as hard as we can with the community of visa holders in Australia to progress the transition to 449 and 687.
And that's just for people in Australia?
That's for people in Australia, and Mr Kiley has outlined the process for humanitarian visas through our normal humanitarian program. But we are very conscious of the needs of this community, and we are doing all we can to assist.
Thank you. And will Palestinians who are on a 786 have the same ability to go through a resolution of status after 3 years that's available to people from Ukraine?
So, Senator, that decision will be made closer to the time, but absolutely.
Sorry, can I just ask why, given it doesn't seem to have been made close to the time for Ukraine?
So, Senator, I think what we are seeing now with the Ukrainian visas is transitioning from the temporary humanitarian stay visa to a resolution of status visa after some years in country. And so those temporary humanitarian stay visas, as you know, are of a 3-year duration. As they start to expire, Ukrainian families, individuals in Australia will start to transition through the resolution of status to a permanent visa. That pathway is likely also to be available as we reach that point with the Palestinian population.
Thank you. When was the decision made for people fleeing on those visas from Ukraine?
Senator, we recently started to process that pathway to permanency.
And that's a decision of government?
So, Senator, that's within the remit of the Immigration Minister to initiate that process.
And if I heard Ms Foster correctly, that decision was made as the 3-year mark was approaching for people who had been granted temporary humanitarian visas of 3 years duration. And so it would be fair to assume that in relation to Palestinian visa holders, we will make a decision about setting up a similar process to what we did for Ukrainian visa holders as we get closer to that 3-year mark. We're sort of doing it in stages, just as we did with Ukrainian visa holders.
Thank you. And just finally, thanks, Chair. And maybe to Ms Foster, given it seems to me it's just such an ad hoc approach to humanitarian visas, has there been any work done to actually develop some sort of framework that guides the way that we respond to humanitarian visas with things that happen overseas? And we talk a lot about social cohesion, and it seems to me one of the things that is actually adding to some of the angst around it is that they're seeing very different responses based on where people come from, what some of the geopolitics of that are, the perceptions. No one's talking about Sudan visas at the moment. Has work happened on some sort of framework, or is that not underway?
So, Senator, I think I'd like to take that in 2 parts. The first is the humanitarian program that has a number of components, but the largest component is those people who are referred to us through UNHCR. Every year we review the composition of that program depending on circumstances globally, on needs, on requirements, and you'll obviously be very aware that it was in that program that we did quite significant increases to cater for the Afghan humanitarian applicants. Secondly, we have the immediate response to a crisis, which, as you know, typically runs through using a visitor visa to get people to Australia quickly, and then looking at what options are appropriate for that cohort, given the nature of the conflict, the circumstances around it, what the possible trajectory might be. And there has indeed been, if I can put Afghanistan to one side for a second, because the circumstances there with Australia's involvement, etc., were somewhat different. The approach we are now using with the Palestinian cohort who has already come to Australia is very similar to that which we used for Ukraine.
Can I just ask?
I thought that was your last question.
That was.
So
I was keen to get the Minister's thoughts on that.
Senator,
Minister, this has been highly politicised. Surely we should have a framework to how we respond to emergency disasters, wars.
I can't add much to what Ms Foster said, but we do. It may not be. I understand that there are members of the community who would like us to grant more visas to people coming from Palestine, the Palestinian occupied territories. I understand people would like to see them processed faster. As I said to you, Senator Pocock, that the process that we're adopting is actually quite similar to what we did in relation to Ukrainian visa holders. It's quite similar to what's happened for other world trouble spots as well. We simply cannot, admit every single person who would like to come here from a world trouble spot, but we're doing what we can.
I understand that. I guess 10,000 Ukrainians.
I know, Senator
240.
Pocock, you've got a political point to make, but I've got to share the call and we can come back to you if you have further questions. Senator Patterson, you have the call.
Senator Reynolds has one quick matter and then I'll take the remainder of the time if that's okay, Chair.
Thank you
It's
very
really
much,
up to you.
Good afternoon. I've got a very quick question, actually, in relation to the English language test for visas. So I've had a lot of feedback from a number of different communities that they find the test quite deficient in two areas. The first one is that it's not using online technologies to actually do, so people have to come in person, and quite often if they're living in remote or regional remote areas when they move here, it's very expensive and quite inconvenient, particularly when they have to do it for a second or third or fourth time for different positions. So that's the first question. The second question is the nature of the test itself, is why, if someone has successfully completed the test once, particularly for those who English is their first language or the language of their education, why they have to keep repeating it and doing it in person. So they're the two matters I'd like to raise. And I particularly have that from the African community in Western Australia because, for many, they speak better English than we do.
Yep. Thanks, Senator. And I'll ask Mr Kiley to take that up. We've canvassed this issue previously. Yep.
Thank you. I can take the first part of your question, Senator. So,
thank you.
As you're aware, the government uses English language requirements in migration legislation as a means of effectively managing immigration risk and ensuring individuals can participate in the Australian community. We have existing deeds with 5 English language providers to provide that English language testing. On the 29th of July 2022, the Department released a request for expression of interest to facilitate more choices in English language testing for visa applicants and also to look to ensure greater consistency across test providers. That process is still ongoing, but we hope to be in a position where we'll have new test providers in 2025.
Before you go on, can I just ask, why has it taken 2.5 years already and it's not complete?
Yeah, there's been a couple of steps as part of that process. And particularly in June last year, we provided an additional opportunity for all of the requests for expression of interest respondents to submit revised responses, again looking to ensure that we could facilitate as much choice in that English language testing process as possible.
And that included online options?
So on sort of remote proctored online English language tests, the proposed model enables one of the elements to be submitted through online testing, but not all elements of the test. The department still has ongoing concerns about integrity and the security of the online environment, particularly how individuals can circumvent digital proctored software. So it's one of the things that we're very alive to. We recognise the benefits of online testing. We're just not in a position to have full confidence in the integrity of those tests at the moment.
So that's for online, but how about doing some of the tests via Zoom or Teams or something else so that you've actually got the individual in front of you?
I'd have to take on notice the exact.
Could you take that on notice, and also if you can provide me a step-by-step process of what was in the RFI, what you're actually seeking, and also why somebody would have to do the test if they pass the test, why they would have to keep doing it if they're looking for, for different jobs or different academic experiences or job opportunities. Can you take that on notice as well? And it just seems to defy logic. Somebody who's demonstrated great aptitude in English would have to keep proving they can still speak it.
I can take that one on
Thank you.
notice. I'm aware that there is advice from the English language testing professionals about the currency of particular tests and having to have a time limit, if you like, on that. I appreciate the point you're making about people who are native speakers or people whose educations are in English. There are some waivers to the testing provision that apply across certain visas in those circumstances.
Could you provide all that, because it just does seem to be one of the dumber things that we do.
Yeah.
And also it seems to be quite weighted towards people from the global south.
I'll take it on notice and provide that context.
Thank
Senator.
you.
So just one follow-up question on that. Mr Willard, are you aware that there are examples of professionals from, say, Nigeria or Kenya who have had their whole learning in English? One recent example, one person I spoke to recently in Queensland who graduated with a PhD from University of Queensland with the Dean's commendation, who's being required to do an English language test. Can you appreciate how demeaning people of that background could find that? And one ponders what it achieves.
I'll make a point, not intending to comprehensively answer the point you're making, Senator, but there is, for example, in our skilled migration points test, differentiations of points based on the level of English language proficiency. So that's a circumstance, for example, where someone who's highly proficient in English may want to take the test to be able to provide evidence of that level of proficiency, which then allows them to get the points for
That's not why
skilled
people are
migration.
being retested, even on academic circles. Anyway,
Sure.
we'll look forward to your advice. Thank you. Thank you, James.
Thank you. Just returning to this issue of the cancelled visa onshore, I got a question on notice back from the department which said, as at 18 September 2024, so just a little bit over a month ago, no Palestinians who have arrived in Australia since 7 October have had their visa cancelled on character grounds. So am I to assume that that answer was accurate and this person's visa has been cancelled since the 18th of September, or is there a need to update that answer?
No, that answer is accurate, Senator.
Okay, so it's a recent cancellation then?
Senator, I think that factually stands.
If that's the case, just say so.
So
Yes,
it has
would be the
occurred.
answer.
It has occurred since the 18th.
Okay, good, thank you. Where is Mr Thomas? You moved, you're over there. Okay, just returning to the issue of adverse security assessments or qualified security assessments. An order for production of documents that I secured through the Senate on the 19th of September went into some detail about ASAs and QSAs in relation to this cohort. It was released by the government to the Senate, so obviously they don't have concerns. For example, one line of this released document said 6 qualified security assessments have been furnished by ASIO. Of the 6 cases, a blanked out number have been cancelled on the basis of incorrect information, while the remaining 5 have been assessed and no further objective ground for cancellation has been found. So there's obviously not a problem providing that information by the department. So coming back to my question, of those visas that were cancelled, were any of them as a result of an ASA or a QSA?
Senator, I believe you were speaking about qualified security assessments. I was talking about adverse security
I asked my question about both of them, ASAs and QSAs, and if that wasn't clear, I hope it now is.
So, Senator, I think Mr Thomas's challenge is that his advice from ASIO was that questions about ASAs should be referred to them, which is why when you asked, he said, can I please take that on notice and refer to ASIO?
Yes, but it's not actually up to ASIO to direct questions or how they're answered. They can answer within their remit, and if we have time, we might ask them later. But I'm asking the department's state of knowledge, and it's not a valid reason to refuse to answer a question that another arm of government holds that knowledge, because you also have it.
Well, I think my recollection is that Mr Thomas took it on notice so that it could be discussed with ASIO. It wasn't simply a matter of him referring it to ASIO.
That's exactly right, Senator.
Okay, so you can't tell me whether any ASAs or QSAs have been furnished by ASIO, even though we know at least 6 have?
I'll take that on notice, Senator.
Okay. All right. I'll try and persist with the other questions then. So we have the figure of the 3,041 visas who were issued to Palestinian document holders. How many have arrived in Australia since the 7th October?
Arrivals for Palestinian travel document holders since that period is 1,749.
Thank you. How many of them have voluntarily departed or been removed following a refusal or cancellation?
Senator, less than 5.
Okay. So those 5 who've left voluntarily, was it entirely of their own volition, or was it because a potential cancellation or refusal?
This is question 4, Senator.
Pardon?
Is this question 4 in your letter?
Yes, correct.
Yes, yeah. Yes, so each of the less than 5 voluntarily departed from the community.
Because?
Between 7th of October and the 18th of October.
Because of a possible refusal or cancellation, or unconnected from that?
No, Senator, unconnected.
Right, so purely voluntary departure.
So they'd already been cancelled on character grounds and then subsequently voluntarily departed.
Right, okay. So there were less than 5 visas cancelled on character or security grounds onshore then?
Prior to 7th of October 2023.
I'm confused. Why are we talking about prior to 7th October 2023?
Just from the dates in your letter, Senator, we were looking at that time period.
Okay. So are these really historic cases?
So, sorry, Senator, just to clarify my evidence earlier, what I was talking about with the cancellations were for the group that came to Australia post 7th of October 2023.
Yes.
So it's the less than 5 cancellations onshore. For this question, this was overall the number of Palestinian document holders that departed, but the cancellations would have occurred prior to 7th of October last year.
All right. For the avoidance of doubt, if my letter wasn't sufficiently clear, I'm interested in the post 7th October cancellations.
What's thrown us, Senator, is that some of the questions you specify that and some
Sure. Okay. Well, I'm clarifying now for your benefit. If that wasn't clear, I apologise.
And Senator, the departure happened after the 7th October.
Right,
the cancellation happened prior to.
Okay. Right. And they were on character grounds?
Yes, that's correct.
Right. Okay. But less than 5?
Yes.
Okay. And then the following question was on adverse security assessments, number 5.
Generally, I can generalise it on security grounds. So following any cancellation on security grounds, the number is 0.
0. Okay. Thank you. I suspect I know what your answer to number 6 is, but let's go through it just in case.
I'll pass to my colleague.
In respect of question 6, again, generalising in terms of security grounds, not speaking about ASAs in particular.
Yep.
We can't report on detailed reasons for refusals across the cohort without looking at individual cases. And the other point to make is that when refusals are made, they're made on, it's just one ground, doesn't have to be met. So
sure,
it could
be many.
Something could meet a number, not meet a number of grounds, and then a refusal is a particular ground.
Yep.
Having said that, though, from advice from processing teams, there hasn't been refusals on security grounds.
There hasn't been?
No.
What about the one who's been in the federal court?
I believe that related to a cancellation.
Right, not a refusal. Okay. So because he was already granted his visa, which presumably allowed him to leave Gaza, and then his visa was cancelled while he was in Egypt rather than refused.
Correct.
Right, okay. All right, we might come back to that case if we have time. How many are on bridging visas?
Senator, at the 15th of October 2024, there were 1,060 Palestinian document holders.
Sorry, could you just repeat the number? 1,000 and?
1,060.
1,060 or 16?
60.
Okay.
On bridging visas, noting that the absolute majority of those are bridging visa A's, which are granted while someone is undertaking a protection visa application.
Yes. How many have applied for and granted or refused protection visas?
So in the period 7 October 2023 to 15 October 2024, there have been 1,132 applications for a protection visa. In that same period, 7 have been granted and 8 have been refused.
Right. And presumably the grounds for refusal are that they didn't meet the criteria rather than security or character?
Without commenting on individual cases, yes, that's my understanding.
Okay. I suspect the answer to question 9 about the number detained is 1 in reference to the Minister's answer before.
It's less than 5, Senator.
Indeed. Okay, thank you. Could you provide a timeline of the advice to government on options for temporary humanitarian visa program?
So we've worked with government over a number of months since the conflict on potential options and pathways, leading up to the Minister starting to make the visas available from September this year.
Yep, that's not a timeline. That's a generic statement about advice. Can you provide a timeline?
Yeah, and then from there, the first sort of formal initial advice was provided to the Minister the then Minister for Home Affairs in May, with subsequent briefings and discussions following that.
In May? To Senator Pocock's point before, this occurred on the 7th of October previous year. We waited until May to provide advice about humanitarian visas.
As I said, Senator, there are a range of discussions and briefings held with ministers following the conflict. It was the first set of formal advice provided in May.
Okay. All right. If you could provide a full timeline on notice, that would be appreciated. The minister made what I found to be quite a startling revelation on an interview with Patricia Carvelis on ABC Radio National a few weeks ago, where he said he was meeting in person applicants for these 786 visas. How many Palestinian visa holders has the minister met with personally?
So the Minister for Home Affairs has met with 12 Palestinian family groups covering 57 individuals, where a pathway to the 786 temporary humanitarian concern visa was discussed. Of those, 36 individuals held a visitor visa and 21 held a bridging A visa. Of those, 51 have accepted the offer for the temporary humanitarian stay. Of those, 14 have been granted the 449 visa and 31 have been granted both the 449 and 786 visa, and 6 are still being assessed.
Thank you. Before I move on to the next question...
One more minute.
Okay, thank you, Chair. Is this a service generally available to visa applicants? In my elected office, and I imagine everyone else's, gets lots of inquiries about visas. Can they all be referred for personal meetings with the minister, or is the minister only meeting Palestinian visa applicants? And if so, why?
So, Senator, the minister met with a number of Palestinian and Ukrainian families essentially to launch the process that we're undertaking. There is no intention that the minister will meet with all applicants, and we are working through, as a department, how we now progress those applications in a more routine way.
Right, it's certainly not routine for the minister to meet them. Does he ask them questions about their suitability? Does he interview them and form a judgment based on that interview whether they should be granted visas or not?
No, Senator.
Well, what's the purpose of meeting with them then?
Senator, the purpose of the meetings, as I said, was to launch the case-by-case approach to providing a pathway for both the Palestinian and the Ukrainian cohorts in Australia. And as I said, we are now moving to process those in a routine way.
Right. Thank you, Chair.
Thanks, Senator Patterson. Senator Tyrrell, we're going to come to you.
I'd like to ask some questions about migration visas. The Deloitte Access Economics Report $1 billion benefit shows more than 620,000 permanent migrants are working in Australia at a skill level. Sorry, I probably should have prefaced, it's about migrants coming here and we're not utilising their skill sets.
Yeah.
Yeah? Perfect. At a skill level lower than their qualifications, and worse, an article in the Australian Financial Review showed almost half of skilled migrants are not even employed in the field their visa was granted in. Given that Australian businesses are reporting skilled shortages and these migrants are coming here with skills we say we need, what checks does the government do, or is there a formal follow-up process once the migrants are here?
So, Senator, I think the issue that you're outlining was one of the things that we considered as we were developing with government the migration strategy that was released late last year, and to reshape our program so that we were much more explicit about the skills that Australia wanted and needed, and had much clearer pathways for people to pursue that path in Australia. And so we had a situation where, for example, many people were coming to Australia on student visas or visitor visas, translating into different kinds of visas, but not actually having arrived with a system that provided a pathway for us to most utilise their skills. Part of the solution is the role that Jobs and Skills Australia is playing, working very closely with the department. So you will see, as we start to implement the strategy, a greater match between the skills that people have and the way in which they're being utilised in the Australian economy. That clearly is not just a Commonwealth issue. That's something we're working with states and territories on because they take quite a large component of the skilled migration intake into Australia. And you know, there are other issues which are not always within our control, which we are also working hard with colleagues on, about how to get skills and professions accredited within Australia. I know that's a source of great frustration both to immigrants and to companies and employers. And so we're trying with a range of strategies to get to the heart of the issue that you've raised.
Is that going to be historical as well as moving forward, like people that are here currently?
So I think different elements of that will relate either forward-looking or historically. So obviously the selection and transition of people is a forward-looking thing. How we can assist people to move into areas that are more relevant to their skills can be both.
So it's a moving feast to date and for a little bit further?
Well, it's a work in progress is the way I would put it, that we absolutely understand the problem and have a strategy which we are implementing to address it.
Okay. So the Department's Migration Program Report 23-24 shows almost 6,200 employer-sponsored, skilled, regional and business migrants nominated. Tasmania as their intended residents last year. The $1 billion benefit report states Tasmania's economy would grow by $250 million each year over the next 10 years. If there was a better match between the skills the migrants have and my state's employment outcomes. I think you've already answered this though previously. What is the government doing to fully utilise the migrants, the skilled migrant workforce that is in Tasmania and more widely Australia?
So I think generically the answer to the first question covers that, but let me see if Mr Willard or Mr Tegg want to add some wisdom. They're a bit closer to the implementation.
I love wisdom.
Thank you, Senator. Brendan Tegg, Assistant Secretary, Migration Reform. As the Secretary said, we're working through implementation of the migration strategy, and one of the key pieces that you have picked up on, Senator, is the issue of skills and those skills not meeting the current workforce. We are currently working through a number of reform measures. One of those is talking to the states and territories and our regional colleagues. Quite a number of consultations occurring around the country to seek to understand better the visa products, how the visa products we currently have are impacting on the regions and how we can work with states and territory governments particularly to ensure that we are meeting the skills requirements in the states and territories. So to date, we've undertaken 22 in-person and 13 virtual consultation sessions across Australia, and we'll be continuing that work in the coming months.
Tasmania has a designated area migration amendment, DARMA, I love an acronym, with the Australian Government to address labour shortages in our building and construction industry. How many skilled migrants have joined the Tas construction industry under this agreement? Are you aware?
Ms Ma's coming to the table to answer that question, but just as she's doing that, certainly the multi-year agreements with states and territories is a really good way for us to work collaboratively to ensure that we understand those needs and we can work with them to ensure that as we're planning ahead, we can funnel the right skills and the right people to those states, which has been really well received.
Perfect.
Thank you, Senator. Cara Mayer, Assistant Secretary, Skilled Visas Branch. I understand your question was around construction workers under the Dharma in Tasmania. If you bear with me for a second, I do have the number of visa holders that have been granted both a permanent or provisional skilled visa or a temporary skilled visa to Tasmania. Sorry, the table's quite difficult to navigate. So this isn't under the Dharma, but Tasmania, we've had 70 construction trade workers granted visas in Tasmania, 8 construction managers, 12 architects and landscape architects, 73 civil engineer professionals, 5 other building and engineering technicians, and 10 structural steel and welding trades workers, totalling around 186 visas granted under the temporary and permanent provision skill programs.
So we've got a lot of people that have migrated here that have huge skill sets. What's the transition then from their previous country to ours? Are we looking at the way that we can recognise those qualifications moving across, or is that just impossible under?
I don't know if that's impossible. I might refer back to my colleague Brendan, Mr. Tegg, sorry, in terms of the migration reform strategy and some of the work that we're implementing there. But there are a range of visa options available for skilled migrants. There's a number of changes that are occurring in skilled migration as part of that strategy. There's a new skills and demand visa that's being implemented by the end of the year, as well as a national innovation visa that will be implemented by the end of this year also. Both of those programs are an outcome from the recent migration strategy and aim to better target migration outcomes and streamline migration processes in skilled migration.
And Senator, I might just add to that, the Department of Employment and Workplace Relations are the organisation responsible for skills assessment to ensure that skilled migrants can have their skills assessed in Australia, and they're doing a piece of work currently to try and streamline and fast-track those assessments.
What have we forecast that we require to actually meet our skills shortages? Do you know that? Or what are we hoping our migration program is going to achieve for us in the next?
So I think that work is led by Department of Employment Workplace Relations with JSA.
I thought you may have known. That's okay. Thank you so much, Chair. Appreciate your time.
Thanks very much. Now, Senator Ghosh, you have a few questions, similar topics, so we'll keep the...
I do, thank you. My questions relate to the skilled migration program as well, and I'd like to pick up where my colleague Senator Terrell has started, which is relating to the way in which the department deals with qualifications of skilled migrants, both in terms of recognition and the certification or accreditation of those skills in Australia. There was a response, I think, from you, Ms Foster, that the department endeavours to help those migrants under the skilled migration program get into pathways or into positions that relate to their skill set or the relevant skill shortage. I was wondering if you're able to elaborate on that answer in terms of what, or one of the officials is able to elaborate on that answer in terms of what that help looks like.
So I think, Senator, what I was really referring to was the settings that the strategy brings into the migration system are designed to support that, but happy for colleagues to jump in if they want to add to that.
Thank you, Secretary. Yeah, I think, as the Secretary was indicating, it's about the settings, and it's about making sure if you're coming on a temporary skilled visa that you have a pathway potentially to a permanent visa. If you're coming on a student visa, that you've got a pathway through a temporary graduate visa to a temporary skilled visa. So looking at making sure that those settings align, and if you meet one of the criteria that you should be able to move through, and issues, as Senator Reynolds indicated earlier about having to do an IELTS test again, it's being able to align some of those settings. So it's very clear to people whether or not they can proceed to and progress through a number of temporary visas potentially to a permanent visa, or if they don't have options to a permanent visa, that they are aware of those options. As I mentioned, the Department of Employment and Workplace Relations undertaking a piece of work around fast-tracking and improving the process for skills assessments. So so a skilled migrant can come to Australia and prove that they've got nursing qualifications, for instance. But that's a piece of work that the Department of Employment and Workplace Relations is progressing.
And do I understand that answer as being essentially that what you were referring to is permissions as distinct from facilitation or assistance in terms of translating that visa into a position or being able to work in the field for which someone has successfully obtained a visa?
Senator, I'm not sure I understand your question entirely, but I think ultimately what we are trying to ensure is that it's very clear if you will be able to meet the criteria for a visa because of your skills and qualification and experience, to demystify some of those things, but also to make it clear if you don't have that skill, if you don't have those skills, that you won't be able to get a visa, and at some point people will need to make a choice as to whether or not they'll meet the criteria for a visa or not meet the criteria for a visa. But looking to dissuade people from continuing to, I guess, stay on apply for visa after visa after visa. Temporary visas, I should say.
Okay. Can I ask how many visas were issued to skilled construction workers in financial year ending 2024?
Senator, I can answer that question. So visa grants for 23-24, was that your?
Yes, that. But if you have multiple years, if you've got the ability to just list those off, that'd be great.
Certainly. Across the both permanent provisional skilled visas and temporary skilled visas, in 2009 to 20, 4,872 visas were granted. In 2020 to 21, 3,984 visas granted. 2021-22, 4,676 visas were granted. 2022 to 2023, 10,589 visas granted. 2023 to 24, 11,349 visas were granted. So I also have this year, if that's of interest, up until the 30th of September, 4,525 visas granted. So that's across the permanent, provisional and temporary skilled programs.
In terms of the skills in demand visa, are you able to outline how the government determines which occupations are eligible for that stream?
So the skills in demand visa will be implemented by the end of the year.
Okay.
And so I can go through some detail with you. I won't be a second. So that was a commitment from the migration strategy, basically to reform and rename the existing temporary skilled shortage visa into the new skills and demand visa. So the new visa includes a number of streams: a specialist skills stream, a core skills stream, and an essential skills stream. And as I said, 2 of those streams will be implemented by the end of the year, with some further work underway on the essential skills stream. In terms of the occupations, the specialist skills stream is that first stream that I mentioned. It's designed to recognise highly skilled migrants who will bring in significant economic benefits to Australia. It will be streamlined and available for applicants across any occupation, excluding trade workers and machinery operators and drivers and labourers. And those people must earn at least $135,000 at a specialist skills threshold, and no less than an Australian worker in that same occupation. And so that income threshold will be indexed annually. The second stream that I referred to is a core skills stream. That stream is designed to bring in skilled employees Australia needs now and into the future, to ensure that we're meeting labour market demands. So that stream will be available to applicants who meet a general eligibility criteria and whose occupation is on a new core skills occupation list.
And the exclusions you mentioned from the specialist pathway, are they covered in the core skills pathway, or?
Subject to, so the core skills pathway and that occupation list is a list that's been developed by Jobs and Skills Australia, so that if those occupations are on that list, then yes, most of those occupations would come through that core skills stream.
And is there a list of occupations that are currently permitted in that second stream?
So that list is Jobs and Skills Australia have provided their advice to government, and we're anticipating that list will be made public in advance of the skills and demand visa being implemented at the end of the year.
Is there a draft list?
I believe there's not a recommendation list. I'm not sure of the terminology. I'm sorry. It's a list that's been provided by Jobs and Skills Australia. The final list has not been published. But I think it's probably a matter for to talk to Jobs and Skills Australia about whether or not there's a draft list available, or I can take that on notice and find out in the break.
That'd be great. You've mentioned that this is a change in the existing, or we're transitioning from the existing system to this system. Why was the change and the related reforms necessary, or what's the rationale for the change?
I might pass to my colleague, Mr. Tegg.
Thank you for the question, Senator. I think the main reason for the new piece of work with Jobs and Skills Australia, particularly to develop the core skills list, is the fact that previous lists have been created and not updated. And so government was keen to have tripartite discussions with industry and unions to really understand which are the occupations that are in shortage, and to ensure that that they were included in the new core skills list. The significant feature of the specialist skills pathway, which is the top pathway that mentioned earlier, the main point behind that is to remove the skills, the particular occupation requirement, to ensure that new occupations, whether it's AI, technology, specialist or whatever it might be, are not looking to wait for a new update to ANSCO codes that may take many years, and in fact in a year or two we may not know. I mean, there may be new occupations that don't have ANSCO codes. So looking to ensure that Australia is able to, and Australian employers particularly, are able to hire migrant workers for those highly specialised new occupations that are coming online.
And there's a new system being developed, obviously. How will that affect processing times for visa applications?
So under the new skills in demand visa, the government has committed in the migration strategy to new processing times of, and Ms Meyer might correct me if I'm wrong, but I believe it is 7 days for the specialist skills pathway and 21 days for the core skills.
I'm sorry,
pathway.
I didn't hear that.
Sorry, 7 days for the specialist skills pathway and 21 for the core skills pathway.
Okay, thank you, Chair.
Thanks very much, Senator. Senator Shoebridge, you have the call.
Oh, thanks, Chair. Secretary, I think you and another government official, I can't remember who, were answering questions on the difference between, and it may have also been the Minister, the difference between the treatment of people fleeing the genocide in Gaza, Palestinians fleeing that genocide in Gaza, and Ukrainians fleeing the Russian invasion. Do you remember those questions and the answers that you both gave?
I do, Senator.
Yep, and a summary of your answers were effectively the treatment of Palestinians and Ukrainians was basically the same.
I think I said it was similar.
That's not true though, is it?
I believe it is true, Senator. So in both cases, the process has commenced with visitor visas, transitioned to temporary humanitarian stay visas, and now in the case of the Ukraine, as Minister said, coming up to 3 years on, we're now starting to translate to pathways to permanence.
Well, why don't we start with some of the core differences? The rejection rate for those fleeing the conflict in Ukraine and seeking safety in Australia was some 15%. More than 11,000 were granted. Applications were granted to Ukrainians in the first year, and only a fraction of that refused. The rejections rates for Palestinians was greater than 70%. That's not the same, is it? One has a rejection rate of 15%, one has a rejection rate of greater than 70%. That's not the same, is it? Or similar?
Senator, I was describing the process of visa pathway.
Well, people from the small cohort of people who'd managed to flee the conflict in Gaza and came here had to wait nearly a year on visitor visas and bridging visas before being provided with the opportunity to get a 786 visa. Yet 786 visa options were offered to Ukrainians almost immediately. That's not the same or similar, is it?
So, Senator, I just repeat what I said. I was talking about the pathway. Absolutely, there is a difference in timing, but the evidence I gave was indeed correct about a similar pathway.
Of the, I think, 68 Palestinians who have been offered a temporary humanitarian visa option, the 786 option as a pathway, 57 of them had to personally meet and submit themselves to the minister's largesse. Nobody from Ukraine had to do that, did they? That's not similar, is it?
Senator, I'm at the risk of repeating myself. I was referring to the visa pathway, and that was correct.
And indeed, those fleeing the conflict in Ukraine were openly offered by the department the option of applying for other visas, including permanent protection visas. And that's still not been offered to Palestinians. And that's not the same or similar either, is it?
So, Senator, everyone should be careful about how absolute my language is here because I've got the program manager with me, has the opportunity to apply for a protection visa.
A permanent protection visa?
Well, Senator, if protection is found to be owed, then that leads to a permanent outcome.
Well, why was that information included on the department's website for those people fleeing the conflict in Ukraine, but why has it not been included on the department's website for Palestinians fleeing the conflict in Gaza? Why is the department making that information available only to the Ukrainian cohort and not the Palestinian cohort?
So could you just clarify exactly what information, where what's been included on one and not the other? Because as the Secretary noted, it's open to any individual in Australia to apply for protection.
And that information is available on our website very clearly.
Well, I've got the two relevant websites. For the information for those from Ukraine, it says Ukraine subclass 786 visa holders who wish to apply for a further visa to remain in Australia can now do so, and discussion of lifting the bar. On the relevant part of the website on the Hamas-Israel conflict, inaccurately named of course, temporary humanitarian stay pathway for Palestinian and Israeli nationals in Australia, no such reference is made.
So, Senator, I think we'll have to take that on notice. Obviously, the Ukrainian webpage would have been prepared some time ago.
So, Mr. Garley, they're the current, printed just this morning from the department's website. For those fleeing the conflict in Ukraine, they're told that they can apply for a further visa after having got a subclass 786 visa. No such information for Palestinians. To be clear, is the department saying there is no bar to the application of a protection visa for Palestinians who are in receipt of a 786 visa?
The migration regulations prevent any individual who's been granted a 449 visa, which is the first step onto a 786 visa, from being granted a protection visa. So any individual who's been granted a 786 visa will not be able to be granted a protection visa.
So when the Secretary said that those Palestinians who'd been granted a 786 visa, which obviously a precedence for that is I think it's the 449 visa, that they could apply for a protection visa, that's actually not true.
I don't think that's what the Secretary said. The Secretary said that any individual who's in Australia is able to apply for a protection visa in a general way. There are some bars that exist in the migration regulations that will prevent the granting of a protection visa in certain circumstances.
Well, let's go back to the difference then. Secretary, your department's website, as at this morning, made it clear that those who'd fled the conflict in Ukraine had been granted 786 visas, could apply for further visas to remain in Australia, and then it went into detail about the way the bar could be lifted. None of that has been made available to Palestinians fleeing the conflict in Gaza. Why not?
So, Senator, I said a little while ago that I'd take that question on notice. I'd like the chance to review both websites, to look at when they were created and to talk to my staff about the differences, if they indeed are there.
Putting to one side the websites, which speak for themselves, the department has made clear that the bar could be lifted for those from Ukraine to seek permanent protection, and quite rightly too, given the awful conflict. Why hasn't the department made the same offer to those people fleeing the conflict in Gaza?
So, Senator, I think Mr Kiley has some information that might be useful to you in the context of the lifting of the bar.
So, as the Secretary noted earlier, the process that's been put in place for Ukrainians was the 449-786 offer, and now the pathway to permanency through the resolution of status on a case-by-case basis. During that 3-year period, the government also made available a pathway to permanency through the lifting of the 91K bar, which is the bar that applies to individuals who are granted a 449 where there are compelling and compassionate circumstances. That was part of the process to support Ukrainians. It's open to government to, in a similar way, look at what to make available to Palestinians over the course of their 3-year temporary humanitarian visa.
So, Secretary, I go back to my initial proposition that I put to you. That benefit and that humane approach is available for Ukrainians fleeing the awful conflict in Ukraine. It's not available for Palestinians fleeing the awful conflict in Gaza. That's not similar, is it? That's what I put to you earlier and you remonstrated with. We've now spent 10 minutes demonstrating how your response didn't fairly reflect. Do you want to reflect on your answer now?
No, I don't, Senator. I stand by my answer, and I think Mr Kiley has just explained that this is, in part, a case of the stage that the process is in. I was commenting on the process that remains similar.
Could we move on to the issue of visas and responses for those people fleeing now the awful conflict in Lebanon, which has at the root the same cause? I think you said in your opening, Secretary, that some 3,000 people have been able to flee Lebanon and come to Australia since the conflict started. Is that right?
I said, Senator, that we had assisted through the repatriation program over 3,000 people.
All right. I thought that's what I put to you, but is there a distinction you want to draw?
I was making it clear that I was speaking about the repatriation program.
Right, okay. Of those 3,000 people, how many of those were Australian citizens?
I'll see if one of my colleagues has the detail. I think perhaps Mr Willard has some statistics.
Senator, figures on citizens have to be addressed to DFAT, who handled the repatriation program. What I can say is that in the last month, 15th of September to 15th of October, we granted 604 visitor visas to family members of Australian citizens.
Were any visitor visas offered to anybody who weren't family of Australian citizens?
Not for the purpose of the repatriation.
Okay.
Separately, Senator, it could be a circumstance where someone in their own right meets the requirements for a visitor visa, which may have been granted at the same time, but it wasn't tied to the repatriation process.
Well, then putting to one side the repatriation process, since that conflict has really heated up in Lebanon since the first of the most recent round of attacks from Israel into Lebanon started, have there been, well, how many visas have been granted for people leaving Lebanon to come to Australia? Do you know?
I have some figures, Senator. The challenge with your question is what is the timing, particularly when the conflict heated up. I think we've been observing for quite a long time now considerable pressure. The Australian government's had travel advice out to citizens not to travel for a considerable period.
Well, if you've got some data with
I've got some data,
some time frames, give us the time frames that might exist.
So if we look at migration and temporary visa applications granted in the period since, this is since 7th of October 2023, that figure is 8,333, of which 4,470 are visitor visas.
Okay. I think probably if I was going to pick a date for when the conflict really escalated, I think it would be from the 1st of October this year, when Israel's most recent invasion commenced. Do you have any data from the 1st of October?
I don't have that to hand. I do have some data where we're tracking weekly application and grant rates.
What you've got, Mr Moffat?
So what we saw was a weekly average of 91 lodgements per day at the start of October.
Yep.
This lifted to a weekly average of about 162 per day in the second week of October. And we've seen grants go from a weekly average of 54 per day to about 58 per day. That's in that first 2-week period in October.
All right, and that's the most current data you have?
That's what we've got here.
Could you, if you haven't got it there, could you provide on notice more current data? And do you have a breakdown of what those, were they visitor visas that you're talking about?
I can provide the detail on notice. What we've seen in Lebanon that's a little bit different, I think, from other crisis situations is when you look at arrivals, the larger group is in fact partner visa holders who's arriving, more than visitor visa holders.
And that's the visitor visas that you said, I think, was it since there were 604 visitor visas granted, that's a collection of family members of Australian citizens?
Yes, so that'd be...
And when's that from? I'm sorry, my notes are a little...
That was 15th of September to the 15th of October.
Okay. Is there a humanitarian visa that's open for people fleeing the conflict in Lebanon, Israel's invasion of Lebanon?
Any individual can apply for a visa under Australia's offshore humanitarian program. We have quite a significant number of cases on hand from individuals who are in Lebanon, approximately 80% of those, and the total number of those who reside in Lebanon as at 4 October is 12,718. Approximately 80% of those are Syrian nationals, with about 15% Iraqi nationals.
All right. I've been told that Home Affairs is requiring anybody seeking to leave Lebanon to get biometric testing, and that biometric testing is only available from a limited number of facilities in the middle of Beirut, where there is a high likelihood of people being under attack from Israelis' bombs, missiles, and it's incredibly dangerous. Is it true that Home Affairs is requesting, if not everyone, then the bulk of people seeking to leave Lebanon to get biometric testing?
Yeah, the bulk of people who are seeking a visa would be asked to complete to provide their biometrics. The facility in Beirut has contingency locations where it can move if the location they're at is considered to be unsafe. At this stage, they haven't moved. They have closed on a few occasions. One of the reasons we've also deployed additional people to Lebanon is to provide a capacity to collect biometrics, if necessary, from another location through departmental offices.
Just last question, Senator Shoebridge.
You must be aware of the concerns that people in Lebanon have of going into central Beirut, where there is a high likelihood of Israeli missiles and bombs and a very high risk to their safety. Why, given that, is the department insisting on biometric data, given it's put in often Australian citizens, their wives, their husbands, their kids at risk? Why haven't you done a risk assessment and said you won't do that?
It's a requirement for visa applicants. I appreciate the Australian citizen partners may be with them, but it's not a requirement for the Australian citizens. The facility itself, there is consideration as to whether it is safe to be open. As I said, it has closed on one occasion in respect of concerns about the particular neighbourhood it was in, but it has remained open for most of the duration of the more recent crisis. It's also been reasonably well subscribed in that most appointments are taken on a daily basis with capacity to fit people in normally within 24 or 48 hours.
Thanks, Senator Shoebridge. I do need to share the call. Senator Patterson, over to you, and you'll take us to the break at 4:30.
Thank you, Chair. I just want to quickly finish off those final three questions in this bracket, questions 12, 13 and 14, then I've got to move on to another matter. A timeline for the government's decision to refer all visa holders to ASIO for security checks?
Senator, the decision was one that Home Affairs and ASIO agreed to. All of our considerations in respect of security criterion are based on the guidance of security agencies. The process for considering for security considerations continues for the life of the visa, both before the visa is granted and then along the journey to Australia, and then
yes,
once
but
a person's in Australia.
2,000 odd visas were referred to ASIO on bulk in March. When was the decision made to do that?
a few days before they were referred.
Right, and what was the process for making that decision? Was it a decision of government, decision of the department?
It was an agreement between Home Affairs and ASIO.
Right. Can you provide a more detailed timeline of any meetings on notice?
I can. We have regular meetings with ASIO. There are a number of meetings.
Yeah, I'm interested in how this decision was made to mass refer the visa applicants to ASIO.
It was a result of a number of meetings discussing security considerations based on...
Not a directive of the Minister or the government?
No, it was a decision of Home Affairs and ASIO.
Okay, all right. Number 13, the number of cancellations of visa holders who've engaged in anti-Semitic rhetoric or conduct.
Senator, between 7th of October last year and 18th of October this year, less than 5.
Right. So, I mean, the Minister's publicly canvassed his willingness to do that. I think there's a public interest in being more specific, so it's not 0, presumably.
That's correct. It's less
Is
than
this
5.
the one person in immigration detention?
No, Senator.
Right, okay. So have any of these people left the country who've had their visas cancelled because of anti-Semitism?
I'd have to take that on notice, Senator.
So it's less than 5, they're not in immigration detention, but you don't know whether they're in Australia or not?
I'd need to take on notice to confirm if they're in immigration detention. They probably are if their visa was cancelled, but I'll take that on notice to confirm.
Well, we've answered before that only one person is in immigration detention because of character cancellation.
Sorry, Senator, just to confirm, are you saying of the people that came to Australia from the 7th of October, Palestinian?
Oh, yes, I am, but I appreciate you might be referring to a large category.
Any nationality.
Yeah, good point. Good point. They could have come from any country in the world and still engaged in anti-Semitic behaviour. So less than 5 from any range of countries, not necessarily Palestinian document holders.
That's correct.
Okay. And you can't provide any further detail on their whereabouts?
No, I'd have to take them on notice. Apologies.
Okay. Thank you. And the number of cancellations of visa holders for displaying terrorist symbols, etc.?
For the same time period and for any nationality, 0.
Yep. Pardon?
0.
0. Okay, thank you. All right, I want to move on to another related matter. Secretary Foster, perhaps you can explain, or if not, maybe the Minister can explain. How does Fayez Al-Hassani meet the character test of Australia's Migration Act?
Apologies, Senator, can you please repeat that?
How does Fayez Al-Hassani meet the character test for Australia's Migration Act?
Senator, I won't comment on individual cases or people.
Okay, well, the Minister for Home Affairs has commented on this case. He's been asked about it in question time, so if he's willing to comment on it, I don't see why you can't.
I can provide information on the character test.
I don't need generic information on the character test. I'm familiar with that. I want to understand how this person meets the character provisions of the Migration Act. We've seen on the front page of the Daily Telegraph revelations that 3 of his brothers and 2 of his sons were members of listed terrorist organisations, operatives in the armed wings of listed terrorist organisations.
I'm not exactly sure what Minister Burke has said about this in Parliament, but what I can say is that all visas from people coming from Palestinian occupied territories have been checked by ASIO by the same personnel and under the same processes that were in place under the former government.
Character provision of the Migration Act is not a matter for ASIO. It's a matter for the Department of Home Affairs and the Minister. That's why I'm asking questions to this department about character. How does he meet the character test?
And so, Senator, as Mr Thomas has explained, we're constrained from discussing details of individual cases. It is, of course, always the Minister's prerogative to do so, but we as officials are not able to do so.
This is a person who hosted Hamas, Palestinian Islamic Jihad and the Popular Front for the Liberation of Palestine at the Rawasi Institute, which he was the director of and the founder of, and held a press conference with them where he said we need to resist Israel by all means necessary. The Minister said, has commented on this, but you're not willing to?
So, Senator, I just explained that as officials we're constrained from commenting on individual cases.
Okay, I'm going to assist you and the government with some further material about Mr Al-Hassani and the Rawasi Institute, which he directs. I'll table in a moment a series of images, but I'll go through them in some detail first, that have been exhibited and published by the Rawasi Institute. It includes vile anti-Semitic material, for example, a post that depicts rats with a Star of David and a blue and yellow flag on them, clearly saying that Jewish people are rats. Another one where a devil is depicted menacing what appears to be a Palestinian child. That devil has the Star of David around him. Many instances of the glorification of Ismail Haniyeh and Yahya Sinwar, senior operatives and leaders of Hamas, a listed terrorist organisation. They are depicted variously as father figures, as champions of the Palestinian cause. There are other images of rockets being launched from Gaza into Israel, posted as a celebration on this social media account of the Rawasi Institute. Others where children are depicted holding photos of Ismail Haniyeh or Yahya Sinwar after their death, and praising those terrorist figures. Others which depict militant fighters with weapons and glorifying them, praising them for their acts of terror, including people who appear to be depicted as members of the Al-Qassam brigades and other listed terrorist organisations in Australia. Various celebrations of Iran's attacks on Israel, various celebrations of the Houthis' attacks on Israel and others in the Red Sea, in international shipping. Children being depicted next to rockets being fired, cheering and celebrating. I mean, even a specific image praising the person who recently, in a terrorist attack in Israel, drove a car into a bus stop, injuring civilians in a terrorist attack, I think including killing one elderly person, innocent civilian. How is someone who founded and directs an art institute, so-called arts institute, that's published this virulent anti-Semitic material, an appropriate person to come into our country and stay in our country? Minister, perhaps you can help, because the officials don't want to.
I assume, seeing as you're so concerned about this, that you've presented that material to the security agencies for their consideration?
As I've said before, Minister, character provisions of the Migration Act are not a matter for ASIO, they're a matter for Home Affairs.
And have you, I assume again, given you're so concerned about these matters, that you've presented them to Home Affairs for consideration before bringing them out in a public hearing?
I hope it wouldn't require me to provide the public Instagram page of the Rawasi Institute to the Home Affairs Department.
Are you asserting that that Home Affairs and ASIO haven't done their job? How are you to know that they haven't considered that material?
This is why I'm asking these questions, Minister. I would like to know whether or not the department has reviewed this material, whether they think it meets the character grounds of the Migration Act. I mean, there's another photo of a blood-stained Israeli flag being set on fire, which is posted on their Instagram. All this is freely available on the internet, Minister. You don't need to be an intelligence agency to find it. I mean, the Minister recently refused the visa of Candace Owens, an American commentator. And I strongly supported the Minister's decision to do so. She's engaged in despicable rhetoric against a range of communities, including the Jewish community, but also Muslims and others. She's not someone who would make our country better by coming here. But Fayez El-Hassani has done at least as much as Candace Owens has done, if not more. I mean, she hasn't hosted a press conference with Hamas. Fayez El-Hassani has. She hasn't said she's raising her son in jihad and raising her grandchild in jihad, as Fayez El-Hassani is reported to have done. I mean, how is this person a fit and proper person under the character provisions of the Migration Act to come to Australia, Minister?
Well, all I can do is keep repeating the point that we rely on security agencies and departments who have responsibility for considering the character of applicants when making decisions.
The Daily Telegraph has printed photos a couple of weeks ago of him embracing members of Palestinian Islamic Jihad, a listed terrorist organisation. They are dressed in full military fatigues and brandishing weapons. This is a clear association with a listed terrorist organisation. How does that meet the character provisions of the Migration Act?
I refer to my previous answer.
Just draw your attention to the time, Senator Patterson.
Thank you.
Yeah, you're right. We come back.
Okay, thank you.
We just have to go to a break so the committee will suspend for afternoon tea break. We'll be back at 4:45. Thank you. Its hearing. Thank you very much. And we'll continue with questions in outcome 2. Senator Roberts, you have the call.
Thank you, Chair. Thank you for appearing again today. How many permanent visas are currently issued for residency in Australia, and how many temporary visas are currently issued for residency in Australia?
I'll just get the relevant officers to come to the table, Senator.
Thank you.
Mr. Kilner, do you want the question again?
Yes, I just want to give my name first, thank you. Damien Kilner, First Assistant Secretary, Immigration Programs Division. Could I please just get the question again?
Sure.
Please?
How many permanent visas are currently issued for residency in Australia, and how many temporary visas are currently issued for residency in Australia?
So, Senator, for the migration program, the current numbers for this program year will be 185,000 migrant visas. That's the program numbers for this year.
That's permanent?
They would be permanent visas, yes.
180,000.
185,000,
185.
Senator.
Thank you.
Senator, for temporary visas, there are a range of different visas that we have. For student visas, most of these are demand-driven, Senator. So the programs, so the key programs for student visas, I'll give you a figure for last program year as an example, and I can give you a figure for visas that have been granted so far this year. So for last program year, there were 580,193 visas granted. So far, this is to 30 September, Senator. There were 99,868 visas granted so far this year from 1 July to 30 September. Sorry, that was lodged. For granted, it was 86,473. The numbers of granted for last program year was 376,731 for students. For temporary residents, Senator, the numbers granted were last financial year 315,632. So far this program year, there's up till 30 September, there's been 64,820 visas granted. And I'll also go to visitor visas.
What was that category?
That was temporary residence visas.
Okay. The previous one was temporary visas students.
So there's a different category. So that was student. The next one was temporary visas that I gave you.
Yep.
For visitor visas, Senator, the numbers granted for last program year was 442. For this year to date, up to 30 September, it's been 1,203,891.
What was that figure again?
Sorry, Senator. 1,203,891. And for working holiday maker visas, Senator, last program year there were 234,556, and so far this year there has been 95,371.
Thank you. Now that the war, I'm going to another tack now. Now that the war in the Middle East has progressed to responding to attacks by Hezbollah, a terrorist group from Lebanon, How many migrants from Lebanon have been received into Australia in the last year?
I'll have to take that figure on notice. I think I'll just check if my colleagues have a figure. We may need to take that one on notice.
Senator, I provided some evidence earlier on the number of visas we've granted to Lebanese citizens over the past 12 months. Your question was specifically about permanent visas, as I understand it. I don't have that breakdown, but I do have that figure which I could repeat. So since the 7th of October 2023, 8,333 migration and temporary visa applications have been granted to Lebanese nationals.
But the migrants you can get on notice? The permanents?
I can get the breakdown on notice, yes, Senator.
Thank you. How many applications for visas over the last year from Lebanon have been received to come into Australia?
So the figure for applications, and again this date is since the 7th of October 2023 to the 15th of October 2024, is 15,525 migration and temporary visa applications lodged.
What is the vetting process for these visa applications?
Senator, all applications are assessed against criteria for grant of a visa, which covers character, security, health and a range of other criteria depending on the visa that's granted. We have to be satisfied of someone's identity and there's a range of processes that sit behind all of those assessments.
So can you lead me through the process? A person makes an application, then what happens to that application?
So typically, Senator, the application is lodged online, which is how over 99% of our applications are received.
Does that go to a consulate or something in Lebanon, or does it come here?
It goes to one of our processing offices around the world. Some of them come here, some go to our embassy in Beirut, some go to other locations. When the application is lodged, there's a series of risk alerts in place that identify concerns or characteristics to look for around fraud and non-genuineness and other concerns. Just to give you a sense of that process, there's well over 1 million alerts in place that relate to identities and documents of concern. That's on something called the Migration Alert List.
So excuse me just for a minute then, it's probably appropriate to ask this now. So you work with intelligence agencies, Home Affairs, cybercrime?
Yes, Senator, we get information from a range of sources, including security agencies, other agencies within the Commonwealth, law enforcement agencies, partners around the world, a whole range of information. In addition to those alerts that relate to identities and documents of concern, there's another 3.4 million entity details which are matched against visa applications, and that might be, and I don't want to go into too much detail here, Senator, in a way that sets out exactly what the process is, because that provides an opportunity to game the process. Yeah. But entity matches are any piece of information that we've collected that might be able to be matched against an application. There's also 1,000 rules-based alerts, which is an alert that comes up to the decision maker to take a particular action on a particular application, depending on the characteristics of that application. And we also have 43 predictive models that again give a decision maker an indication of the risk associated with a particular application. That's not all that happens, but that's the starting point. Then there's an assessment of the application, all of the claims that are made, documents that are submitted in support of the application, and that's all considered against the criteria for the grant of the visa. If all the criteria are met, then the application is granted.
Two questions around that, please. What's the estimated time taken to process visa applications? And I'm guessing there's a wide range of times here. And secondly, would it be better to process these visa applications prior to these persons being allowed to enter Australia?
All the applications are processed when they're lodged offshore, are processed prior to them entering. In fact, they can only enter if they are granted a visa, so they've gone through that process and met all the criteria for visa grant.
Does that apply to refugees?
It applies to all visa applicants, including
Thank you.
refugees. Sorry, Senator, can you repeat the first part of your question?
What is the estimated time taken to process these visa applications?
At the moment in Lebanon, we're looking at about a couple of weeks. Again, as you said, there's a range of processing times, but that's roughly what we're looking at.
So 2 questions from that. Is that a fast track for people from Lebanon? And I've got nothing from people from Lebanon. I buy my lunch from them every day, and they're wonderful people, some of them.
What we're doing in respect of Lebanon is we're supporting circumstances where Australian citizens are seeking to leave, and a close family member might be someone who needs a visa. So it might be their partner, it could be children, it could be a parent. And in that circumstance, we're prioritising that assessment, but we're not. We still have, everyone still has to meet all of the criteria for the grant of a visa, and that process is at the moment taking a couple of weeks.
Is there any consideration being given to staying applications for visas from people from Palestine and Lebanon until hostilities cease?
Senator, across many years we've seen in all sorts of circumstances situations where there's challenges in various countries. The officers who make the decisions, the delegated decision makers, their role is to consider applications against the criteria and make an assessment of whether or not someone can be granted a visa.
So my interpretation of what you just said, and thank you for that, is that the criteria are not compromised.
No, the criteria are not compromised.
So that's the most important thing, criteria. But if there's a human rights crisis, as there is right now in Palestine and Lebanon, you may try and put more resources in it. How would you shorten up the period?
It's an exercise in prioritisation. So, for example, triaging applications when they come in and where there's additional information required, making sure that's actioned promptly. People get information about what they need to provide to satisfy the criteria. It's also about making sure we've got contingency, particularly in Lebanon at the moment, to be able to handle unexpected circumstances. For example, we have a capacity to collect biometrics through a mobile collection facility. We also have some additional officers in country who are supporting the staff that are already there, who've been going through a long period in Lebanon where it's been in a crisis situation, and so providing some additional staff to support them is part of what we're doing as well.
So would those staff already be in Lebanon? I think that's what you said.
Yeah.
And they're redirected to that, retasked?
So we've got 2 posted officers and 10 locally engaged staff in Beirut, and they've been doing a tremendous job in difficult circumstances. What we've done is have some additional people go in to provide some support and capacity for them to rest and recuperate and actually have a break as well.
Are they from Australia or from somewhere else in Europe and Middle East?
So there's a few from Australia and some have been cross-posted from other posts overseas.
How do you make sure that they can understand the cultural signs in Lebanon?
There's a series of training and assessments that we do before we post people. And they are trained on cultural awareness training, but in particular for this particular situation, they're also trained in working in high threat environments. They've also been assessed in terms of resilience because sometimes it is a very difficult circumstance, and officers are selected with those particular qualities. So
those cultural training, that's to be familiar with the local culture so that people understand the flags, not DEI cultural awareness.
It's a broader training that people go through on their overseas preparation course around cultural awareness. It's not specific to each country. When they do go into country, though, they are briefed by the local post, particularly around the security circumstances.
Thank you. Switching to Palestine, how many visa applications from Palestinians have been finalised over the last year with full risk vetting completed?
Senator, I provided some evidence earlier. I'm happy to repeat that. So, Senator, there's 3,041 visas have been granted to holders of Palestinian travel documents, and I'll just get that number for you. 7,252 visas have been refused, visitor visas have been refused. In addition, another 45 migration and temporary visas have been refused, 8 protection visas have been refused, and less than 5 humanitarian visas have been refused.
So out of about 10,300, 3,041 have been approved. Okay.
Yep.
Is it true, as the media stated, that some of those visa applications were processed in around 1 hour?
Senator, I do have some processing time information that could perhaps provide some detail there. So since October 2023 and going through to the end of September 2024, the median processing time for all visas finalised from holders of Palestinian travel documents is 116 days. And the average processing time in that same period is 107 days.
Medians and average, and I'm not accusing you of hiding anything, can hide many, many things. Were some of the visas approved in less than an hour or around an hour?
Senator, we're not able to report on that level of detail. I would be very surprised if that was the case, but I can't provide a report to...
Are you familiar with the claims made in the mainstream media, the mouthpiece media?
I am familiar, Senator, and in fact some of it may have related indirectly to evidence I provided previously before this committee, in which I was making a reference to globally visitor visas are processed in 1 day. But in making that reference, I mean all visa applications from all nationalities around the world, the median processing time is a day, and that is on our website, that median processing time.
That's from application being received to the visa being granted as a day?
That's the median processing time for visitor visa for all nationalities around the world. Doesn't mean it's the median processing time for holders of Palestinian travel documents. I just provided that figure at 116 days.
Senator Roberts, I'm just going to draw your attention to the time. I'll have to share the call in a few minutes, if you can.
Okay, thank you. One last question then. How many of those Palestinian visa applications are still outstanding?
Senator, I gave some evidence earlier. I think the figures...
And how many of them are connected with Hamas or Hezbollah sympathisers?
So for the visa applications outstanding outside Australia, as at the end of 30th September, that figure's 200. And I can't provide a response to the second part of your question because the fact they're outstanding means they haven't yet been assessed.
Okay. Thank you, Chair.
Thanks.
Thank you.
Thanks, Senator Roberts. Senator Shoebridge, we're coming to you next.
Oh, thanks very much, Chair. That's kind of useful to lead on from those questions. I think you said the average processing time for a Palestinian visa is now 116 days. Is that right?
That was the median. The average was 107.
The average was 107. I have some data from an FOI that the department produced, which gives the details, the processing times between October 23 and October 2024, and I just might put them to you and see if you can explain the differences. The average processing time for a Ukrainian visitor, a subclass 600 visa, between, I think actually this was between 1 February 2022 and 31 December 2022, which was right after the conflict, was 1 day. The average processing time for an Israeli visitor subclass 600 between 1 October 23 and 31 July 2024, in the period following the start of the most recent round of conflict, there was 1 day. Yet the average processing time for a Lebanese visitor subclass 600 in that same time, from 1 October 23 to 31 July 2024, was 14 days. And the average processing time for a Palestinian visa on subclass 600 was 4 months. Same visa, same application. Ukrainian visitor, it's 1 day. Israeli visitor, it's 1 day. Lebanese visitor, it's 14 days. Palestinian visitor, it's 4 months. How do you explain that discriminatory response?
Senator, at a general level, all assessments are against the same criteria, but they're applied to the individual circumstances that are presented in each case. That can lead to additional assessment being required, further information being sought. There's a range of reasons that can lead to a longer processing time for particular individuals.
These are thousands of applications.
Mm-hmm.
This isn't individual characteristics. This data makes it clear it's because of where someone came from. If you come from Ukraine, it's 1 day. If you come from Palestine, it's 4 months. If you come from Israel, it's 1 day. If you come from Lebanon, it's 2 weeks. That's not the individual circumstances. That's based on where they come from, their identity, their culture and their country, isn't it?
Right. Senator, each application is considered against the full range of circumstances that are presented, and that determines, among other things, the speed of processing, but also the outcome of the application. There are a range of reasons why some cohorts might have longer processing times on average than others. Generally, it goes to risk and the risk treatments that's required to be able to assess those applications.
It is deeply, objectively discriminatory, isn't it? That's what these numbers show. If you're trying to get a visitor visa from Lebanon, you've got an average 2 weeks wait. If you're trying to get a visitor visa from Palestine, it's 4 months. But Israel or Ukraine, it's processed same day. It's deeply discriminatory, isn't it?
No, Senator, it's the application of the criteria to individual circumstances.
Is it your assertion that even though the results are so wildly different, it was all a uniform application of process?
It's the same criteria that are assessed, but they're assessed against individual circumstances. The point I would make as well in terms of application flows is that there are circumstances where we are focusing on particular parts of a caseload, typically where we prioritise efforts in response to a crisis. That will mean applications that are well presented and likely to meet criteria are processed first, and then applications that are more complex can take longer to process. What that means is in a particular month you might then start to see longer processing times.
There was a crisis in Ukraine. Applications were finalised in a day. There's a crisis in Lebanon, 2 weeks. There's a crisis in Palestine, 4 months. It's not about there being a crisis. It's about where these people come from. It's about
Senator,
their culture and their identity, isn't it?
Senator, I think Mr Willard has made his evidence very clear. Each application is assessed against the same criteria relevant to the specific circumstances of that application. And there is nothing more he can add in response to the same question.
Well, if a process produces wildly discriminatory outcomes, the process is discriminatory, isn't it, Secretary?
I don't agree that they're discriminatory outcomes, Senator.
Well, I can't conceive of how you say that. One process produces visas in a day, the next is in 4 months. They're not the same outcomes, Secretary.
I didn't say that they were same, Senator. I said we're applying the same criteria to differing circumstances.
Cool. Is no one in Home Affairs considering a review about this grossly disparate outcomes to see if it's not discriminatory? You just accept it and you just say it's all fine, processes are all fair. No one's looking at the discriminatory outcomes here?
Senator, I'm confident that the officers are following the processes appropriately.
Okay. Notwithstanding the wildly disparate outcomes based upon where people come from, it's all fine.
I'm confident that the applications are being processed appropriately.
Minister, are you comfortable with those outcomes?
Well, I've got no reason to disagree with the evidence of the officials.
Moving to another matter. In response to a question on notice, the department about returning people who are held in offshore detention to places from which they'd fled because of fear of persecution. the response we got from the department on notice was the department conducts screening assessments to ensure it does not refoul individuals in breach of Australia's international obligations. Australia does not return individuals to situations where they face persecution or a real risk of torture, cruel, inhumane or degrading treatment or punishment, arbitrary deprivation of life or the application of the death penalty. Do you stand by that answer, Secretary?
Senator, I prefer to have the answer in front of me rather than be responding to an oral presentation of what my department wrote.
Does the department refoul individuals to places where they face persecution or a real risk of torture, cruel, inhumane or degrading treatment or punishment, arbitrary deprivation of life or the application of the death penalty? Do you do that?
It does not.
All right. Well, that's the assertion the department made in its answer to the question on notice. Are you aware of reports from The Guardian, for example, about Samad Hawladar, who after 5 years in offshore detention in PNG was then coerced and forced back to Bangladesh by your department in March of 2018, only to be stabbed and beaten on his return? Are you aware of those circumstances?
I'm not, Senator.
Does it trouble you?
Senator, I prefer to have an opportunity to review the facts of the situation before I comment.
All right, so you'll take that on notice?
I will.
Are you aware of the 2014 case of Zanallah Nazeri, who was forcibly returned to Afghanistan after being held offshore, only for, I think, the ABC to publish video of him being tortured on his return, actually tortured? You aware of that case?
I'm not, Senator.
Will you review that case?
I will, Senator.
What about Son Pham, who was held in PNG in offshore detention by your department and in 2017 said, "I'm very scared now. I don't know what happened to me in the next few days. If they deport me, who is responsible if the police arrest me or kill me in prison?" He said that just before your department arranged for his return to Vietnam. Do you know what happened to him after he was then forcibly returned to Vietnam?
I don't, Senator, nor do I have the facts of what actually happened in that circumstance.
Well, I'll let you know. He was stabbed to death, as he feared he would be. Do you stand by your position that the department doesn't return people to situations where they face a real risk of torture, cruel, inhumane or degrading treatment, punishment, arbitrary deprivation of life or the application of the death penalty? Do you stand by that?
Senator, I'm not prepared to speculate about information I'm being given orally that I've had no chance to check.
Well, because your department doesn't check. It doesn't follow up on anybody who's been returned, does it?
I don't think that's an assertion that has an evidence base, Senator.
Well, tell me, do you follow up on the welfare of people who have been returned?
Senator, I'll take that on notice.
Secretary, you've told me before you don't. Do you want to change your evidence now?
I don't recall the circumstances which you're referring to, Senator, but I'm conscious that I would prefer to see my evidence rather than have it played back to me by you.
Well, Secretary, you know for a fact that nobody in Home Affairs checks on the welfare of people after they've been forcefully returned, or as you would put it, they agree to be returned. You know that for a fact, don't you? And you're just trying to avoid saying the obvious truth here.
Senator, if you could stop answering on my behalf, I would appreciate that. I do not know that for a fact.
Does anyone in the department check
I'll take
on
that on
people's
notice, Senator, and I'll come back to you.
Well, if you did have people checking, Secretary, you would probably know that just this year, Abbas Gezi, who's part of the Awahi minority group, who is also part of the Fast Track group, saw his father forced to be returned to Iran after being denied permanency here. Do you know what happened to his father?
Senator, I'm only hearing the facts as you're presenting them to me. If you provide the questions, we will review them.
Well, I'll tell you what happened to him, because I've spoken to Abbas, and if you'd, or anyone from your department had spoken to Abbas or tracked his father, you would know that he was beaten by authorities on being returned and is now missing. Will you take that on notice too?
Yes, Senator.
You see, as of March of this year, there'd been some 984 people who'd been returned or removed to their country of origin, both voluntary or involuntarily, since the beginning of offshore processing, and your department hasn't followed the welfare of any of them, have they?
Senator,
don't care.
I've said I'll take your questions on notice because I would prefer to check the facts before I respond.
Minister, is the reason the government doesn't follow the welfare of people who have been returned and see about the stabbing of Mr Pham, the disappearance of Abbas's father, the torture of Zanula, is the reason you don't follow people's welfare on return because you just don't want to see?
Well, we haven't agreed to the proposition you're putting that people aren't followed up and checked on, and Ms Foster has taken that on notice, so I can't confirm what you're suggesting.
Do you think you should?
I'm not going to give an opinion. I'm going to wait and see the answer to the question that Ms Foster has taken on notice about 3 times.
So you're not... The government doesn't have a view about whether or not you should check on the welfare of people.
I'm going to wait and see the answer.
Let me finish my question.
Well, you keep presuming and asserting that we do or do not do things.
Because you don't.
Well, that's your assertion. We have taken on notice 3 times. Ms Foster has taken on notice the question to provide a factual answer.
Well, you've got a room full. There's be about 50 people here from Outcome 2.
And Ms Foster is entitled to take that on notice.
No one here is able to identify
to
whether or not there's a single person in Home Affairs who checks. Nobody in this whole room. 50 people.
Ms Foster is entitled to take that on notice.
It's because you don't, isn't it, Minister?
I know...
You know that's true, yes?
No. I know that it serves your political agenda to put words in people's mouths. You do it all day. I'm not going to let you do that to me.
We see, Minister, my political agenda here
is to put words in people's mouths and run an agenda for the Greens Party. I understand that.
You see, Minister, my political agenda here is to stop your government and the government that preceded you returning people who have sought protection from our country to places where you know they're going to be tortured and killed and disappeared.
I think
that's the agenda, and that's the agenda you're resisting here, isn't it?
No. I think everyone is well aware of your political agenda, including members of your own party, Senator Shoebridge, who've woken up to you.
And that's your response to those instances that I put to you, Minister.
It's my response to you. It's my response to you repeatedly.
Order. Senator Shoebridge, I'm calling you to order. Minister, I'm also calling you to order.
You turn it into that
Senator
shabbiness.
Shoebridge, I've called you to order 3 times now. You cannot speak over me as the chair. Minister, we will come to you, and then Senator Shoebridge, you have one last question in this block, and then we'll share the call.
To respond,
Thanks,
it is my response to you putting words in my mouth, in Ms Foster's mouth, not my response to the individuals involved. It's my response to your political agenda.
Yeah, of stopping people being tortured.
No.
Yep. But no, I understand your position, Minister.
There you go. You're putting words in my mouth again. Good for you. You can't do anything but that.
Senator Shoebridge, one last question. I'll share the call.
Well, I just might flag, Secretary, I have some questions about fast-track processing. So if you might, if there is a chance, identify what, if any, data there is about ministerial intervention for people who have been the subject of fast-track. I think there's some data produced about generic ministerial intervention numbers, but do you have any data about specific ministerial intervention numbers for those people who have been the subject of fast-track?
We'll see what we can do, Senator, while the call's being shared.
Thank you.
Thanks very much. Senator Patterson, we're coming back to you.
Thank you, Chair. I want to return to Fayez El-Hassani, and in the spirit of helpfulness, I want to provide some further information to the Department about Mr El-Hassani. This document, which I'll table in a moment from the SMHS News Agency, is a report from a event to commemorate the 1-year anniversary of the killing of Qasem Soleimani, who was the Quds Force commander of the IRGC, who was killed by media reports suggest the United States strike while he was in Iraq. Mr El-Hassani was one of the guest speakers at this event, and there's a photograph of him speaking at the event, and his remarks are reported by this news agency. He praised Soleimani. He said things to the effect of, and I quote, "Jerusalem was still in his heart and mind, and he did not hesitate for a moment or fail to support it and support the Mujahideen with all his strength in order to liberate it." He goes on to say, It is a difficult place to stand today on the first anniversary of the martyrdom of the Martyr of Jerusalem, the Martyr Commander General Qasem Soleimani, to remember and remunerate his humanitarian, cultural and jihadist virtues. In fact, we've not been able to distinguish an aspect of these virtues which needs to be underlined for the huge volumes so as not to underestimate the right of this leader and his comrades, even if it is under his fingertip. He goes on to praise his martyrdom in order to liberate our beloved Jerusalem from the defilement of occupation. He goes on to say, everyone who knew and accompanied the martyr confirms the size of his humanity, nobility and high religious and jihadist culture, through which he looks at the unity of the entire Islamic nation under the one command to liberate Jerusalem without fanaticism for any sect or ethnicity. This is the martyr of Jerusalem, Qasem Soleimani. This is yet more evidence of Mr El-Sani praising terrorism. This is more evidence of Mr El-Sani advocating violence against the State of Israel and Jewish people. It's available on the public record. Was the department familiar with this information before I just read it out to you?
Senator, I'm not able to talk about what we do and don't know about particular cases, and any speculation or engagement in discussion by officials of the department could put in jeopardy future decisions around any particular case, and I'm very concerned to ensure that I don't do that. Okay, well, let me ask this way. The Director General of Security, Mike Burgess, has publicly said that the act of simply liking a tweet that advocated the destruction of Israel or was in support of a terrorist organisation would be enough for someone to not pass muster for a security test. Obviously, security checks are not Home Affairs' responsibility, they're ASIO's responsibility. But if that's sufficient to not meet a security test, surely it's enough to cause a visa to be cancelled on character grounds. So, Senator, I think we've been on the record, and I can say generically, and Mr Thomas can provide some information about generically the things that we would consider in a character test. What I can't do is related to this particular case.
Okay, well, has the Minister requested a brief about Fayez El-Hassani?
Again, Senator, I'm not sure I can comment about the procedures around a particular case, but I'll take that on notice and speak with my General Counsel and see if that's something I can answer. Thank you. Mr Watt, you did an interview on 4BC Radio a couple of weeks ago where you were asked about this case, and you said that the Minister was reviewing Fayez El-Hassani's visa. Is that accurate?
I may have got that wrong at the time. I think I may have been confusing that case with one of the other cases that was in the media at the time, and I've forgotten the individual involved.
The person who was speaking at the anniversary of the 7th of October on the steps of Lakemba.
It may have been that case, yeah.
Possibly. Right. So Fayez El-Hassani's visa has not been reviewed?
I'm not sure. The answer that I gave in that interview, I think I may have been confusing the case with the other one that would receive a lot of publicity. Right. And I'm not sure, I actually don't know for sure whether either of them are. Okay. It's probably best to rely on...
Well, that visa was subsequently cancelled, the one you're referring to.
Yeah, it's probably best to...
that individual left Australia. But in light of this further information that you've been provided, will the government now review Fayez El-Hassani's visa?
Well, we've repeatedly said that the government and relevant agencies continue to consider information about individuals. It may well be that information you've provided today has already been considered. I'm sure if it hasn't been, it now will be, and we'll continue to take advice from the department and security agencies.
Because it's very hard to reconcile the standard that Mike Burgess has publicly set with what this person has done. He's done far more than simply like a tweet. I mean, he's hosted a press conference with Hamas, among other things. If the Director General says that's a threat to security, surely it's also sufficient grounds to cancel his character visa, and I urge the government to review the case very carefully, and I'll table this document to assist. Thank you. Moving on to other matters. Ms Foster, you talked before about how Minister Burke launched the process for transitioning Gaza tourist visa recipients onto their humanitarian visas by meeting with a number of them, and some of them have been granted visas since then. And you said that it's now not necessary to meet with the minister in order to apply for a visa or be granted a visa. Just to clarify, these visas, as they're granted, will they be part of our capped humanitarian intake of 20,000 places, or will they be in addition to the 20,000 places?
So, Senator, that's a decision of government about how that process works. What I'd like to do is take that on notice so I can see if there are any sensitivities in detailing where that consideration is at.
So I take it from your answer that the government hasn't made a decision yet about that. I mean, we've heard that dozens of visas have already been granted, so presumably they're either coming as part of the cohort or not coming as part of the cohort. Mr. Willard? Is it from the humanitarian cohort of 20,000?
Senator, it's not actually in my space.
So, Senator, we are going through the process of establishing that, but as I said, I would like to take that on notice so that I'm not transgressing.
Sure, I appreciate your care in making sure you get the answer right. That's appropriate, but I just want to understand what you need to clarify. When you say we're in the process of clarifying this, does that mean the government is in the process of making a decision about it and has not yet done so, or you are in the process of clarifying what the government's decision is in respect to this cohort?
It's the former, Senator, but I'd caveat that by saying that clearly we have capacity within the humanitarian program to accommodate a range of different priorities, and we are in the process of working with government on how best to manage this particular cohort.
Sure, but when you say there's room, does that mean we're not currently meeting the 20,000 places? We're not currently utilising the full 20,000 processes?
So each year, Senator, as you know, we establish broad parameters for the makeup of that program, yes. Whatever the limit is set at, and those allocations can be varied. That's a policy decision of the minister.
Yes, I know that, but that doesn't answer my question. In recent financial years, for example, have we got close to the 20,000 cap?
Sorry.
Have we exceeded it? Are we a long way below it?
We came on bang on target.
Right.
Last financial
they're fully allocated,
year.
the 20,000 places in previous financial years. We've been able to meet the 20,000 places. I'm sure demand is far higher than 20,000 per year.
But Senator, in each year, we look at what the composition of that might be, and so that's why I'm saying there is capacity to absorb that because we change the mix each year.
Yes, but it is material whether the government decides to include this category of people under the 20,000 cap or separate to the 20,000 cap, because that will then have an influence on whether other people can be accepted under that 20,000 cap.
It is, Senator, and that's why I'm taking on notice to find out exactly where we are in that decision process.
So we're more than 12 months on since the 7th of October and the humanitarian crisis that it unleashed, and the government still hasn't made a decision about whether the 3,000 odd tourist visa recipients who will now seek to stay here permanently are going to be included in the cap or not. I mean, that's extraordinary to me.
Senator, I think I've said all I can. I'll take on notice.
Okay. Do you have a breakdown of the costs incurred of people from Gaza on bridging visas, tourist visas and now humanitarian visas as they're being transitioned?
I don't believe so, Senator, but I'll invite my CFO to come up if she has any information that would help us.
You can just shake your head if not. No, the head is shaking, so I'll save you the trip to the front.
Thanks.
How about you take it on notice and come back to me on notice? Thank you. Chair, I want to move on to another topic. I'm seeking your advice, but it's a good time to do that. Okay, thank you.
Well, just to let you know, we were due to go to outcome 3 at 4:45, so we're running a little bit behind.
Thank you, yes.
I know senators are keen to make sure we don't miss out on those agencies this evening.
Thank you. I'll do my best to be as quick as possible. I want to ask some questions about the social cohesion funding. To date, how much money has been spent on the $25 million package? How much of that's been allocated and spent?
That's the package, Senator,
to the Palestinian, Muslim and other communities.
We'll just get Ms Chatterjee to come up. She's got the details of that for us.
Thank you.
Senator, while Ms Chatterjee's getting set up, I've been advised that the places are outside the 20,000.
Right, okay, thank you.
Senator Sneha Chatterjee, Acting First Assistant Secretary, Citizenship and Multicultural Affairs. So, Senator, as at 30 September 2024, 16.84 million of that package has been committed. And then an additional 5.6 million of that package is going through a competitive grants process that is currently being assessed.
So the 16.8 million that were granted already, allocated already, was that not through a competitive grant process?
Senator, there have been a variety of funding allocations. Would you like me to take you
Please.
through those?
Yes.
Yep. Senator, 7 million of that funding was for national programs, so combating racism, Islamophobia, reducing misinformation and disinformation. 2
and was
million.
That, and just to be clear, for my previous question, was that allocated through a competitive grant process?
Senator, that was done through a direct funding process.
Correct. So just a decision
Ad
of
hoc.
government.
An ad hoc grants process.
So the government chose the recipients of that $7 million.
With feedback from the department based on engagement with communities and with stakeholders.
Okay.
Additional funding, Senator, $2 million for national programs focused on youth affected by the conflict.
Just sorry, again, before we move on, that $2 million, was that a competitive grant process?
Senator, they were done through the ad hoc grants process.
Right, so again, decision of government to allocate that money?
So, as Ms Chatterjee described it to me, the department engaged with community groups, stakeholders, etc. They prepared options and the government adopted those options, and that's how that direct funding was made. You'll recall at the time we were trying to operate pretty quickly to get money out.
Okay. And you were going on to talk about a $3 million program or component?
Senator, $3.84 million for local social cohesion projects. $4 million for the...
Sorry, again, on the 3.84, was that a competitive grant process?
So, Senator, the 3.84 was for projects where the organisations may have already existing social cohesion projects in train, where they were contacted by the department to understand if those existing projects could address identified gaps and areas of concern raised by communities.
Okay, so again, it wasn't a competitive grant process?
It may be, Senator, that the original grants process where those organisations had funding
that might have been historically competitive, yep.
Some of those organisations were organisations that had fostering integration grants that were awarded in 2019.
Sure. But the top-up grants they received, there was no competitive process.
It was an ad hoc grants process.
Yep. Okay, ad hoc, thank you. And then you're going on to describe another bucket?
That's correct, Senator. So $4 million for the Community Cohesion Support Program, which is for community grassroots organisations, and that's administered by the Social Policy Group. So the department has ran a targeted grants process with the Social Policy Group, who are a peak body, and they ran a competitive grants process through the allocation, through the grant that that the department awarded Social Policy Group.
So the Social Policy Group, that's not part of the Department of Home Affairs, that's an independent group is what
That's
you're saying?
correct, Senator.
Right, so money was given to this independent group and they determined how it was allocated and they ran their own process to allocate it?
That's correct, Senator.
Okay, thank you. Does that get us all the way to 16.84 or is there more?
So that gets us to 16.84.
And then there's the remaining 5.6, which is a competitive grants process, which is open now, and people are applying and being assessed against criteria. And
so, Senator, the 5.6 million is for Australian, Palestinian, Muslim and Arab communities support projects. That grants process was open between the 18th of September and the 16th of October.
Yep.
There were 160 applications for that grants round received, and they're under assessment by a selection panel.
And so that's a selection panel within the department?
The selection panel is run by the Department of Social Services Grants Hub. The department has an officer who will be part of that selection panel.
Right, and presumably there is criteria which they're assessing those applications against. They'll grade them against those criteria. How will the decision be made who gets to receive those grants?
So the department will, the selection panel will finalise their report, and the department will provide advice to the Minister for announcement before the end of this year.
Right.
The Minister for Home Affairs.
When you say advice to Minister, does that mean the Minister has to sign off on the recommendations? Does the Minister have the ability to disagree with the recommendations, to vary the grants in any way?
Senator, I'd have to take that on notice, but the department is conducting the assessment of those grants in line with the grant opportunity guidelines associated with that particular part of the package.
Yes, and what I'm just seeking to understand, if there's anyone else in the room who has knowledge of this, that'd be helpful, whether upon those recommendations being made to the Minister, that's the end of the matter, or whether the Minister then has the ability to vary the recommendations, vary the grants.
Let us look at the way the guidelines have been set up, Senator, and we'll come back to you.
Thank you, that'd be helpful. And I've also read that some groups specifically have been invited to apply, that Assistant Minister Hill has written to some groups and said, you know, you're invited to apply. For which category of funding did that apply? Is that 5.6 or is that a different bucket?
Senator, that's an additional bucket of funding.
Which one's that one?
Senator, in August this year, August 2024, there was 5.08 million for ad hoc grants, which includes 2.6 million for Australian Palestinian-led community organisations and 2.4 million for community services that support youth through culturally informed youth services and pathways for positive community participation.
Thank you. And would either of those buckets of money, the 2.6 or the 2.4, through a competitive process?
Senator, they were through ad hoc grants processes.
Ad hoc grants. So again, it was ultimately the government. In this case, was it Assistant Minister Hill or is it the Home Affairs Minister who was the decision maker to hand out those grants?
Senator, I'd have to take on notice the exact signatory for the allocation of funding. It may be that the department delegated official may sign off on the actual expenditure of the grant money, but I'll take that on notice.
Yeah, I'm less interested kind of who authorised the money to go out the door and who made the decision which organisations were going to receive it, whether it was the Minister and if so, which Minister. So were there any criteria which those grants were assessed against? Any process for determining the recommendations?
Yes, Senator.
What was the criteria?
The first part of that process, which is the 2.6 million for Australian Palestinian-led community groups. So, Senator, I can take on notice the exact criteria that they were assessed against, but the particular focus was on Palestinian-led organisations who were able to provide direct support to arrivals from Gaza. And this was based on feedback from communities that there was a particular need to support those arrivals through through funding community organisations.
Okay. Can I please request on notice the criteria for all of these grant programs that you have? Thank you. Was any investigation done as to whether or not any of the groups who were receiving this funding had previously engaged in any extreme or inappropriate rhetoric?
Senator, the department works with the Community Department of Social Services Grants Hub, and we undertake due diligence checks for all applicants and successful grantees. So standard processes in line with the Commonwealth grants guidelines and rules. So they assess business, financial and self-declared criminality checks, as well as a review of publicly available information.
Right. So, for example, if a group had posted on social media, extreme content about the 7 October attacks, would that count against them being awarded one of these grants?
Senator, the department looks at the information provided by the organisation.
Mm-hmm.
I can take on notice the full process that we undertook.
Yeah, but this is a fairly important question because part of the rationale for some of this funding was the promotion of social cohesion, and it would be deeply ironic if taxpayers' money went instead to groups who are undermining social cohesion rather than promoting social cohesion. So I'd like to know what due diligence the department or the government did to make sure that that wasn't the case, that no taxpayers' money went to organisations promoting disharmony or extremism.
We can take that on notice.
You're not able to tell me about those processes now?
I think Ms Chatterjee said she'd take it on notice, Senator.
Okay. Well, I want to give you some examples of organisations who did receive funding under these programs who have been involved in promoting extremism. One group is Sydney Community Connect Incorporated. I understand they received $110,000 under the social cohesion grants to Australian, Palestinian, Muslim and Arab community groups. They were given that funding on the 16th of May of this year. On their social media account, they have promoted extremist events, including one to be addressed by Sheikh Ibrahim Dadoon. Sheikh Dadoon, of course, is infamous because he addressed the October 8 rally in Western Sydney in 2023, where he said it was a day of pride and that he was elated and it was a day of victory and it was something to be celebrated, what had happened the day before on the 7th of October. He also addressed the rally on the anniversary of the 7th of October at Lakemba Mosque, where he repeated similar things. Another person in this event promoted by the Sydney Community Connect group is Ahmed Basal, who has also engaged in extreme rhetoric and anti-Semitic rhetoric. For example, on his Instagram page, he posted a photo of the Biden cabinet, and next to the names and photographs of each member of the Biden cabinet was a flag, in this case an Israeli flag, and he said in this post, "Jews make up less than 2% of the US population, but hold every senior cabinet position in the Biden administration except the Secretary of Defence." And he has some comments alongside that about how terrible it is that Jewish Zionists have taken over the US government. Is that an appropriate person to be receiving a social cohesion grant?
So, Senator, what we were looking for was organisations with track records of supporting their community, those with whom we have worked. We will take on notice the issues that you're raising today and come back to you with more detail on due diligence.
Okay. The Sydney Community Connect has also posted on their own Facebook page a photo with them meeting with Tony Burke. Appears to be in some kind of ministerial office, judging by the photo, and they posted this on the 18th of October. Is it appropriate for the Minister to meet with a group that is promoting extremists and extreme events?
Well, it's probably best if I answer that. I mean, again, I'd need to find out what Mr Burke's level of knowledge was about that. You might remember a few weeks ago, Senator Patterson, in question time, I answered questions from you of a similar nature about the United Muslims of Australia organisation, and I pointed to the long history of that group in providing services, mentoring and I think de-radicalisation to young Muslim Australians. So I would want to have a good look at any organisation's track record before accepting the proposition you're putting.
Okay, well I'll provide on tabling that document about the Sydney Connect organisation. Another organisation which received funding was the Lebanese Muslim Association. They received $1.65 million on the 22nd of March of this year. They, of course, were a co-organiser of the rally on the anniversary of the 7th of October at the Lakemba Mosque, at which Sheikh Dadoon spoke, but also our visiting American friend, who subsequently had his visa cancelled after he left, also spoke, and at that rally, said that it was a day of victory and a day of celebration and other things. This is, of course, a rally on the anniversary of the largest loss of Jewish life since the Holocaust, which the Prime Minister himself said shouldn't proceed. So again, is the Lebanese Muslim Association, who's involved in promoting events like this, an appropriate recipient of a grant like that?
Well, again, I think from my perspective, and probably Ms Foster's, we'd just repeat what we said, that we'll take on notice those details, but I'd remind you that on numerous occasions the Prime Minister, Minister Burke and other members of our government have condemned a range of hateful remarks made by a range of people concerning what's happening in the Middle East.
Okay. Another organisation which received funding is Palestinian Christians in Australia. They received $525,000 on the 6th of September. There's numerous photos of them meeting with Tony Burke and other Labor ministers on their social media account. They promoted anti-Semitic conspiracy theories, including that the war was never about Hamas, it's about the Gaza gas reserves. Is this an appropriate group to receive taxpayers' money on social cohesion?
I'll give the same answer I've already given.
Okay, I'll provide that to you on notice for your consideration as well. They also described, they also say on their social media, Nazism and Zionism are two sides of the same coin. Zionism is a continuation of Nazi ideology and the Palestinians are the final victims of the Holocaust. Is that an appropriate statement for a government grant recipient?
Same answer as before.
The treasurer of this organisation posted it on Instagram. I can't repeat these words on Hansard because it would be unparliamentary, but she uses expletives about Israel. She said, "It's almost over for you all. The whole world knows. They know you're monsters," and that's putting it lightly, and includes the caption, "Israel is a terrorist state." Yeah, there's extensive commentary about this from this person about Israel of a similar nature. Again, comfortable with taxpayer money going there?
Well, again, we'll do some due diligence on that, but I'd repeat the point that no minister in this government endorses any hateful remarks made by any participant in this debate.
She also posted, this treasurer of this association also posted the Al-Qassam logo, a targeting symbol, the inverted red triangle, along with the captions, "You poked, you pushed, you prodded, you provoked, you play victim, you deserve to pay, you parasitic pariah." Pretty clearly endorsing violence and terrorism against the State of Israel. Is that an appropriate thing to post?
Same answer as before.
Okay. All right. Well, look, this keeps going on and on. What I should probably do is just provide all of this as a tabled document so that you can assess it yourself, Minister, and the government can assess whether or not they've handed out taxpayers' money for social cohesion wisely. You mentioned specifically United Muslims Australia, and you referred to my questions to you in question time about it, and I have heard from you and from others that United Muslims Australia is a constructive group, and particularly that Sheikh Shady, who runs UMA, is a constructive partner of government and the Department on National Security. But UMA continues to employ Sheikh Dadoon despite his repeated inflammatory comments, which, as you rightly point out, have been condemned by government ministers. So do you think it's appropriate that UMA continues to employ Sheikh Dadoon, given his extreme comments?
Well, again, I'll take that on notice so we can do some fact-checking of all of that. But it's good that you've acknowledged Sheikh Shady as an eminent member of the Muslim community, and I know that he's someone who's met former Liberal Prime Ministers such as Mr Morrison as well.
Yep, I've no doubt about that. But his organisation employs someone who I think we all agree has not contributed to social cohesion constructively.
Well, we'll check all of that and come back on notice.
You're in doubt about whether Sheikh Dadoon has contributed constructively to social cohesion?
No, I'm in doubt. Well, I'd like to check your proposition about Sheikh Dadoon's current employment.
Okay. All right. Well, if you've got an update for me on that, I'll welcome it. But as of very recently, he was still employed. Look, there is a ream of material about other organisations here. I'll provide it all on notice, and I just ask, Minister, for you to reflect, in light of this, whether you think the government's processes have been adequate in ensuring that taxpayers' money for social cohesion doesn't go to hate preachers or other people inciting discord in Australia.
Is that a question?
Yeah.
Well, the department has gone through with you the process that was adopted, which sounds to me like it involved close consultation with stakeholders, particularly in the Muslim community of Australia. I can only repeat what I've said. We don't endorse any of the hateful remarks that have been made by any participant in this debate. We do, however, strongly support providing funding to organisations to play a role in social cohesion, and we don't endorse some of the divisive behaviour that has gone on within this building to try to divide different groups within our community.
Thank you, Minister. I'll leave this for your consideration, and I look forward to whatever information you're able to provide on notice about these organisations.
Thank you, Chair. The call. Is that all the questions you have for outcome 2? Or we're coming back to you?
I will check whether we have any further.
Thanks. Senator Shoebridge, we're coming to you. I'm just, when you were out of the room, I just did note the time. We're about an hour behind now, so we'll have a discussion about that in the break, but just so to let you know.
Thanks, Chair.
We're still in outcome 2.
Yep. Secretary, do you have any, are you able to provide any data on the number of ministerial interventions involving applications from the fast track cohort?
So, Senator, I'm advised that we don't store the data in that way. We would have to go back and manually check, but Mr Kylie is going to provide you with what we can.
All right.
Thank you, Secretary. Just give me 2 secs, Senator. So I think at the last estimates hearing I provided some data on ministerial intervention requests, so I can provide some updates on that. Cool. So in the 23-24 program year, we received 786 Section 48B requests. 552 were referred to the Minister, and the Minister decided to lift the bar for 537 individuals. In this program year, 24-25 through to 30 September, we've received 210 requests. 206 have been referred to the Minister, and 214 bar lifts in that period.
And that's some that have come from the last year's cohort.
Previous years, yeah.
That's how you have the number larger.
And further to what the Secretary said, even though we can't break it down by fast track, a reasonable proportion of those would be previous fast track applicants.
So last year there were 786 requests made to the department, last financial year. 552 proceeded to the Minister, went through that screening process and proceeded to the Minister. Well,
correct.
I think they're all made to the Minister, but
yes, correct.
786 were screened by the department, and of those 552 were placed before the Minister last year. Is that right?
Yeah, 552 went to the Minister. They may have related to requests received in previous years, but yes, 552 were put to the Minister last program year.
Thanks for that. And then in the year to date, 210 have been received, and that, I could be wrong, but that looks like it's roughly on track for similar numbers. Is that right, given we're in November?
Yeah, give or take, yes.
So around, and is that historically consistent, around about 750, 800 applications for ministerial intervention a year?
In the 22-23 program year, there were 872, so somewhere in that ballpark. I don't have previous year's data, but that's about right.
And fast track would it be your assessment is the majority of those, or?
Again, I'd be comfortable saying a reasonable proportion, but beyond that would require us to go through each request.
All right. The Secretary, do we know how many of those people who refused asylum claims under the fast track process remain in the country and haven't had ministerial intervention? You know the number?
I believe the answer is about 7,500.
Yeah, so there are 7,178 individuals in the UMA cohort who have been refused their TPV SHEV. Some of those may have a ministerial intervention request on hand. That's just the totality of the refused figure.
And it's true, isn't it, that the only pathway they have to get permanency or in Australia is through 48B, through the ministerial intervention. That's the pathway available to them that they've been told.
So, Senator, that we gave you that evidence at the last estimates and that was correct. Subsequently, the Minister has asked us to provide options to work through potential outcomes for those who came as unaccompanied minors and those who have been here the longest, i.e. who arrived in 2010 or earlier. And so we are currently doing that work.
So for those who came as without their parents, as unaccompanied minors.
That's correct.
And for those who came before 2010, they're the
2010 or earlier, yep. So those who have been here for
before
the longest.
2010. And that's what you're looking at in terms of some alternate resolution of status process, is that right?
Some pathway for those cohorts, Senator.
Do we know what proportion of the 7,178 fall within those categories?
I don't have that breakdown.
Can you take it on notice?
Yes, I can.
It's by no means the majority, though, is it?
I'll take it on notice.
What about those who didn't come as unaccompanied minors? What about those who may have come as an infant with their parents and spent their pretty much whole life here? They don't have an option other than 48B?
So, Senator, at the moment, the options are the ministerial intervention or the first couple of cohorts that we're starting to look at.
So if you came as an infant with your parents and you spent your whole life here, may have gone to infants, primary school, high school, your whole life here, if you came with your parents, there's no option other than 48B, is that it?
At this point, Senator.
The Minister hasn't asked you to come up with options for them either, have they, apart from that?
So, Senator, we've been discussing a range of options. This is what the Minister has asked us to look at right now.
Yeah, so I'm asking you about that cohort. People who came here as infants with their parents, with one or two of their parents, there's no other option and there's nothing on the... and you're not looking at any other options for them. That's as I understand your evidence.
So, Senator, the evidence I gave is correct. We are looking at the two cohorts that I specified. For everyone else, currently the option they have is ministerial intervention.
Yeah. You see, if there's more than 7,000 people in that category, and assuming the Minister continues to have decision rates of about 500 a year and only a proportion of those are for fast track, this is going to take the better part of 2 decades to work through that. People who came as infants
Senator,
could potentially be on bridging visas until they're 30 or 40. But that's just an outcome of the numbers, isn't it?
So, Senator, that assumes all policy settings stay the same. As I've just said to you, the Minister's asked us to look at options for a couple of cohorts, and we're doing that.
But even if you take those cohorts out, we're still waiting, we're still talking about, with the current policy settings, and that's all I can ask you about, decades, aren't we, till this gets sorted, if the only pathway is ministerial intervention?
Senator, there's nothing that caps the numbers of ministerial intervention, Senator. And as you say, all I can answer you about is what we're currently doing. Well,
I mean, the ultimate cap on ministerial interventions is you only have one minister and the minister needs to spend a reasonable amount of time considering the application. I mean, that's...
So we have
I think that's the cap, isn't it? One minister, and it's quite detailed, and the minister, I assume, does his job thoroughly and carefully considers matters.
So, Minister, we have 3 ministers, 1 senior minister and 2 assistant ministers, all of whom can consider ministerial interventions.
So are all 3 ministers currently exercising that power?
So the answer, Senator, is it's open to all 3 ministers to do it. I don't have a breakdown at the moment of who is actually doing it and how many, and we'll take that on notice.
All right, thank you. Minister, I'll give you that example. Someone who came as an infant with their parents here was refused under fast track, which your government has quite rightly admitted was unfair and has legislatively repealed. Do you have any response to the fact that that person who came here as an infant spent their whole basic life here, has no option other than to wait potentially decades for ministerial intervention?
Well, I've heard Ms Foster a couple of times mention that that exact point is now the subject of policy advice from the department to the minister.
Well, but Minister, that's not what Ms Foster said. Ms Foster said other cohorts were unaccompanied minors or people who came here before 2010.
Sorry, I misheard you. That's what I thought. That's
no,
the groups
so I was
that
asking you
were
about
talking
someone who came with their parents. I assume they came after 2010. Came as an infant, had their claim rejected under what your government quite rightly acknowledged was a biased and unfair process. Do you think it's right that their only option is to wait potentially decades for ministerial intervention? Do you think that's fair?
Well, Ms Foster has mentioned that there are 3 ministers now who are able to look at these matters, and I dare say that the policy work that the department is doing may do something about the overall number of people who are in this cohort.
Ms Foster, we're going to get on notice a breakdown of the cohort that identifies what proportion of the cohort are the subject of those classes you're doing options review for, is that right?
Yes, I took that on notice, Senator.
Can I ask more broadly about family reunion and family-based migration? Ms Foster, I assume you're in receipt of policy directions from the government in this regard, but do you have any understanding about why the proportion of our migration program, which used to be overwhelmingly family reunion, has now entirely switched and is now overwhelmingly skilled migration rather than family reunion?
Senator, I'm just going to ask Mr Willard to come to the table so that he can take us through not just the current status but also give some historical context.
That's the basic pattern over time. The blue is the family reunion, the purple is the skilled migration.
I think if there's a time series on that chart, it's probably going back to, I guess, mid-90s when it crossed over. It's just a recollection off the top of my head, but it was around
Sorry,
that
I held
time.
it upside down.
And prior to that,
purple is family reunion, the blue is...
And when you go back to the 70s, it was more and more family-based migration.
Yeah, if you go back to when the White Australia policy was first lifted and we first began to implement multicultural policies here, it was overwhelmingly family and community related, and then over time it has skewed to be quite the opposite. Is that a conscious policy setting?
And that period in which it shifted more towards a weighting towards skilled migration and family even predates me in terms of the department, but it really is driven by successive governments looking at migration in the context of being a national asset, looking at the costs of migration over a lifetime, and balancing up that composition between skilled and family to provide opportunities, obviously, for family migration, but also to provide for skilled migrants coming in the migration program, which who do provide a positive in terms of not just their contribution to Australian society, but also an economic benefit in terms of their fiscal contribution.
Mr Willard, I understand you're implementing government policy that's been given, and that's actually reflecting that change in government policy from seeing a migration program that was largely about family and community connections and has really since the 1990s, probably the late 1990s, really skewed much more towards skilled migration. That's the kind of policy shift, is that right?
Yeah, that's been the policy shift, and it's you know, very broadly, it's sort of 2/3, 1/3, or 70-30 skilled to family.
Yeah.
And that's been a setting that's been consistent, look, at least for the last decade. This is off the top of my head, Senator. So
no. And that's,
around,
I think that's consistent with the data I've seen. Yeah. And it's basically a flip from what it was in the 80s.
Yeah, in the 80s it was much more family-based migration.
Yeah. Secretary, that flip, though, is one of the reasons why I assume that we've got such incredibly long delays for things like family reunion visa applications. Is that right? So, for example, I think
with the capped program, what we choose to prioritise will impact on the other cohorts.
Sorry, Secretary, I think I'm.
Would you like me to say that again?
Properly. Yeah, would you say that again?
So, yes, in a capped program, when we prioritise one category or group, then that will have a subsequent impact on the numbers that we can take in the other, and therefore the time that people will wait.
Yeah. So family reunions capped, is that right?
So the capped provisions within the family program are parent and other family, which is broadly there's a lot of subsets to other family, but it's self-explanatory.
But I mean, that's because it's capped. Is that what explains now that the estimated processing time for a newly lodged aged dependent relative? So if your mum's overseas and is old and needs to come to Australia to be with her family, that explains why that wait-in time is now 24 years. Is that right?
In short, I mean, age-dependent relative is not necessarily your mum, but it could be another relative. But the point you're making is that there are a whole range of categories, typically in the parent and aged relative space, where governments over many years have had to make a decision about the cost of that cohort in respect of their impact on the budget and their cost to the taxpayer, with the desire to have some places available for family reunion. So what we've seen is much more demand for visas in those categories than there are places available, which means you have a longer wait time and a larger cohort of people waiting for those visas. We do provide that information on the website, so it's clear for people when they apply that they could be facing very long wait times.
Do we now know how many people last financial year and perhaps the previous 3 financial years, do we know how many people died on the waiting list?
I would have to take it on notice, Senator.
Because I assume the application is void once someone dies.
If there's a circumstance where someone passes away, there's provisions for the application to be refunded and it is closed.
So can we get that data over the last...
Can I take on notice to see what I can get you? It might not always be something we can readily report on.
The Ombudsman also found that when applications were withdrawn because someone's life can change over 24 years or 30 years, or when somebody dies and the application is withdrawn, that the department doesn't always pay back the bond that has been lodged. And the bond, call it what you like, the VAC, can be up to $40,000. Is that right?
There's a few bits to unpick there. The visa application charge, particularly for something called the contributory parent visa, there's 2 stages in the visa application charge. One is the first upfront payment, and then when you're found to have met and you're able to be granted a visa, then you're asked to pay the second visa application charge, which is, I think it's a little higher than 40,000, but it's in that ballpark. The issue with refunds is the circumstances in which we can provide a refund are governed in the migration regulations, and there's a specific set of circumstances in which we can and in which we can't provide a refund. One of them is in the event a person passes away, then there's a provision to provide a refund. Others, and I think you're referring to the Ombudsman's report on this matter, Senator, and they've made a number of recommendations which we've accepted and have commenced work on, mostly going to the way we provide information in respect of this cohort, and also a provision of a review mechanism where when the initial refund, initial decision is not to provide a refund, there's a provision to review that.
So is there a discretion to provide a refund if someone has died?
Some discretions some refunds are mandatory and some are discretionary.
So if somebody dies waiting for their age-dependent relative, is that mandatory to provide a refund?
I think it is mandatory, Senator. I don't have the details in front of me.
Do we know what the upfront payment is?
I do have that handy. It's in the order of several $1,000s, but I can see if I can find the specific for you.
Mr Willard, while you find that answer, Senator Shoebridge, I'm due to share the call. Can I just get an indication outcome to, if we're able to wrap it up before the dinner break at 6:30? We're just getting into territory now where we may not get to our agencies until very late. Sorry, just give me 1 second. I'm just going to give Senator Shoebridge a chance to have a look at his notes.
I reckon if it's done at a clip, yes, I reckon we could get through. I'll try and speed it up.
Okay, Senator Patterson, I'm coming back to you with the call, or no?
Senator Scarr, and we're going to have more questions than I'll come to, I'm afraid. I think we are going to need them after the dinner break.
Okay, we'll have to have a meeting during the dinner break.
But I don't
to
have a
release
huge amount more,
agencies.
is the answer.
Sorry?
I don't have a huge amount more, if that's your question.
Okay, we'll have to share the call and then we can come back. Senator Scarr.
Can we get the answer, though?
Oh, sorry, Mr Willard, I forgot about you.
Subclass 114, which is age-dependent relative, which I think was the one you were asking about. The first visa application charge is $5,125 and the second visa application charge is $2,065. And for the folks who put this table together, thank you very much for providing that.
And then the VAC on top of that can be $40,000 or more.
So that would be for a contributory parent visa. There's
right.
two types of parent visas. One is you can make an additional contribution, which has its own allocation.
All right. And are the same fees available for a contributory parent visa?
So the first visa application charge is $4,895 and the second one is $43,600. That's the second VAC.
$43,600.
$43,600.
And is it discretionary as to whether or not the $43,600 is repaid?
Well, it depends on the circumstances as to whether or not it can be repaid.
Can you provide whatever data you can about on how many occasions the discretion has been exercised not to return those fees for both of those classes of visa in the last 4 years? How many occasions that discretion was overturned and what the total amount of funds has been that has been taken for applications where they haven't proceeded?
Sure, I'll take that on notice.
Because, I mean, I don't know about you, but and I'll probably put this to the Minister. So the idea that a family, and they might be, obviously, they're in another country, they're struggling with an aged parent, they pay the department, the better part of $50,000, and then their circumstances change and then the department doesn't give any of it back. That doesn't seem right, does it?
Well, let's wait and see what the answers are before I comment on that.
Well, it happens, doesn't it, Mr Willard?
Shoebridge.
It happens, doesn't it?
Thanks.
That happens.
I'll wait to provide the answer on notice. The reason is because you're referring to that second VAC. Typically, that's only received very shortly before the decision's made, so the circumstances in which a refund might occur are much more limited than someone who's in that queue waiting for a very long period before they get to the second VAC.
You'll tell us how many, won't you?
Thank you, Senator Shoebridge. Senator Scarr,
thank you, Chair. If I can ask some questions in relation to the resolution of status visas proposed to be granted to subclass 786 visa holders from the Ukraine. Who can help me with those?
Yes, Senator.
Thank you very much. So I note on the department's website that the government is offering a resolution of status visa on a case-by-case basis. Could you explain, please, how the process will work?
Thank you, Senator. As you said, it is a case-by-case basis that enables the government to prioritise those in more compelling circumstances and also by visa expiry date. The way the process is working is we're working closely with Ukrainian communities who can provide details of individuals who want to take up the offer, as well as an expression of interest form on our website as well. If you just give me 2 seconds. To date, we've had 225 expressions of interest provided through the website, another 131 directly through Ukrainian organisations. Of those, 254 offers have been provided to individuals, 197 have been accepted, and 57 we're still waiting to hear.
Okay, so it's actually an expression of interest process. You either personally lodge an expression of interest or you do it through an Australian-Ukrainian community group. Is that correct?
Yeah, someone could do it on your behalf, a registered migration agent or lawyer.
So what is the purpose of that process as opposed to someone making a formal application?
It's just the nature of this particular visa class. You're not able to apply for a resolution of status visa. You need to be offered a resolution of status visa. And this enables individuals to express their interest in the pathway, and then offers can be made following that expression of interest.
Right. So I understand how someone might someone might find the expression of interest form and lodge that. Can you give us a bit more visibility with respect to how you're actually working with Ukrainian community groups to identify people? How does that work?
Yeah, so we work closely with Ukrainian associations to make sure that they're aware of the pathway, pushing information out through the Community Liaison Officer Network, again, to make sure they're available. We've had no concerns through our engagement with those leading Ukrainian organisations about the way the process has been rolled out, but we'll continue to work closely with them over the coming weeks and months.
Okay, so once an expression of interest is lodged, or that expression of interest comes to your attention through a Ukrainian community group, what's the process then?
We would take those expressions of interest and put them up to the Minister. It's ultimately up to the Minister to make an offer. When the Minister agrees to make offers in relation to individuals, then we'll be in touch with them or their nominated representative directly. We'll provide them the information to then effectively apply for the visa at that point once the offer is made.
Okay, so the Minister's not going to personally meet with these families, as we've discussed earlier today, is that correct?
No, Senator, so he's asked the department to pick up the process from here. Of course, he may choose from time to time to meet with families, but the process will now become handled by us primarily.
Okay, and there's, as I understand it, there's approximately 4,000 Ukrainians on these protection visas at the moment. What criteria is the Minister going to apply in order to determine whether or not a particular holder of a visa should be given an offer?
So the number I have is it's about 3,600, give or take, individuals onshore on that 786 visa at the moment. As I said earlier, there's a couple of elements that we're looking to focus on in these initial stages of providing cases to the Minister in our engagement with the Ukrainian communities. That's two things driving that. So where there may be individuals who are in Year 12 and looking to progress to higher education, to make sure that they are progressed as a matter of priority so they can have that available going into the school year next year. Individuals with other compassionate or compelling circumstances, for example, individuals who might need access to the NDIS and those additional entitlements that are available to permanent residents. And then beyond that, it'll be based on the cessation date of the 786 three-year visa.
Okay, so as I understand it, current visas 786 visas are going to start to expire in July 2025. Is that correct?
It's from May next year.
From May next year.
Correct.
So what's your assessment with respect to the timeliness of this process, and how are we going to get to resolving all of these expressions of interest, etc., by that deadline?
Well, the design of the process is to ensure that we do finalise that process for each individual before the cessation of their 3-year visa for those who express an interest in taking up this pathway.
Okay. As I understand it, and you might have an up-to-date figure on this, but as I understand it, there are approximately 600 Ukrainians who are on a bridging visa A. Will they have a pathway to permanent residency?
So what the government is doing is focusing on those individuals who are on the 3-year temporary humanitarian visa, given there's a clear end date for their 3-year visa, and providing them a pathway in the first instance. It has said it will consider options for other Ukrainians in due course.
Okay. What about any other visa types? Are they able to have a pathway to permanent residency?
So at this point in time, it's just those on the 786 and potential pathways for other visa holders across all other subclasses will be considered by government.
Is there a cost to government in transferring people from a protection visa to a resolution of status visa? So does the issue of a resolution of status visa trigger additional entitlements to government support?
It does trigger additional entitlements. I'll take on notice financial implications.
Okay, and if you could take, as part of that, if you can consider it on an aggregate basis in terms of whatever estimates the department has in relation to the cost in that regard. And when you're considering the cost, do you also consider potentially the balance of the fact that they may well then join the workforce, pay tax, etc., etc.? How do you consider that in terms of balancing the costs and benefits?
Yeah, we'll take that on notice as well.
If you could. Thank you very much. Okay. Next question I have is, and I've got some handouts. They're very large because my eyes are. I need a new set of glasses.
Yeah,
so,
I'm sure they are. I'm sure that's the reason, and they're going to be used as props.
Actually, you can use those. I've got those. So this line of questioning is in relation to, and I suspect you won't need the articles. I just table them for the sake of convenience, but it's in relation to some media in relation to training given to Victorian magistrates in relation to sentencing convicted criminals such that the sentences that they apply do not trigger deportation under Commonwealth immigration laws. Ms Foster, are you aware of that issue, or I'm sure your General Counsel's aware of it?
I am, Senator, and became aware of it through the media. I'm also conscious that the media discussed the context for. So it was billed as training magistrates to avoid deportation, but there was also a perspective given about informing magistrates about the implications of various sentencing. But it looks like our General Counsel would love to contribute if you have further questions.
Okay, so are you, Ms Sharp, are you aware of it?
Yes, well, similarly I saw the media article and asked my team a few questions about it.
Okay, does the department have any concerns?
Similar to Ms Foster, my reflection on that article is that the headline is a little misleading relative to the content. Really, the content is going over some training, and it's a matter for the courts as to what training they decide to offer on the way the Migration Act works and the implications of if they issue a particular sentence, what the implications are under the Migration Act. Okay,
well, my understanding is that some state jurisdictions, and tell me if I'm wrong in this, and I'm not asking you from a state jurisdiction perspective, I'm asking you from a Commonwealth policy perspective. My understanding is some state jurisdictions actually do not permit judges to take into account ramifications under Commonwealth immigration law arising from criminal sentences. That they should put that to one side and actually use their judicial discretion to determine the sentence that applies, and the immigration consequences that may or may not flow from that are considered separately. Is my understanding correct? Or do you want to take that on notice?
I think, yeah, I'm certainly not an expert in how each state's sentencing laws work. So I wouldn't, unless, I think you're asking for a policy view.
No. Well, let me crystallise the question further. Let me ask you whether or not the department has provided a brief to the minister in relation to this practice of judges in the state jurisdiction considering the calibration of sentences to take into account, for example, if they impose a one-year custodial sentence upon someone who's found guilty of a criminal offence, it could trigger a right under Commonwealth legislation for that person to be deported. Has any brief been given to, or prepared, or advice given to the minister in relation to that issue?
No, Senator, not that I...
So, Senator, I think we're still trying to establish what actually happens in the jurisdictions. So we have obviously the media report, as Ms Sharp said.
Okay.
She's asked her staff some questions about this.
Okay, so you're actually, Ms Sharp, you're in the process of ascertaining what actually occurred in Victoria and what the provisions are of the Victorian law. Is that correct? In this, as they relate to this story?
Yeah, but to be clear, it is a matter for states, and I'm in no way questioning what courts do. I'd be very cautious of suggesting that we're questioning what the Victorian court system decides to do and how they train their judges.
Well, that's a reasonable comment, and as someone with a legal background, I don't disagree with that. However, at the same time, if there's sentencing occurring at a state level that has the potential from a policy perspective of undermining the efficiency or practical efficacy of the intention under Commonwealth legislation, I would have thought that is something that falls four square within the Commonwealth domain. To give you an example, if you have judges, for example, making criminal custodial sentences of 11 months and 29 days because they want to avoid a trigger under Commonwealth legislation, I would have thought that is something that the Commonwealth Department needs to be aware of, needs to be briefing the Minister in relation to see whether or not there needs to be amendments of the Commonwealth law. Mr Thomas, do you have anything to add in relation to that?
Senator, what this is referring to is the threshold for mandatory cancellation under legislation.
Correct.
There are still discretionary cancellation powers available to the department to make decisions. So it might change the way the case is looked at in terms of cancellation, but we assess each case that goes through the court system to determine if cancellation is the most appropriate mechanism.
But I think, Senator, to go to your broad question, we are looking at this as it's been raised in this article to see whether or not there are elements of concern. We just haven't completed that consideration.
Okay.
Senator Scarwood, we have to go to the dinner break.
Okay.
Okay, thank you. The committee will now suspend for the dinner break and return at 7:15. We'll have a discussion in the break about agencies later this evening. Just before we proceed, we're going to be releasing IGES and the ACIC tonight. Obviously, that doesn't buy us a lot of time, so we'll probably have to come back and have some other conversations in the next break. But at the moment, we're proceeding with outcome 2. Senator Scarr, you have the call.
Yeah, thank you. I'd like to ask some questions in relation to students on bridging visas. So, Ms Foster,
Yeah, we'll get the right officers.
yeah, if you could. And just as they're coming to the table, for the benefit of Hansard, I note that on page 24 of the Administration of the Immigration and Citizenship Program, which was published this morning, there's a reference to an explosion in the number of students on bridging visas, and I'm looking in particular at figure 9, which refers to bridging visa A, B and C holders in Australia by selected temporary visa category, and it reports an increase from 86,566 to 113,566. And again, for the benefit of Hansard, I note that the commentary, paragraph 115 of the report, states as follows: The recent increases to the number of BV ABC holders in Australia can be attributed to growth in application volumes for student visas. It is likely this was driven by legislative changes implemented from 1 July 2024, which limits the holders of certain visas from applying for a student visa while they are in Australia, end quote. And that's from paragraph 115. So my question is, can you, in the first instance, could you provide the basis for the statement that it's likely this was driven by the legislative changes? What led the department to come to that conclusion?
Thank you. Alison Garrett, Assistant Secretary, Temporary Visa Branch. So within my branch, I have the student visa program, and actually, incidentally, also bridging visas A, B and C. So at the moment, we do have a relatively large number of on-hand student visa applications in the onshore caseload, and it's that group, while they are pending a visa decision, who have a bridging visa in the meantime. So that is the group that is being referred to there, and I do have some data as at the 30th.
Okay, so just before we get to the data, there's the statement, it is likely this was driven by legislative changes implemented from 1 July 2024. What is the basis for the department coming to that view? What were those legislative changes, and what's the link between that number of 113,566 and those legislative changes?
Yep. So on the 1st of July, there were a series of changes to the student visa program, including who could apply for a student visa onshore. So from the 1st of July, visitor visa holders, temporary graduate visa holders and maritime crew visa holders were added to the list of people who cannot move on to a student visa while onshore. That was announced a couple of weeks before that came into effect, and we did see a fairly significant increase in visa lodgements in June. So there is therefore, as a result of that, a pretty large number on hand as part of that bubble as that transition occurred.
Okay, so you said you had some figures that can give us a bit more granularity in relation to that?
Yeah, I was just going to give you the number of student-associated bridging visas on at the end of September, but actually you've got the data from the administration program anyway. But as at the end of September, it was 88,570 associated with the student visa application.
Okay. So that's helpful. Is it possible for you to break it down further into cohorts how would you break down the 113,566? So, for example, how many of them are going through appeal processes, perhaps previously with the AAT and now through the ART? How many of them are waiting for a decision for a new student visa? Do you break that figure of 113,566 into different cohorts?
Yeah, look, that's of the on hand. I don't have that with me, a breakdown of what they've come from or what they're waiting for.
Okay.
The vast majority will be awaiting a primary decision from the department. That will be the bulk, without any doubt.
Okay. So 50%, 75%?
80%,
I won't hold.
I'm guessing, but
sorry, how much?
Maybe 80% will be waiting the primary decision.
Okay,
Yep.
of that magnitude.
Yep.
Okay. All right. Well, if you can take on notice to provide us the particular figures, and I appreciate you giving us your insight. Does the department have any operating assumption with respect to how many of these visas that are awaiting processing are likely to be granted? And just by way of introduction, it seems to me for planning purposes, there probably needs to be some sort of operating assumption that the department's acting under.
Look, we are looking pretty closely at what we think could happen, but we are monitoring it closely from month to month. At the moment, the refusal rate for the onshore group has increased significantly. It was sitting around sort of 4 or 5%. Prior to COVID and more recently just after COVID, and we're now looking at sort of closer to 20-25% are being refused in the onshore group. So it is an increase in refusals in the onshore caseload.
So is it fair to say that perhaps the assumption is that 20 to 25% figure's likely to continue, or does the department anticipate it might even go higher than that or lower than that?
Look, it does depend. So it can be a little bit seasonal as well. So as we sort of go through the year, there are certain times of the year where we get large numbers of applications that will go through very quickly that tend to be approvals, and then there are other parts of the year where we see the number increase, the refusals increase. So, yeah, look, I think we're probably looking at around... Yeah, it's difficult to say, to be honest. It really does depend as we go through that number on hand.
Okay. So I'm looking at this table. It's got 31 March 2024, well, actually I'll go back, 31 December 2023, it had 32,607 students on bridging visas. March 2024, 75,399, so doubled.
Yep.
30 June 2024, 86,566. And then the last figure we've got is 113,566. Is that the peak?
That is peaks building on peaks. So at the moment, so the figure in March...
That's peaks
building on peaks.
What do you mean by that?
That we have got a large number of on-hand onshore at the moment. So the March number you gave, that is a peak period for the onshore caseload. That is when we get a lot of applications for student visas onshore. June, again, is another period where people transition, so we see a large number coming through then as well. And then the final figure you gave, that has actually come down a little bit now. That is more like about 109 at the moment, and we hope to see that continue to go down.
Okay, so let me ask you this. When is the next peak? Is there another peak coming for the next quarter?
The next onshore peak is about March, but we will be entering the offshore peak in November.
So in terms of the onshore peak in March, for planning purposes, you're assuming that number is going to be materially lower than the 130, well, you've now said 109,000. What's your operating assumption?
It's about 109,000 at the moment.
Right.
So, yeah, look, we will be actually focusing on the offshore caseload for the offshore peak to support the sector through the beginning of semester 1 and the transition to the National Planning Levels Scheme.
Right.
So that's the offshore caseload. So we will do what we can to support the onshore caseload as well. But students who are onshore on a bridging visa can still study and attend their courses.
Okay, so how do these figures dovetail with the 270,000 student cap? Where does this fit with the 270,000 student cap?
So any of those students who have got a confirmation of enrolment, they will need to have a confirmation of enrolment that's issued at the time, that's valid at the time that we grant their visa to be able to be granted a student visa. So if we grant a student visa now, it won't be affected by the cap. If we grant a student visa after 1 January, they will have to have a confirmation of enrolment that is outside the cap. Sorry, that is in the cap. Sorry, that is included in the cap already, yes, unless they're a category that's outside of the cap.
Right.
Planning level, I should say.
Okay. So what's going to happen then? So I guess there are a few questions that flow from that. What happens if someone's gone through this process and then they hit 1 January and they don't have that confirmation? And they're still in country?
If they have been studying and they have a confirmation of enrolment that continues through after 1 January and that is still valid, that will be fine. If they are trying to move on to a new course, they will need to be moving into a course that has a place that is available under the national planning levels at that point.
And what happens if they have trouble finding that?
That means they won't be able to get a student visa, so they'll either need to move into a different visa class, visa category, or depart.
So that could trigger applications for other visas, theoretically.
If they're eligible, yes.
Yeah. Okay.
Theoretically, yes.
And then, so that's if they'll say successful in terms of this process to get a student visa. What if they're unsuccessful, if their application's refused? Presumably then they have a right to appeal to the ART, correct?
Student visas that are lodged onshore do have a right of appeal to the ART, yep.
And whilst that appeal is in train, they would still have the benefit of their bridging visa.
That's correct.
Correct? And then just to take the analysis further, in the event that they were unsuccessful in terms of that appeal to the ART, they could still apply for another visa, for example, a humanitarian visa. Is that correct?
In theory, that is correct.
And then and that itself would trigger an extension of the bridging visa, correct?
Correct.
And that could trigger, again, a period of waiting for the decision on that and an appeal to the ART, correct?
Correct.
So with respect to an individual student, depending upon the pathways they take, this could take years to resolve with respect to an individual student. That's correct, isn't it?
Yes, it is correct, although, and other colleagues can talk about this, not me, but there are some processes in place to move through the protection visa caseload quickly, and conversations happening with the ART.
Okay, what are those conversations?
So, Senator, I think you're aware of the changes we've made to the protection visa system.
Yep.
With the last in, first
Yep.
addressed, which is starting to bring down our mean processing times very significantly. We're also starting to see a trend in lowering of lodgements, which is the sort of longer term effect that we were trying to achieve with the changes. Yep. So that's that part of it. The ART has been in discussions with us about, are there ways that we could streamline this, that they could streamline this appeal process, and how could we assist them with that so it's not taking so much time through the system?
Sorry, when you say this appeal process, you mean in relation to student visa applications?
I do, yeah.
Okay, so what are the, well, presumably you have to follow a procedure though. So what are the sorts of things that are being considered in that regard?
So I'm just not sure what stage they're at, Senator.
Stage who's at?
I'm not sure what stage the discussions are at about what might be done. I just wanted to give you a heads up that we are working on that angle as well.
Okay. So, Ms Foster, do you have any operating assumptions? Because it's been a very helpful discussion in relation to this dynamic that your department's grappling with, and it seems to me that there are potential forks in the road as someone goes through their visa application processing where they could well keep trying to exercise their right under our system to apply for different visas. You've obviously thought, in conjunction with the ART, how you streamline the process with respect to consideration of student visa appeals. What about this issue of people who have their student visas knocked back then applying for a humanitarian visa, and the delay that could trigger?
So, Senator, we've got the capacity with the way we're approaching the protection visa reforms to prioritise particular cohorts. So if we decided, for example, that we wanted to put a significant effort into processing the student visa protection visa applications as a message, as an indication that actually this is not...
As a signal.
As a signal,
yeah.
Thank you. And I think you know also that in this PV reform, we've been working closely with the AAT, now ART, so that to the extent possible they are mirroring our process, so that for the first two stages of the PV process, we have levers that we can pull to make this a whole lot less attractive, and we can target those levers quite deliberately. So whereas before the reform it was kind of join the queue,
right.
We've now got policy and operational levers that we can use to influence behaviour. There's also a fair percentage of people, when faced with a knockback on their visas, who will go home. And we need to do everything we can to support that behaviour also.
Okay.
Senator Scarr, we're reaching the end of this block.
Can I just add one thing?
One more question?
Yeah, of course you can.
Can I add
Please.
one thing
Yep.
that's, I think, germane? We're also doing a lot more to try and communicate with people about the impacts of vexatious or unmeritorious protection visa claims, i.e. it will make it very unlikely that they would get another visa into Australia. And so we're putting quite a lot of effort into that communication through community groups, etc.
Okay, can I, just as a final question on this, and that's admirable, final question in relation to this is, how many of these people are awaiting decisions as opposed to people who have actually had a decision and they really are awaiting potentially deportation? Do you have any figures in that regard?
I don't have any figures on that. I'm afraid with me, I'd have to check that for you.
Can you take that on
unless someone
notice?
else has got
I'm
it.
just, so again, it comes down to breaking down this cohort in relation to where they're up to in the system.
And just one other note on that, one of the other areas we've been putting significant focus into is on the removals process. Taking active measures to engage with the cohort that needs to leave to encourage them to leave.
Which is why I'm very interested to understand the volume.
The whole dynamic.
Yeah. Okay. Thank you.
Thanks, Senator Scarr. Senator Shoebridge, you have questions for outcome two?
I do. Secretary, before the break, I was asking you questions about family reunion, family-based migration, and I think you said one of the reasons there's such long delays, in my question about what's the explanation for long delays for things like family reunion visa applications, you said yes, with the capped program, what we would use to prioritise would impact on the other cohorts. Do you remember that exchange?
And yes, Senator, I thought at the time that you might have misunderstood what I meant by capped program. I wasn't referring to the family program being capped, but rather to the target that government sets each year for the permanent program. And so if we have a target, for example, of 185,000, then the proportion of family visas within that can be accepted will diminish if we have higher numbers of skilled workers coming in. And I'm not trying to say family members aren't skilled, but...
Are you saying if there's an overall cap, that will reduce the number of family reunion applications if there's an increase in skilled. Is that what you're saying?
So I've got my expert at the table now, but essentially each year the government sets a planning target for the migration program. Do you want to add to that, Michael?
Yeah, it's a planning level, Senator. Within the family program, as I think I gave evidence previously, there are certain components of that are capped, and I mentioned the parent and the other family components.
Yeah, I get that, but I was asking the Secretary earlier about family reunion. And just to be clear, those planning levels operate as informal caps, do they? Is that how it works?
No, so there's a formal cap on a subcomponent of the family program. Then there's a wider planning level, which includes, and the planning level includes partner and child visas, which aren't subject to formal caps.
No, but they're subject to planning levels.
They're subject to planning levels, correct.
And in fact, if you go back over the last few years, the planning levels have determined the numbers, haven't they? Almost exactly.
For the most part, probably over the last couple of decades, there's been a few years where it hasn't.
Yeah.
But for the most part,
could you just, so as we provide on notice, the planning levels for the different categories within the family stream, going back over the last 5 years, and then against the actual numbers granted for each of the categories in the family stream?
I'm just seeing if we've got it here, but I think I'll take it on notice, Senator, because I think we've got outcomes but not the planning levels to go with them.
Yeah. Well, you see, when the planning level and the outcome so closely coincide, almost exactly mirror each other, and it's unlawful to have caps, how do you explain that outcome? So you can't have a cap, but if you just call it something different, is that how the cap operates? You call it a planning level, it still operates as a cap.
We attribute resources, so a couple of components are capped, so there's a cap which is provided for under the Migration Act. We attribute resources in line with government's priorities, and that's set for us in terms of the planning levels.
So you achieve the cap by allocation of resources?
We achieve a planning level by allocation of resources.
Yeah, and as a matter of practicality though, there's no difference, is there, between a planning level and a cap? You set the planning level, you hit the planning level, you don't exceed it. You set a cap, you hit the cap and you don't exceed it, as a matter of practice.
I guess I'm something of a migration nerd. I mean, there is a difference in that there's a specific formal mechanism under the Act in which you cap particular visa categories, and that applies to parent and other family. It doesn't apply to partner and child.
But you achieve the partner and child planning levels by only providing enough resources to meet the numbers set in the planning levels. That's how it works in practice.
To deliver government's intent, that's right.
Oh, no, I accept you're delivering government policy. Secretary, have you had any advice about whether that's lawful, given it's not lawful to put a cap on those categories?
So, Senator, my understanding is that, as Mr Willard has explained, what we do with the planning levels is we take the government's broad direction to us around planning levels, and we appropriately allocate resources to their priorities. It is technically different to a cap.
No, but it has the same effect as we've just gone through. So my question was, has the department obtained legal advice about whether setting the planning levels in that way, adhering to them in that way so stringently, is lawful, given it is unlawful to put a cap?
Senator, let me take that on notice.
Thank you, Secretary. For example, child visa applications have been subject to planning levels. That's right? Is it child visa applications, they're subject to planning level?
Yeah,
they're
not capped.
Yeah. Last year there was 8,240 odd child visa applications waiting to be processed, and some of them went back to 2011. What's the current state for child visa applications?
Senator, we have currently on hand 8,478 visas as at 30th September.
And what's the oldest one of those? Not the oldest child, although they've probably all been ageing rapidly, but what's the one that was lodged earliest?
I don't have that information with me. I can give you the processing times, but I can't give you the oldest case, but I can come back to you on notice on that.
Yep, that would be, I appreciate that, but have you got average and median processing times there?
I've got the 50th percentile, 75th percentile and 90th percentile.
I'll take what you've got.
So for child visa, the 50th percentile as at September is 18 months, 75th percentile is 21 months and 90th percentile is 24 months.
All right. So that means 90% have been dealt with within 2 years. Is that how I read that?
Yes.
But we don't know what the outliers are. As I said, last year the oldest, the longest had been there since 2011. You see, the result of these planning levels is there's meant to be a right under the Migration Act for people who are citizens of Australia to bring their children and their partners into the country without a cap, without an arbitrary cap from the government. But by imposing these strict planning levels, you deny that right, don't you? And that there's no lawful remit to do that, is there?
Well, Senator, the program's made up of both onshore and offshore applications. So some of those on-hand applications are also people who have applied already in Australia and are together with family here as well. I also note that as with many other programs, there are levels of complexity in the child programs, and part of the delays can be around ascertaining that they meet all the requirements, including guardianship, etc. So there's a lot of work that goes into it to these cases. They're not all that straightforward.
But then there's also the very conscious decision not to resource understanding those complexities and addressing those complexities because you've got planning levels. If they're complicated, they just wait longer because you've got a very conscious decision to only allocate enough resources to meet the number set out in the planning levels. That's the truth of it, isn't it?
So
Senator, as I said before, the government gives us guidance on planning levels and we appropriately allocate resources to their priorities.
Good. Well, I look forward to getting that detail and notice, and I appreciate your assistance. Moving to another point, I think about a week ago, the department gave a notice that that a data breach by Zerco data impacted upon people who had been using the department's free translating service run by migration translators. Have you got a copy of that data breach notice?
I don't have a copy of the notice itself, but of course.
Can you provide a copy on to the committee?
Yes.
Yep, but I think you were going to say you could tell us what was in it, Mr. Kelly, is that right?
Well, I'm aware of the nature of the breach.
So it's my understanding the data comprised users' full names, dates of birth, mobile numbers, email addresses, visa details, including application numbers, visa grant numbers, delivery dates, subclass numbers, driver's licence data and passport information. Is that right?
Yes.
Any other data?
That's the information I have.
Why were you giving all of that material to a translation service?
So just to clarify the nature of the arrangement, under the free translating service, individuals had access to have 10 documents translated for free as part of that service. We had entered into an arrangement with the migration translators to perform that translating function, so the department never held any of that data. It was data held by individuals, provided directly to that company for translating purposes.
But it then held on to that data. What possible... In what world is it reasonable to allow a contractor like that to hold on to such deeply personal data. How did that happen?
I'd have to have a look into the nature of the arrangements through which they manage their data.
Well, it's not just how they manage their data, it's the obligations that Home Affairs gives to any third party that has access to some of the most personal data about people's lives. If it includes visa details, application numbers, grant numbers, driver's licences, the entity may require it for the purpose of the translation, but in what possible world do you let them keep it after that's finished?
As I said, Senator, I'll have to take on notice that arrangement.
Are there any other arrangements where the department permits third parties like this to hold on to people's personal data?
I'm not able to comment on other arrangements.
Secretary, are you aware of any other arrangements where the department contracts to corporate entities like this and permits them to keep such deeply personal data?
So, Senator, I'm wishing that we were still in outcome 1 and I had my...
I'm not wishing we were still in outcome 1.
I wish we were in outcome 3, Secretary.
It's 10 to 8.
Not even there yet.
You're on an island there. You're on an island there.
Sorry,
Secretary.
Chair, I couldn't resist.
And because, in fact, the whole question around retention of data is one that we are trying to tackle across government. And I think it's true to say that until there was such an awareness of attacks like this, data breaches like this, that there hadn't been a sufficient focus on data retention policies. It's an issue which we are now working on very hard.
Well, this data breach happened in February of this year, Secretary. There'd been years of data breaches before that.
Yes, so Senator, as I said, it's only been in the recent years when these attacks have been more prevalent and we've started to look at the whole system around them, that we've been uncovering a range of things we need to tackle. But to go to your specific question, we'll take on notice about whether there are any other arrangements of a similar nature.
Why did it take from February to October for Home Affairs to notify the breach? I think you were advised at least in July from Zerco data.
So, Senator, the breach was actually a breach by Zerco data, and I know that the cybersecurity coordinator and others were working with Zerco data to understand the full nature of the breach and on a notification process. But without those staff here, I'll have to take any further detail on notice and provide that to you.
The only thing I can add to that, Secretary, is given the numbers of people involved, it did take some time to confirm the contact details of those that were affected by the breach. So we wanted to make sure that we could contact those individuals, so some time was taken to confirm contact details ahead of the notification.
How many individuals?
Approximately 33,500 clients.
33,500. Were any of those seeking asylum with all that kind of personal detail?
I don't have a breakdown.
Can you give a breakdown on notice?
I can take on notice whether we can.
How many of the 33,500 have been contacted?
So as at Friday, 25 October, 23,000 notification emails have been sent out to individuals with a delivery success rate of 98%. And then approximately 10,500 of those clients' documents were lodged by settlement providers who were contracted to offer that assistance, and we're working with those settlement providers on notification to those clients as well.
Thanks, Chair. I note the time. I'll put some other things on notice.
Thanks, Senator Shoebridge. Are we coming back?
Chair, I do have further outcome 2 questions, but in the interest of time, I will put them on notice and we can move to outcome 3.
Well, thank you. We will do that. We will excuse outcome 2 officials. Thank you for your time, your lengthy time with us today, and we'll move on to outcome 3.
And we're moving forwards, not backwards to one.
We are not going backwards, Ms Foster, I assure you. We'll try to go forwards as quickly as we can. given the time, and we can go straight into outcome 3 questions. I don't think it'll be a big change at the table. So Senator Patterson, you'll have the call.
Thank you, Chair. Let's go to my letter and the information I was seeking in relation first to the NZYQ cohort, please.
Sure, and I need to get 3 or 4 officers up to the table. So
Sorry,
we'll
they're in an estimates room just around the corner, so they won't be long. They have distinctive uniforms. Oh, sorry. Senator Patterson, if you just hold on 1 second, we would usually invite the Commissioner to make a statement, but I'm not sure whether they have one.
Oh. Thank you, Commissioner. How you going?
Yeah. Sorry, Mr. Fitzgerald, I almost skipped over your appearance at the table. I apologise. As the Acting Commissioner today, do you have an opening statement you'd like to make?
I do, Chair.
Thank you.
And I have tabled it, but what I would do in the interest of time, because I know we are running late, I might just abridge.
Yeah, of course.
Do an abridged version, but there was 3 key areas that I just wanted to call out about some of the fantastic work that our ABF officers are doing. In particular, the first one being a focus remaining on combating illicit tobacco and vaping products, and the ABF has seen a marked increase of illicit cigarettes arriving into the country, with over 12% more seized compared to this time last year. Since the ban on disposable vapes, we've seized over 5.4 billion vapes and vaping products and stopped tens of millions offshore from entering Australia. Obviously, this is an important step in protecting public health, particularly our youth, and ensuring compliance with Australia's import regulations. Intensified operations against illicit tobacco with state and federal support have further bolstered our capacity to disrupt the trade of harmful goods. Senators, ABF's commitment to supporting Commonwealth revenue collection totaled $15.39 billion in the 23-24 financial year. We work hard to promote revenue compliance through our voluntary disclosure program run by a small team of officers within the Australian Border Force. This initiative allows businesses and individuals to rectify errors in customs declarations without incurring penalties, fostering a culture of transparency and adherence to border laws. It is an essential element of our strategy to maintain the integrity and efficiency of Australia's border management system. Over the past year, the ABF has uplifted revenue collection through the voluntary disclosure program to the tune of over $255 million. Committee members, I would also like to highlight a recent successful operation where the Australian Border Force provided vital support to our law enforcement partners in their successful effort to dismantle a significant child exploitation network after ABF officers identified a high-risk passenger entering Australia through one of our international airports. This complex investigation, which involved police in Australia and overseas, led to the arrest and prosecution of the individual involved in abhorrent crimes. Importantly, it resulted in the identification of 111 victims of child exploitation. To date, 27 children have been rescued, as well as the extradition of the syndicate ringleader from Dubai to Manila, where he has been charged. Further, 19 offenders across 10 countries have been identified. This operation is a powerful example of the ABF's commitment and that of our partners in Australia and overseas to ensuring that those who seek to harm children face the full force of the law. Grateful for your opportunity that you provide me just for that brief introduction, and welcome any questions.
Thanks, Mr. Fitzgerald. Senator Patterson, we're back with you.
Thank you. So yes, turning to my letter to Secretary Foster and particularly the NZYQ component of it, question number 15. The number of NZYQ affected individuals released from immigration detention facility for each calendar month since November 2023.
Senator, the number of NZYQ affected individuals released from immigration detention in November 2023 was 144. In December 2023, 5. 0 in January 2024. Less than 5 in February. Less than 5 in March. Less than 5 in April. Less than 5 in May. 8 in June. Less than 5 in July. 13 in August. 7 in September. And 13 in October, up to the 18th of October.
Thank you. So just help me with what the total is there. I'm not going to attempt to add those together. If you've got it, that'll be handy.
I don't, Senator. Apologies.
Okay. I think there was a community protection summary that was released a few weeks ago that said 215 is the total number. Has it increased since then?
So at the 18th of October, there were 215 people on a bridging visa R that were NZYQ affected.
I know I've asked this before, but I think it might seem surprising to some Australians that following the High Court's decision, there is this continual ongoing release of people rather than all being released in the same go after the decision of the court. What is the reason why there's this continual release of people?
Senator, the NZYQ cohort, and in fact the immigration detention cohort, is not static, as you know. Yep. As individual circumstances change, they're tested against the High Court test in NZYQ, and where they meet that test, they're required to be released. So it might be that a visa process is finalised, or in discussion with a country, we conclude that removal is not reasonably practical, and at those points, they become NZYQ affected, and we are required to release them.
Okay. And this will just continue in perpetuity unless the High Court comes to a different view at a subsequent case?
Yes, Senator.
Thank you. All right, so what's the updated breakdown of that 215 cohort by offending type? So murder and attempted murder?
12.
12. Sexually based offending, including child sex offending?
66.
Assault and etc.?
97.
Domestic violence?
15.
Serious drug offending?
15.
People smuggling?
5.
And low level or no criminality?
Also 5.
Also 5. Okay. I'm just going to jump...
Noting, Senator Patterson, as we've previously discussed, that there were 102 convicted sex offenders released from detention while Mr Dutton was the Minister.
Thanks.
Of the 1,300 criminals that were released from detention while he was the
Senator
Minister.
Watt. My question didn't go to that, but appreciate it
But it's
nonetheless.
important to have that context.
Moving on to question 17, a breakdown of the cost incurred to date by the Commonwealth.
Thank you, Senator. Stephanie Cunn, Chief Finance Officer. So life to date, so over the full year of 23-24 and life to date as at 30 September 2024, the department has spent $73.228 million, broken up into departmental operating of $52.141 million, departmental capital of $1.095 million, and administered operating of $19.992 million. Community Protection Board, do you want me to keep going?
Yes, please.
Community Protection Board, total life to date, again, $2.738 million relating to the Community Protection Board, which includes $0.284 million in direct costs for board members and $2.454 million in support costs for the board. And government assistance, life to date, as at 30 September again, life to date costs of $2.718 million relating to government assistance provided to the released cohort. This includes $0.420 in income support payments and benefits and $2.298 million in healthcare assistance.
Thank you. The number of current NZY cohort who are in custody?
Senator, as of the 18th of October, there were 28 people in custody.
28 who are currently in custody, and I'll come back to that. The total who've been in custody at all since their release?
62 people as of the 18th of October.
Okay, again, a pretty high recidivism rate out of 215. How many BVR holders are subject to electronic monitoring or specified curfew conditions?
Again, at the 18th of October, 143 had electronic monitoring and 126 had curfew conditions.
How many have had those conditions removed?
As at the 18th of October, 64 people had neither EM nor curfew, and of those 64, 56 of them previously had electronic monitoring, curfew, or both. But I will mention that 28 of those are due to them being in custody.
Okay, well, of those who were not removed because they're in custody, because that's obviously a good reason, what is the reason that their electronic monitoring or curfew conditions were removed?
A delegate would have considered their circumstances and made the decision that it wasn't reasonably practical for the protection of the community.
Okay. How many of the NZYQ cohort have committed state or territory offences since their release?
As at the 18th of October, 65 people had been charged with a state or territory offence.
Okay, so obviously that's not visa breaches, that is, criminal offences at a state and territory level.
Yes, Senator.
And how many of those are currently on bail and how many of them in remand?
Again, at the 18th of October, 20 of those people were in remand and the rest were in the community either on bail or because their processes had been finalised.
Okay, so that would be 45 in the community?
Yes, Senator.
Okay. How many times has the Minister for Immigration applied for a community safety detention order or a community safety supervision order?
Senator Claire Sharp, Group Manager Legal. We anticipate the Minister will apply for the first order in the coming weeks.
Okay, so it's currently 0. So presumably my next question, none have been granted either. Didn't Minister Giles say many months ago when he was still in the portfolio that there was a whole lot of matters that were quite imminent? I think it might have been in May or even earlier.
Senator, I think those comments were a little later. The application process, as we've discussed in this committee before, is incredibly complex and time-consuming, and there's several ways in which an application that is quite well progressed might then need to be paused or delayed. Those sorts of circumstances are when there's an intersection with another justice process, or the person goes into mental health care. Other situations that can occur is that due to work on their identity through the complex identity teams, we start to see that there might be a viable removal pathway. So there are a number of things that are happening all the time with these applicants, and so that it is hard to make predictions.
Okay, well, nonetheless, the Minister did make a prediction, and it was on the 30th of May, when he was interviewed by Kieran Gilbert on Sky News. He said, and I quote, "These are progressing. 6 cases are before the expert review stage, which is the last stage before a matter can go to court, for a court to make an order for prevention detention, and 26 are an advanced stage of preparation." So how is it that 5 months on, none of those cases have proceeded to an application to the court?
The Minister's comments about the expert report being the final stage is true in the sense that is the final evidence gathering phase. We go through a very intensive review of all the material to ensure that we have picked up all the exculpatory material, all the reasons why the order should also not be made. That it has proved to be time consuming, as is also the case in the high risk terrorism offenders scheme. Would you like to add anything to that? Or are you, Ms. Opinion? Yeah?
Evening, Senator. Mary Legbinia, Assistant Secretary of the CSO Task Force. As Ms Sharp's evidence indicates, the process in order to build a case to bring before a court is quite complex, and one of the critical components is the expert evidence. What the legislation requires is an assessment of whether the person poses an unacceptable risk, and that risk is really heavily informed by material, evidence reports that we get from clinicians, and I believe that's what the Minister was referring to in those remarks.
Ms Sharp,
Senator Patterson, I might remind you, as we've previously discussed,
thanks, Minister.
It took 3 years for the former government it was either apply for or be granted a similar order under the Harto regime.
Yeah, my questions weren't about the Harto
long way off
regime.
3 years.
Thanks, Minister. Not relevant. Ms Sharp, you said before that one of the reasons why the process could be interrupted is if a removal prospect has arisen. How many of the NZYQ cohort have been removed from Australia?
None.
Right, so that clearly isn't a factor that's delayed a CSO application or a CDSO application, is it?
So none have been currently removed yet. As we're doing the complex identity work, we have identified at least one where we're working to go through the process to effect a removal.
Okay, well, that would be welcome if that could be achieved. You said you expect the first application will be made in the coming weeks by the Minister. Is it just one application which is imminent?
Yes.
Yes, okay, one application. We're getting pretty close. We're only a couple of weeks out from the 1-year anniversary of this legislation passing the Parliament. Do you think the Minister will be able to make the application before that 1-year anniversary has elapsed?
I think, noting my remarks about the dangers of predicting timing on these things, I don't think I'll be any more precise than I've already been about in the coming weeks.
Well, we hope that at least one can be made. Is the one to be made one of the 12 attempted murderers, or is it one of the 66 sex offenders, or is it one of the 97 people convicted of a violent assault?
I don't think it would be wise for me to kind of offer that kind of commentary before we file in court.
Probably not. After the first application is made, do you anticipate that there will be others that can be made soon after?
We are certainly working to progress a group of applications.
Because if not, then even if it is one of the murderers, there'd be 11 murderers still out there, or if it is one of the sex offenders, there'd be 65 sex offenders out there. I mean, I won't go on, but...
Kind of like the 102 convicted sex offenders released under Mr Dutton's tenure as the Minister, who never had such an order.
Thanks, Minister. The question wasn't about that, as I think you know.
You always leave that bit out.
Moving to question 24, the recommendations of the Community Protection Board provided to the Minister relating to an application for a CDSO or CSSO.
So just to clarify, is the question how many recommendations there were, or what the
How many recommendations have there been?
So the Community Protection Board has provided advice in respect of 28 individuals to, it hasn't been to the Minister though, just to clarify, that has been to the Community Safety Order Task Force in the department, who has then closely looked at those recommendations to identify whether the individuals who have been referred are eligible, and of the 28 who've been referred, 20 are eligible for the scheme.
Okay. So going back to Minister Giles' comments on the 30th of May, he referred to 6 before the expert review stage and 26 in the advanced stage of preparation for a total of 32. How could that be the case if only 28 were referred to the department and only 20 were suitable?
The Community Protection Board's advice to the task force is one input. We also look carefully at the cohort and use other tools and assessment techniques to try and identify who should be in scope, and then within those who are in scope, who should be prioritised for kind of the most effort. And that's an ongoing piece of work that's done between both those in IMI compliance group who are working closely through OpAegis and looking at the cohort, as well as the Community Protection Board recommendations and the work we're doing with the experts as well.
Okay, so is it only 20 cases that are proceeding that have come through the Community Protection Board process, or are there other cases the department has added to that pile?
There are other cases.
How many?
So at present, Senator, there are 35 cases that requests for information have been issued against. Ms Sharp's evidence previously indicated, and I think on previous occasions, we've outlined that at the commencement of the legislation, what the CSO task force did was identify and triage the cohort for individuals that presented on the basis of their offending a risk. That was one lever and one avenue which individuals were sought to be prioritised. Another way, as Ms Sharp has indicated, is through the referral process, and equally as we continue to engage with the cohort as they offend.
Sure. Okay. So 35 cases in total for consideration for a CSDO or a CSSO.
Those are the cases that requests for information have been issued against. That's correct.
So in Minister Giles' terminology, how many of them are in at the expert review stage and how many of them are in at advanced stage of preparation?
So 9 have been through an expert review, and we also receive counsel advice about our prospects. In terms of those that are in that advanced, I think Minister Giles was referring to those who have had a request for information issued. So that'd be the 35 figure.
So that's the 35. Okay. All right. Thank you. How many actions have been brought against the Commonwealth seeking habeas corpus relying on the NZYQ ruling?
Sorry, Senator, I'm just pausing while I've got the current numbers rather than a historic number, so it might be better that I take on notice if you're after.
Okay, why don't we start with the current number?
So currently we have two current matters about seeking habeas, that where the claim is that the NZYQ limit has been reached, even though the individual's visa status is not yet finalised. We've had 13 applicants in similar with a similar claim, but those matters have been resolved as their visa processes have been finalised.
And how have they been resolved? Have they been resolved by that person being released from detention or some other resolution?
Yes, they would be resolved by the person either being granted a protection visa or them being found not to be removable and being released from immigration detention as NZYQ affected.
Right, so 100% success rate from the point of view of the applicant. They either get the protection visa or they're released. The Commonwealth has not succeeded in any of those cases in continuing to detain someone or alternatively deport them.
In those cases, rather than where if they're close to, as I said, there are two ongoing matters.
Yep.
Where their visa process has not been concluded and the habeas matter is still live.
Yep. But the other 13, the Commonwealth has effectively conceded and released the person or granted them a visa?
We haven't necessarily conceded the legal point.
No.
There is a fairly significant one of those matters, an individual CZA 19, where the Commonwealth is taking, that matter is going to the High Court for hearing on the 14th of November.
Right. And that's someone seeking to ensure their client is captured in the NZYQ cohort or expand the definition of the NZYQ cohort?
That's correct.
Could you just elaborate on that?
So currently the NZYQ limit is reached when the purpose for detention, one way of simply explaining it is there are two legitimate purposes for immigration detention, for the purpose of processing a visa and for the purpose of removal. The NZYQ decision dealt with holding someone in immigration detention for the purpose of removal when there is no real prospect of removal.
Yeah.
This separate cohort of cases is arguing that the NZYQ limit could be reached at an earlier point while the person's still being processed for their protection visa regardless of the outcome of that protection visa, they're not removable.
Okay.
Senator Patterson, I have to share the call around.
Sure.
If you...
I just have one quick other related matter, which is the YBFZ matters. Where is that up to, Ms Sharp?
So the YBF, the full court of the High Court heard that matter on the 6th of August 2024 and reserved its judgment.
And remind me, is this the challenge to the electronic monitoring and curfewing? Or
Yes, it is.
Yes, it is, yeah. And so has the Minister been briefed on the implications if the Commonwealth loses this case?
Yes, he has.
And what contingency plans does the government have in place to address it if that's the case?
We've made very extensive planning for all possible outcomes.
Including legislation?
Depending on the reasons, that is a possible outcome.
Okay. I know the Chair will want to share the call. Thank you.
Senator Shoebridge, outcome 3.
Thanks very much, Chair. Secretary, to you or whoever is best placed to answer it, I have some questions about contractual breaches and contractual penalties for Serco in terms of offshore detention. Who's best placed for that? So the annual reports...
Sorry, Senator Shoebridge, did you say offshore or onshore?
Oh, sorry, it's Serco, so it's onshore. Yes, my mistake. I think I said offshore, but I meant to say onshore. The annual reports seem to show a good trend in the number of critical incidents per 1,000 people held in detention, being at 179 in 2019-20, 171 in 2020-21. It's 378 in 21-22, and then it starts dropping dramatically in 22-23 and 23-24 to 73.6 and then it appears to be 27.8 in 23-24. Do you have an explanation for those numbers?
Vanessa Holborn, Deputy Commissioner, Regional Operations, Australian Border Force. Senator Shoebridge, there are numerous reasons, obviously, why incidents occur in the detention network. I note the statistics that you have recalled. So what we know out of the detention network is incidents occur for a range of categories. So the types of incidents which your statistics will encompass are contraband, self-harm, assault, serious assault, use of force, food and floor refusal, escapes and deaths. So that totality encompasses all those types of incidents.
Well, if only that was true, Ms Holborn, because that actually was true for 1920, 2020 to 21 and 2021 to 22. That was true up to then. But then Border Force changed its reporting strategy, didn't it? You started changing how you reported the numbers of critical incidents.
The numbers that you reflect on for certain years, Senator, encompass COVID incidents as well. So you would have seen a spike in those years, also relative to the number of detainees in detention.
Yep, but you see the 2022-23 annual report where you see that significant drop kind of belled the cat, because under the category major disturbances and actual self-harm, it's got NA, and then the footnote makes it clear that you changed the reporting requirements, and by doing that you changed the contractual categories for penalty for SERCO, and you no longer include actual self-harm or major disturbances in the reporting of critical incidents. And that's followed through to the most recent annual report, hasn't it?
I can take you through the statistics, Senator, for self-harm incidents in IDFs. Would that be helpful to you?
No, I have the numbers, but by all means you could update them on notice. There have been hundreds of actual self-harm in the last 2 years, and none of them have been included as critical incidents because ABF changed the definition of critical incidents to exclude actual self-harm.
The number of actual self-harm incidents, Senator, in 23-24 was 74.
Yes, and if you put the two together,
the threat of self-harm is 264, totalling 338 total incidents across that category.
Ms Holborn, I just want to be really clear. Border Force changed the definition of critical incidents for the 22-23 annual report by excluding major disturbances and actual self-harm from the definition of critical incidents. And that is said in black and white on page 92 of your 22-23 annual report, and it's confirmed in footnote 52 of that report. That's carried through into the current, the 23-24 annual report. The polite description is fudge the figures. These used to be included in critical incidents and they're not. And that's what explains the apparent improvement in SERCO's performance, doesn't it, in your annual reports? Just a change in how you count it.
I will take the reasons for the change on notice, Senator.
Senator, if I could add... You
don't need to take it on notice. It's said in black and white on page 92 of your 22-23 annual report. It's not open for argument.
Senator, I think Ms Holborn doesn't have the annual report in front of her, so let her take it on notice and come back to you, and I think Commissioner Fitzgerald wants to contribute.
What I was going to add, and we will take on notice in terms of critical incidents and the actual definition, but those incidents of self-harm, etc., that you're referring to are included in our total incidents in the detention network.
No, but you see, SERCO was the real... Well, the public was the loser because we lost transparency. You changed the numbers and you tried to make it look better for SERCO than was true. But SERCO was the real big winner in this, wasn't it? They had a big contractual win when you changed the definition.
Again, Senator, I would need to take that detail on notice.
Well, you see, SERCO only pays contractual penalties when there has been a critical incident. And by Border Force changing the definition of critical incidents, you gave Serco, what was it, a multi-million-dollar gift by not including over 100 incidents over 2 years as critical incidents, which they'd have to otherwise pay a contractual penalty for. Who made the decision to give Serco that gift?
As suggested, we'll take that on notice to get more details around that potential decision.
Secretary, were you aware that the definition had been changed, and were you aware that Serco was going to get such a significant contractual benefit from the change? Had anyone reported this to you about that explains how the trend changed, though?
Senator, I don't recall being advised of that, but I would welcome the opportunity to work through that with my team to understand what the circumstances were behind that change. And so I think, as Ms Holborn has said, we'll take it on notice and we'll come back to you with more information.
Do you accept it's troubling, though, that the data has been changed to exclude what are pretty serious matters like major disturbances and actual self-harm from critical incidents? Do you think they are critical incidents?
So, Senator, what I'd like to do is have the opportunity to work with my team to understand what the facts are, and then I'll be in a position to have a view.
Do you think a detainee engaging in actual self-harm is a critical incident, Secretary?
Senator, I'd like to look at the facts and then we'll come back to you.
Well, you see, things that don't seem to count as serious incidents under ABF's new definition are things like Serco using firefighting equipment unlawfully in response to a major disturbance. Did that count as a critical incident, Mr Fitzgerald? When Serco
I'll have to take that on notice.
Took out the fire extinguishers and put them on people in detention?
I'll take that on notice.
Can you provide the numbers and the monetary value of the contractual penalties that have been imposed on Serco for the occurrence of critical incidents over that period from 2019-20 to 23-24? Ms Holborn?
Yes, we can take that on notice.
Do you know what the maximum penalty is under the contract?
No, I don't, Senator. I would need to get the contract parameters.
And is it true that as you said as Border Force said in its annual report, that the definition of critical incident can be changed by the ABF and was changed by the ABF in its incident reporting guidelines?
Again, Senator, I'll take that on notice.
And you'll identify who made that decision to change the reporting of critical incidents?
Yes, Senator, we'll take that on notice as well. We'll include that in the answer.
Was Serco consulted on the changing of the definition?
Again, Senator, I will need to take that on notice.
When does Serco's contract run out?
December 2024.
And can you remind me what the state of the tender process is?
Yeah, so I'll talk to you about both contracts, Senator. So the health services contract.
I have separate questions about the health services contract, so we'll just deal with Serco first.
Yep. Serco, the contract for facilities and detention services is in its final stages of negotiation.
So there's an identified preferred tenderer?
Correct.
How many entities tendered?
Senator, I think it's problematic for Ms Holborn to comment on the process and the numbers at the point at which the process is being finalised. I think our Chief Operating Officer was advising that we shouldn't do anything to jeopardise the resolution of that contract.
But you can indicate, did you say you're at the final stages of negotiation on that contract?
Yes.
What was the tender term for the contract?
The tender total is up to
Term. How many years?
5 years.
And is it a 5 plus 5?
Those are the terms of the contract that are still to be negotiated, Senator. So I guess due to the arrangements and the timing of where we're at with the contract negotiations, I think at this point in time that's all I can say on where it's at in terms of its
Perhaps
stage.
you can answer what was in the public tender. Did the public tender, was it for a 5 plus 5 or was it for a 5 year?
Check with the Chief Procurement Officer to get that detail for you.
All right. Well, while that officer is coming forward, and I do understand about there being commercial negotiations, I'm not...
So Ms O'Neill might be able to answer that question.
Sorry? Ms O'Neill, I'm only asking about what was in the tender because I understand you're at a commercially sensitive point in the negotiations.
Thank you, Senator. Marie O'Neill, Acting Chief Procurement Officer. Apologies, I've had some dental work, so I'm coping with that at the moment.
you have our collective sympathy, I'm sure, if you've had dental work.
Thank you. The tender went to out to tender with a 5-year initial term and 2 possible extensions of 2 years each for a total of 9 years.
All right. Could I ask then about, are there any other, sorry, wind it back. How much has been paid to date to Serco in relation to this contract, including the contract extensions? Because I think they initially contracted a decade ago, is that right?
It's approximately 10 years, yes.
Yeah, so how much has been paid to Serco over that whole period? And then I will then ask you what the initial contract price was.
I do have it in a brief, Senator. I'm just...
Ms Holborn, while you're looking for that, just because of the time, I might ask some questions about the health care tender, and maybe Ms O'Neill can help with that.
Certainly.
The healthcare contract has been awarded, is that right, the new contract?
That's correct, Senator.
And that's a 5-year contract with Healthcare Australia Proprietary Limited?
That's correct.
Is that a wholly Australian-owned company? Is it a subsidiary of an overseas company?
It's an Australian company.
All right. Is it a subsidiary of an Australian company or is it a standalone?
I would have to check, Senator, but I believe it's standalone.
And it's the 5-year contract was for $866 million, is that right?
I believe the figure is 786 million.
Sorry?
786 million. But I will take that on notice and check.
I have 866 and I have the IHMS as having received 789 million over the last decade. But what do you say the Healthcare Australia thinks?
1 moment, Senator.
Yeah. I mean, I have the Oz tender page published on the 25th of October for the Healthcare Australia contract. It's $866,295,100. Is that right?
Senator,
so it's on Oz tender.
Oz tender has on the page, then that is correct. The figure I have is different to that, so I'd like to take that on notice if I could confirm, please.
Yeah. And so what was the figure you had?
787,541,000.
What do you think that was for then?
The contract is always an estimated value because there is different pricing components. So some of it is fixed fees, there's activity fees, and there's variable costs in that. So it's an estimate, so I'd have to check what was put on Oz tender.
So which is the estimate, your 787 million or the Oz tender's 866 million?
The figures I have with me is 787, but I would like to take that on notice to confirm the Oz tender amount that you're referring to.
So it wouldn't be the case that since agreeing to the contract and the department signing off on the contract at $787 million, it's already grown to $866 million?
That would not be correct, Senator.
But perhaps you can explain how the 90
Ms O'Neill is unsure
$90 million difference?
Ms O'Neill is unsure about why there's a difference, and she said she'd like to go back and check the figures, so we'll come back to you on that on notice.
But it's a very significant difference, the better part of $100 million.
Senator, Ms O'Neill has indicated that she doesn't know what has caused the two different figures. She wants to check AUSTender and she wants to check her figures, and we will do that and come back to you on notice.
And that's for a 5-year contract, is it?
That's correct, Senator, with the 2 extension options.
Now, again, I'm going off AUSTender, so if you have a different figure, let me know. But AUSTender indicates that IHMS, who had the contract for 10 years, received $789 million on an original contract for $438 million. Does that accord with your data, Ms O'Neill?
Sorry, Senator, I have found that the difference, the figure between what I have and you have for the health contract for Healthcare Australia is the difference of GST. So in procurement, we look at different figures, and so what was reported is including GST. So I'm sorry, could you repeat your question?
All right. The IHMS contract that is now, has it concluded? Has it run its course? Have they left, or?
No, Senator. So
they go to the end of the year?
IHMS, that's right. So mid-December is the end date.
All right.
And now that we obviously have a new contracted provider in place to transition. So transition is now happening to the new provider.
Right. So that contract that, well, by the time it ends, run for a decade, AUSTender says the value of the contract is $789 million and 51,000. That's its current value. The original value, what they originally tendered for, was $438 million. Does that accord with your numbers? Give or take 10%, Ms O'Neill?
Senator, I don't have the numbers for the current contract for IHMS.
Senator, so I've located that in my brief. So the value on AUSTender, as you have rightly pointed out, is $789.05 million for IHMS, with the period 11th of December 2014 to what will be the expiry date of 10th of December 2024.
Yeah. And how did it go from an original tender of $438 million up to almost doubling to $789 million? Do you have an explanation for that?
I think, as Ms O'Neill has her evidence so far, is different services in terms of delivery of health services and the types of health services and support provided to detainees will fluctuate in terms of the cost. So it's not fixed, hence why you have a difference in the contracted original pricing to the end date of 10 years later.
But the numbers in detention reduced dramatically over the time, didn't they? Yet the contract doubles.
I wouldn't say dramatically, but they have reduced, yes. Over that period of time, they have reduced, Senator.
So how do we explain those two codes? Numbers reducing,
Senator
contract
Shoebridge,
doubling.
I have to share the call if you've got one more question in this block.
We can take that on notice, Senator.
Did you manage to find the contract, the amount that's been paid to Serco over the last decade?
Yes. So the value on AUSTender for Serco is $4.643 billion for the same period, 11 December 2014, 10 December 2024.
And what was the original contract?
I don't have that detail, Senator. I can take that on notice.
We'll come back to this. Thanks.
Thanks, Senator Shoebridge. Senator Patterson, you have the call. We're going to a break at 8:45.
Thank you, Chair. I want to go back to my letter and the OSB request I had there, or the request for OSB numbers, please. Starting with question 27, the total number of illegal ventures and unlawful maritime arrivals that had attempted the journey to Australia since May 2022.
Senator Patterson, Rear Admiral Brett Sonner, the Commander of Operation Sovereign Borders and the Commander of Maritime Border Command. From the 1st of May 2022 to the 30th September 2024, 22 maritime people smuggling ventures targeting Australia have been successfully resolved by Operation Sovereign Borders.
Thank you. How many of them made it to the Australian mainland or an Australian territory?
So, Senator, we've had 4 ventures over that same time period have made it to the Australian mainland.
That's the mainland. What about to external territories?
A further 3 ventures have reached Australian territories, Senator.
Okay, so a total of 7 out of 22. How many were turned back?
5 ventures were turned back to the country of departure, Senator.
Thank you. How many, is it the same number for the number of passengers returned to the country of departure?
When you talk passengers, you're talking about potential irregular immigrants. So turned back over those 5 ventures was 117.
117. And they were all returned to their country of departure, presumably?
Correct.
Any others that were able to be returned to their country of departure by any other mean?
We had returned to the country of origin 9 ventures for a total of 239.
Okay. So if they're not returned to the country of departure via a turn back, what's the other means available for those?
So if we're not turning back, we're doing a take back, which I've just given you the return to the country of origin. That's the turn back.
Right, but explain the take back and how that differs from a turn back.
A take back is where we safely escort them out of Australian waters. A take back is where, through the agreement with another nation, we actually return them to their country of origin.
Right, but which could be by plane, for example.
Correct.
Yep, understood. Thank you. And how many of those ventures had people taken to a regional processing centre?
8 ventures, Senator, for a total of 119.
Thank you. Could I have the total number of maritime surveillance flights and patrol days for 23-24 compared to previous financial years?
Nicole Spencer, Acting Deputy Commissioner, Australian Border Force. Senator, for aviation hours, for aerial surveillance, for 2023-2024 was 12,579 hours. Previous year, sorry, Senator, would you like me to go through previous years?
Yes, please.
Yep, so previous year, 2022-2023, 12,688. 21-22, 14,784. 2020-21, 16,005. 2019-20, 15,212. And patrol days for the Blue Water Fleet in 2023-24, 2,086. 2022-23, 2,182, 2021-22, 2,337, 2020-21, 2,485, 2019-20, 2,298, 2018-19, 2,195. Would you like me to keep going, Senator?
No, thank you. That's more than sufficient. I appreciate that. The number of criminal incidents investigated in onshore immigration detention facility and the nature of those criminal activities?
Yes, Senator. Since April 2023, the ABF has referred 636 incidents to law enforcement partners for further investigations. Types of referrals have included arson, possession of drugs and weapons, sexual assault, financial fraud, property damage and theft.
Thank you. And I've seen the Commissioner Outram's comments on that issue, and I welcome the government's signal to introduce legislation to deal with this. I note that it is eerily similar to a bill the previous government sought to progress, but nonetheless that's welcome. The total number of people charged with a people smuggling offence or an illegal fishing offence?
Yes, Senator, this line of effort is led by the Australian Federal Police, so they will give you specifics when they come up but I can tell you that since last Senate estimates there's been 4 arrests in terms of people smuggling offences.
Great, and can you say whether or not they've been charged in Australia, those 4?
I defer to AFP for that detail.
Okay, and that applies to illegal fishing as well?
Illegal fishing, the Australian Fisheries Management and Authority are the lead, as you're aware. I can tell you from May 2022 to the 30th September 2024, there's been 141 foreign fishers prosecuted for offences under either the Fisheries Management Act or the Torres Strait Fisheries Act of 1984.
Okay, very good, thank you. I'm indebted to Senator Shoebridge for drawing to attention some discrepancies between the 2022-23 annual report of the Department of Home Affairs and the 2023-24 annual report, because I noticed one as well, and it relates to the reporting of some of these figures I was just asking you about, in particular the offshore patrol numbers. So in the 22-23 report, target 40 was assessed as maritime patrol days and area surveillance hours are maintained or increased, and the rating was not met, and it explained the decline in those numbers. I can't find in the latest annual report an equivalent target. It appears to me that it has been removed and possibly replaced. The only one that I can find, and someone can direct me to it if I've missed it, is target 35, which instead of measuring aerial surveillance and maritime patrol days, just measures whether or not ABF effectively supports OSB to maintain 0 successful maritime people smuggling ventures, and it has been assessed as met. What is the reason for that change?
Senator, in terms of the annual report for that year, I'll have to take it on notice in terms of the detail, but I do recall that there was some particular issues in the performance information that we had previously, where there was a delay of up to 11 months in some information, and that's one of the issues that we've sought to remedy, which we have been doing, and now have clearer information regarding both patrol days and aerial surveillance performance.
And you've given them to me now, but then I can't find them in the annual report, and the assessment that Home Affairs used to do against its own target of achieving those appears to have been removed. Is that right?
So we now capture performance targets in our corporate plan that go specifically to these issues.
Why is it not in the annual report?
I'll have to take that on notice, Senator.
Because it kind of looks like you're setting yourself an easier homework task instead of measuring something, you know, very objective and measurable, like the number of patrol days or the aerial surveillance hours. You've taken that out and you instead just giving it, which you didn't give yourself a tick for, and now giving yourself a tick for saying, well, there were no successful people smuggling ventures despite our inability to deliver on those targets.
So, Senator, with regards to making it easier for ourselves, in the corporate plan, we're actually more specific now, including about our own performance management and contract management around aerial surveillance and patrol days, and I can just speak to those, Senator.
Thank you. But
just one more minute.
Senator, I think we might be able to help you with the information
that would be great.
in the annual report.
Thank you.
Senator Pete Bellis, Assistant Secretary, Performance Governance Inquiries. So, Senator, page 66 of the 23-24 annual report includes the number of patrol days and aerial surveillance flight hours.
Correct, but it's no longer measured as a target by which the department gives itself a pass or fail, is it?
So, Senator, as you can see, it's included as supporting performance information within the annual performance statement. So, as Ms Spencer outlined, the reporting requirement was changed as part of the 23-24 corporate plan and has since been reinstated in our 24-25 corporate plan, which you'll see a number of patrol hours in that corporate plan.
So why was it removed from the annual report as a target which Home Affairs assesses its own performance against?
So, Senator, as Ms Spencer articulated, we'll take that on notice in terms of the rationale for removing the target. But obviously we go through a range of performance improvement requirements that we undertake on an annual basis, and we continuously look at how we can improve our performance information, which includes making assessments on whether or not data is accurate, verifiable, and, to Ms Spencer's point, taking into account delays, etc.
Is there any question about the accuracy of the data you've just given me? Is it not accurate? Is it not able to be measured?
So, Senator, our data within our annual report goes through quite a robust quality assurance process, which includes clearance from our Chief Data Officer for publication.
So this wouldn't meet that standard?
In the current annual report?
Yes.
Yes, it does.
No. Well, then why is it no longer being assessed as a target?
So, Senator, as Ms Spencer said, we'll take that on notice in terms of the rationale for removing the target.
Okay, but you just gave me a rationale which was about whether or not the data was up to scratch, and then you've just admitted, in fact, the data is up to scratch because it's in there.
Senator, I think what I indicated was that we'd take it on notice in terms of the rationale for removing the target. The data that's contained within this annual report is accurate.
Okay. So you said that it's been moved now.
Senator Patterson, we're due to go to a break. Sorry,
Okay.
we need to do that.
All right, well, we'll have to return to this. Thank you.
We will, I'll seek some advice during the break about the program and try to get back to see how we go. Moving on to those agencies seems unlikely. Thank you, everyone. We'll suspend.